By your Lordship's division bench. When your Lordship was pleased to direct the service to be affected, I am sure my Lord is satisfied with the service, but my client instruction is no service affected. But apart from that, main thing is the appeal was in respect of an refusal of identity model. When the matter was taken up for hearing, prior to 4 days prior to that date, the order 38 rule to application has been rejected.
You can file a recall application.
I have filed it. But urgency is, my lord, this is already a physicians associations meeting ended on 26th with the order. But today difficulty is, my lord, now the disbursement will start. There is huge organization. Disbursement will start. We cannot do anything.
You filed the application here.
I filed the
You
application.
can give the number. We'll try to put it at 2 today.
Okay.
Or can you put it at 10:30 tomorrow? That will be easier. Otherwise, it will
Tomorrow.
be a mismanagement.
Tomorrow.
So please hand over ask your junior to hand over the slip. It a kalke topic. Mr. Basu, please give a notice to the others.
Yes. No, today you have to give another.
Yes, that will appear tomorrow 10:30. It at 10:30 te kalke appear korbe, huh? Specially. Thank you.
Madam, may I be permitted to matrimonial appeal hearing?
Appeal hearing, no. Yes.
Hearings,
please don't mention. Application and order 41 to be mentioned, please mention.
Application. Inclusion.
Just hand over the slips, order 41 and application. Let this be over. Yeah.
Order 41, I had some urgency.
Urgency we cannot look into, but we are taking up order 41 matters every day. Yes. What is that? ওটা যেটা উনি দিলেন ওটা কি? যেটা লাস্টে তলায় ভদ্রলোক যেটা দিলেন উকিল নন। এটা কি হিসেবে হেডিং এ অ্যাপিয়ার করবে?
এটা ইন পার্সন করা আছে
কি হেডিং এ অ্যাপিয়ার করবে? অ্যাপিল হিয়ারিং না অ্যাপ্লিকেশন নাকি?
ফ্যাট 378 টু আপ টু 2024
এভাবে হবে না, ঠিক করে মেনশন করুন, প্রপার মেনশনিং স্লিপ দিয়ে মেনশন করতে হবে।
আছে মেনশন ডেট আছে স্যার।
ওফো কি হেডিং এ আসবে?
অ্যাকনলেজমেন্ট
আপনি কোন উকিল বাবু সাহায্য নিন, নিজে করতে গেলে এটা প্রবলেম, আমরা এতটা ডিল করতে পারবো না, আমাদের অত সময় নেই। এটা অ্যাপ্লিকেশন হেডিং এ আসবে না টু বি মেনশন না অর্ডার 41 কি হেডিং এ আসবে? কেন টু বি মেনশন? কি অর্ডার? না, আপনি কোন হেল্প নিন, সরি এভাবে মেনশন করব না, কালকে ফিরে আসুন।
This is an application, your lordship appeared in this matter.
To be mentioned then, to be mentioned for release. Yes.
May I live to mention, my lord?
Right, to be mentioned for release.
Right.
Isn't it obvious? Why should it appear in the application?
May I live to mention, my lord, regarding this 2016 appeal from the preliminary decree? I am the
Hearing we are not taking up.
No, I am not praying, my lord. From 2016, order 41 was not moved. 2021
First appeal, order 41,
my lord, not moved.
Order 41, it is not required to be admitted under order 41.
Preliminary decree.
Order 41 first appeals are not admitted.
My lord, what's happened in 2022?
What are you wanting now?
I am praying, my lord, to listing of the dismissal of this matter, because there is already order of Justice Shoman Sen Division Bench that they have not taken any steps in the matter and showing in the Alipur court that the matter appeal is pending. No steps has been taken by the appellant, my lord. And from 2016, I am suffering.
No, but is it ready for hearing otherwise?
I don't know. They are not taking any steps.
You take no. If it's not ready for hearing, pendency won't do. They have got an injunction order.
The order, my lord.
They have got an interim order.
No.
Then show that to the court below.
They are not passing any order, lordship.
No, not like that. Then file a proper application,
Lordship.
whatever.
Lordship.
Yes.
Kindly to mention an original side commercial division matter, my lord, for listing in your lordship.
Original side we will take up on a particular days, probably Wednesdays. When it is taken up on that day, please mention.
Mention for listing, my lord. First appeal, my lord, of 2009.
No.
Matter, paper
Yes, Mr.
Applications, lordship.
Yes.
Application
Hand over.
Application of Monday.
Application hand over.
After February date has been fixed before the line court below for.
Please hand over. Yes. Call on the list.
Upgradation.
My lord, I have one matter, my lord,
Yes,
for
sir.
inclusion, my lord. Hearing matter.
Hearing, no, we are not taking. No, Mr. Mithu, we cannot take up hearing matters now. Yes.
For upgradation, I say.
No, upgradation refused. Call on the list.
Let me mention this to your lordship.
You are not there in time. You are taking up the list. Call on the list. Yes.
Kindly allow me, my lord.
No, you cannot come anytime and
Well,
This
Just
matter I
mention is
prefer-
over, sorry. Yes,
one second, my lord.
On 20,
You're
22,
appearing.
22,
yes.
an order was passed by the Justice Suman, and for filing of the original documents, they have not complied with the order, and it is still pending. Department saying we cannot ignore that order since they are not filed the original documents in the department. The department is saying that their lower court is not record is not ready, so the appeal can.
Give us half a second. The order is that appellant shall prepare paperwork on the basis of photostat copies of documents,
Yes.
those exhibits.
Yeah, filed.
If they are not available, further administrative notice shall be issued on the respondent. So this has to be complied with now.
Yes, we have complied it. We are.
So what is your grievance now
Last paragraph. Last paragraph.
of the judge of the
Yes,
order?
Yes.
In the event they are not available, further administrative notice shall be issued upon the respondent directing to produce the original documents.
They are not producing.
Administrative notice has been issued.
Yes, it is in the record. They have given several notices, but they are not producing the
Who is appearing for the other side?
Mr.
Somebody appeared.
Mr. Talwar.
Give a notice to Mr. Talwar. Give a notice in writing that we'll keep it tomorrow under the same heading. And if it does not appear, then no, on the they never appear.
Doctor, kindly seek the administrative order. They
We do not. When did they appear? Through advocate? Let us see it. You have done your duty. Yes, Mr. Harish Chandra Talwar. Yes. You have photocopies of those documents, those originals.
we have filed the paper book with the Xerox copies, but they are not producing the original documents in. So the records are not being ready by the law, department saying that lower court record is not ready. They are ignoring the order passed by the Justice Suman.
The Justice Somensen's division bench did not say that it would be treated to be ready. Paper books were directed to be filed, you have filed. Administrative notice has also been issued.
Yes.
Respondents are not.
Not. They are not complying with the last line of the order.
No, Mr. Harishchandra Talwar is no longer appearing in the matter.
I do not know, my lord.
Then why was administrative notice directed to be issued?
File the original documents.
Yes, for that their respondent's advocate could be informed. It's his liability.
It has been notice has been given to them, but they are not responding. They are not complying with the order for last 2 years.
No, no administrative notice has been sent, but no postal article has yet been received by the department.
But
We don't know whether that has been served. Administrative notice has to be served on the respondent before you say that they are not complying. We'll seek a further report from the office asking, we'll put it next week. The office is to give a report that whether this administrative notice has been served on them. Because till the last endorsement, there is no service.
But in the last order, in the last line of the order, my lord, Justice Sen, there was the date.
We have seen the last line.
There are date fixed for filing.
By an order dated September 22, 2022, a coordinate bench had directed the appellant to prepare paper books on the basis of photostat copies of certain missing exhibits, being exhibits A to G.
They have taken away the order.
Please, full stop. It was further directed that in the event the photostat copies of the said documents are not available, further administrative notice shall be issued upon the respondent directing to produce the original documents positively by 11th November 2022. You have found the photocopies.
Yes.
Next para, learned counsel appearing for the appellant submits that photostat copies of the said exhibits were available and have been incorporated in the paper books. Next para, from the office report dated December 11, 2024, we find that although administrative notice was issued on the sole respondent, vide memo number 1396S dated 12/10/2022 by speed post, no postal article has yet been received by the department. Hence, despite lapse of sufficient time, it is evident that the respondent has not yet furnished the originals of exhibits A to G. In such view of the matter, we are of the opinion that further that the court need not further wait for the originals to be produced. Full stop. The appeal, comma, as such, comma, be treated to be ready as regards hearing on the basis of the photocopies of the exhibits A to G incorporated in the paper books. First up, you have served a copy of the yes, copy has been served. First up, next para. Since we also find from the office report dated December 11, 2024, that a copy of the paper book has already been served on the learned advocate for the respondent, Mr. Harish Chandra Talwar, comma, there cannot be any impediment to hear out the appeal on the basis of the papers already on record. Full stop. Next para. Accordingly, the appeal was admitted, otherwise must have. So accordingly, comma, let the appeal be placed. Let the appeal be treated to be ready as regards hearing. Full stop. Liberty to the parties to mention the matter before the appropriate learned single judge for inclusion in the list for the purpose of hearing of the appeal. So you have said that the appeal is ready for hearing on the papers already there. Now you mention before the single judge so that it can be
They
listed.
have not filed the original document that.
Without those, we have said it. Even on the basis of the photocopies, the court shall proceed. So even if they don't file, they will never file. It's obvious.
Yes.
If they don't file, you cannot wait forever. So we have held that on the basis of the photocopies already on record, the appeal is treated to be ready as regards hearing, and you will mention it before the appropriate.
Much obliged.
Thank you.
Much obliged.
Next.
Hey, Dada.
Order.
In this matter, I am appearing for the appellant wife. This
Yes.
is the third time pursuant to your lordship direction, 23rd December 2024, first, subsequently, 6th of January 2025. Department is directed to.
The report was called for from the learned district judge Alipur.
Report has been given by the complainant, it has been given by the district judge. Now, there it has been informed that matrimonial suit could not be traced out in spite of vigorous searching, and for such reason, the staff attached to the learned trial court had been detained on 25th and 26th January also on holidays. 26th was a holiday, by assigning them for special duty for searching out the same. And learned court has prayed before this court to be gracious to whatever for granting adequate time for tracing and transmitting the said case record at the earliest. This is the best the district judge could do. Do you have both sides are before us?
I am
Yes, yes.
respondent.
You are
But
for the
I am for the
respondent, is for the appellant. So do you have all the relevant papers? Exhibits, I don't know whether you will be having.
That I need to take.
Please ascertain. We'll direct a further report to be filed after a fortnight by the district judge as to the developments. And in the meantime, learned counsel will be requiring to trace out if they have all the original documents. You can have a talk between yourselves, Mr. Mukherjee, and please have a talk. As per previous direction of the court, comma, a report has been submitted by the learned district judge, comma, South 24 Parganas, comma, as found from the office report dated January 27, 2025. Full stop. It appears therefrom that the learned district judge has taken all efforts to search out the papers of matrimonial suit number 92 of 2008 within bracket 73 of 2007, bracket closed. Despite staff being attached during holidays to the said task, comma, the same has not been traced as yet. Pushed up, the learned district judge has asked for some further time for tracing out and transmitting the said case record at the earliest. Pushed up, next para. Keeping in view such efforts of the learned district judge concerned, comma, we appreciate the effort and adjourn the matter till February 17, 2025, when the matter will be listed again under the heading to be mentioned. Pushed up, the learned district judge, South 24 Parganas, shall continue the endeavor to send the records and ensure that the records are sent at the earliest. Full stop. A further report in that regard shall be filed by the learned district judge with the learned registrar general of this court by February 12, 2025, which report shall be tagged with the main file and be presented to the court on the next returnable date. Thank you.
Great.
আচ্ছা আরেকটা লাইন অ্যাড করো the learned advocates for the parties are requested comma in the meantime comma to ascertain whether they have photocopies of all the relevant documents including the evidence as well as the exhibits for the purpose of uh, ascertaining as to whether the records can be reconstructed if so necessary. So, যেখানে photocopies বললাম and to court certified copies. Thank you.
Much obliged.
Great.
My lord, I beg to appear on behalf of the appellant.
Yes, please. In
My
this
lord,
one.
in item number 3, my lord, I am appearing for the respondent plaintiff, my lord. My lord, I
Right.
mentioned the matter before your lordship, my lord. My
Yes.
lord, on 12th March 2014, my lord, there was a direction to file the paper book upon the appellant, my lord. But my lord, it has not yet been prepared, my lord. And lastly, on 2nd December, my lord, the matter appeared before the Lojima court, my lord. And the Lojima court has been pleased to place the matter before the bench.
My lord, I pay
And
for
my lord, there is, my lord, I filed an application also, my lord, CAN number 9609, my lord, for an direction, my lord, either upon the appellant to prepare the paper book immediately, my lord, or my lord, leave may be granted, my lord, to
Application
file
টা
it, my lord, 9609 of 2018.
What about the paper books?
my lord,
Notice has been served long back.
yes, my lord.
Yes, my
Notice
lord.
was issued on January 2021. Then,
My lord, it is mistake, my lord. My lord, I pay for it.
Acha, very well, please file the paper books then within a fortnight. We cannot give
My
him.
lord,
No, sufficient time has been given. Otherwise, we'll dismiss the appeal. First.
4 weeks, my lord.
Pardon?
4 weeks, my lord. 4 weeks, 4 weeks. I pay for, I pay for,
My lord, the respondent plaintiff is 73 years old, my lord, and it is a
Ma'am,
money
are
suit,
you
my lord.
can you prepare the paper books within a shorter time? He's asking for 4 weeks. The appellant is asking for 4 weeks. If you want, we can direct you also.
Yes, my lord. Within, my lord, direction may be given upon the appellant to prepare it within 4 weeks, my lord.
No, appellant we are directing. You are for the respondent. Are you agreeable to prepare the paper books?
Yes, my lord.
So can you do that? Then we can dispense with their
Yes, my
preparation.
lord.
So you
Yes, my
prepare
lord.
within 4 weeks and the appeal will be then ready for hearing.
Yes, my lord. One submission, my lord. My lord, there is
Yes.
some exhibits, my lord, which are measurement book, my lord.
Yes.
Those are so voluminous, my lord. So exemption may be given, my lord, regarding that, my lord. Because those, my lord, measurement books, my lord, not possible to incorporate in the paper book, my lord.
What is the scope of the suit? Money suit?
My lord, it is a money suit, my lord. The works was executed by the plaintiff, my lord, and my lord, he claimed money, my lord. He filed a money suit, my lord. Decree was, my lord,
And the measurement
passed
books
in favor.
measurement books would be necessary.
Yes, it is. It is in the LCR, my lord.
LCR we understand, but there will be only one copy in the LCR. Two judges and the counsel are not expected to share those copies.
My lord, those copies are not, my lord, in the custody of the plaintiff, my lord, plaintiff respondent. They have submitted the original copy before the land trial court below, my lord. And they are so voluminous, my lord.
What is the volume? I mean, thick, very thick. What is the number of the papers?
My lord,
Thousands, thousands of pages or
yes,
hundreds?
yes, my lord, more than that, my lord.
Acha, very well. CAN 9609 of 2018 has been filed by the respondent. Post of Learned Counsel for the respondent submits that in view of the lackadaisical attitude taken by the appellant in not preparing the paper books in terms of the direction of this court, comma, the present application was necessitated, comma, more so as the appellant is in his 70s. Pushed up, next para. Learned counsel for the appellant seeks further 4 weeks time to prepare the paper books, full stop. However, comma, in view of the prayer of the respondent and keeping in view that the respondent is the worst sufferer for the long pendency of the appeal, comma, we direct the respondent through his learned advocate to prepare and file the requisite number of paper books within 4 weeks from date. Full stop. Next para. On the prayer of the learned advocate for the respondent, comma, the incorporation of the measurement books.
Yes, my lord.
What was the exhibit number or series?
My lord, I have to check, my lord, your lordship.
The incorporation of the voluminous measurement books, comma, which were a part of the exhibits according to the respondent, comma, is in the paper book is dispensed with. Full stop. Next para. Upon filing of the said paper books, comma, liberty is granted to the parties to mention the appeal for inclusion in the list for hearing. Can
I'm
such and
grateful
such
to your lordship, my lord.
can 9609 of 2018 is disposed of in the light of the above observation.
I'm grateful to your lordship. my
Thank
lord.
you.
My lord, may I be permitted to mention one thing, my lord? My lord,
The matter had been listed on January 7, 2025, when the appellant, comma, appearing in person with the leave of court, comma, sought further time to collect and deposit the deficit court fees and to cure the defects. Full stop. Next para. However, comma, when the matter is called on for hearing today, comma, none appears for the appellant. Full stop. Next para. As a last chance to the appellant to deposit the deficit court fees and to cure the defects, comma, we grant time for curing of such defects and depositing the deficit court fees to the appellant till February 7, 2025. Pushed up. Next para. The office shall thereafter furnish a report as to whether the defects have been cured, comma, including the deposit of the deficit court fees. Full stop. Such report shall be prepared and tagged with the main file. Full stop. The matter be listed under the same heading on February 17, 2025 for passing further orders.
my lord, in item number 3, my lord, may I be permitted to mention one thing, my lord? Number 5. I'm appearing on behalf of the husband. In obedience to my lord's last order, my lord,
Yes.
I have filed the modification application, which is scan 5.
Modification means?
Modification of the order.
Let us just check. Modification of order dated?
Order date. That's the appellant has filed a can 4 for violating, as the violation mentioned there is a violation of order dated April 19, 2022. Actually, that order is not violated, my lord. Ad hoc payment has already been made then and there. The violation has happened much later, which is May 17, 2022.
The parent order is order dated April
The parent order is, my lord, if your lordship can come to my
19th.
application.
Acha, your application. Where is the application? Application
Can 5.
application department. Can 4 or 5 দুটোই বার করুন। অ্যাপ্লিকেশন গুলো ক্যানটা ক্যানটা দিয়ে সাজিয়ে দেবেন 4 আর 5 দুটো। আচ্ছা ঠিক আছে থাক। ওইটা তাহলে কি? আচ্ছা অর্ডার চিত্র। This replies to what?
That is can 4. Can 4.
আচ্ছা
I have filed the opposition.
এটা অপোজিশন ক্যান 4 আচ্ছা ক্যান yes please.
This is a can 5, my lord. If your lordship can,
Yours is can 5.
yes.
the modification of the order.
Yes, where do we find the,
My lord, there is, I have explained it. What's the violation?
no, show us that order.
My lord,
April 19?
if your lordship can come to page 4 and paragraph 2.
No, where is the order?
That's the mother order was passed on March 15, 2022, my lord. And the order has been annexed and the page number is. Copy maybe. Page number is.
Copy?
We have not received any copy of that.
Why haven't you given a copy of Can 5? Unless you give a copy, how can they deal with the matter? It was affirmed on 20th of January. So you found ample time. Could have done it on 21st, 22nd, 24th. Should have given a copy to them. You cannot continue the violation without giving copies. Can 5 of 2025 is an application for modification of an order dated April 19, 2022, passed by a coordinate bench by the respondent husband. For sub next para, unfortunately, comma, a copy thereof is handed over only here and now to the learned advocate for the appellant wife. Full stop. Next para, let the matter be placed in the list. Can you come prepared tomorrow?
Day after tomorrow.
Let the matter.
My lord, there is one indulgence, my lord. This all had happened before with their presence only. If it is not adjourned, then it will be better for the benefit of the main appeal, my lord. It's just a can, my lord. Can 5 is a modification of that order.
It's unacceptable that the husband does not pay full alimony. It's unacceptable. Their appeal will never be ready. We will ensure that the appeal is never heard out until you pay out the full alimony.
It's not possible for the husband.
Then you'll have to suffer the consequences. First, you suffer the consequences, then we'll hear out the appeal. The matter shall next be listed on January 29, 2025. The matter number both the applications Can 4 of 2025 and Can 4 of 2023 and Can 5 of 2025 shall be listed together on site. Affidavit in reply filed by the petitioner appellant to Can 4 of 2023 today be kept on record. Is he in court? Give his name also.
One thing I.
Yes, Ms. Anand.
Is the asset and liability filed by the appellant is already in record, my lord?
We don't know. You have filed it?
Yes. Filed it.
Next.
Yes. Item number 6.
Yes.
I'm the respondent wife. Can 2 Millard was filed by me, Millard, praying for alimony. Kindly see Millard, the order dated 21st March 2024. As an ad hoc measure, Millard, the sum of rupees 50,000 was directed to.
You are the respondent wife.
Wife.
You obtained.
No, the husband filed Millard.
Divorce to dismiss.
Dismissed.
Order dated?
Order dated Millard 21st March 2024. Kindly see. Millard, kindly see Millard at the bottom, Millard.
Just let us find it. Yes. At the bottom?
Yes, last 3 paragraphs. We therefore direct both the parties to file their respective affidavits strictly in terms of the judgment rendered by the Apex Court in the case of Rajneesh versus Neha within 2 weeks from date. Pending instant application, the appellant is directed to transfer a sum of rupees 50,000 in the account of the wife respondent on or before 31st March 2024. Millard, this has been complied with.
Yes.
Now, Millard, kindly see, Millard, the next order dated 22nd April 2024. 22nd April 2024.
Yes.
Kindly see, learned advocate for the respondent submits that the respondent being engaged otherwise on account of education needs of the child has not been able to give instruction to file the affidavit of assets in terms of the earlier. Since in the meantime, the time has learned advocate for the seeks more time to file the same, on which we are inclined to grant 2 weeks time to file the same. Both the parties may file their respective affidavits in the meantime. Thereafter, the bench changed, Millard. There was no occasion to file. Millard, today I am filing the Millard affidavit on of assets, Millard. The
wives,
but nothing has been served, Millard, on behalf of the husband to me.
Have you served this on them? Then file those. The affidavits of assets filed by the respondent wife today in terms of the order dated April 22, 2024 be kept on record, full stop. The respondent is directed to serve copies thereof on the learned advocate for the appellant, full stop. The matter shall be listed, the application shall be listed next on February 11, 2025, when the appellant husband shall also file his affidavit of asset pursuant to the order dated April 22, 2024, comma, upon service of prior copies of the same on the learned advocate for the respondent. 11th February.
For the appellants.
Yes. Your application?
Yes, my application.
So goes for the respondent.
For an extension of time to deposit the.
Please just use the microphone, microphone. Yes. Extension of time.
For extension of time to deposit the shortfall differential amount, my lord. Initially pursuant to your order passed by this honorable court, we have deposited the enhanced amount, my lord. Thereafter, my lord, kindly see page 24.
It was already extended for 4 weeks.
Several times, my lord, in spite of that.
Extended, thereafter, my lord, we could not, my lord, deposit the shortfall decretal amount.
That was more than 1 year back.
Yes.
The
And in
page
the court
24,
below,
my
they are
lord, kindly
taking
see page-
time that there is.
Mr. Ghosh, let him.
Page 24 is the order, my lord. Pursuant to this order, we have filed this application, my lord.
Page 24 of can.
I can file.
Yes, 18th of August.
Yes, my lord.
So why haven't you filed? What is the explanation?
I have given my explanation. my lord.
Show me, show us the explanation.
Let me see, my lord.
If you are not satisfied, we'll deduct 1 month's salary of the person concerned to be deducted
But
of your
initially,
officer.
We have deposited the enhanced amount. my
What
lord.
is the explanation?
Page 7, paragraph 8. my lord. The requiring body has not, my lord, released the fund in time. my lord. That
Very
is
well.
the-
Whoever is responsible will suffer. His salary will be attached.
This is for only, my lord, the shortfall declared level. We have.
Even then, 1 year back court gave a direction. You are so adamant on that. It's just a shortfall, not just a shortfall. It's a direction of the court 1 year back. If you don't comply, your officer, his salary will be deducted. What is the explanation? Let us see.
Page
So
8,
casual. The state is so casual, sir.
we have
Don't be so casual. This is public money, not your own coffer. Where is the explanation?
page 8, we start from page 8, Roman 1, my lord.
Read it out in the microphone so that all can hear.
A server copy of the solemn order dated 18th of August 2023,
Yes.
passed by this order in the said appeal was uploaded on 21st of August 2023. That on 29th of August 2023, the land acquisition collector Purvo Bardhaman, being the appellant number 1, wrote a letter by his office memo number such and such dated 29th of August 2023 to Superintending Engineer Public Works Directorate Khadya Bhavan such and such, my lord, thereby requesting him for placement of fund as per original LA case records. my lord. But I have annexed the documents, my lord. Thereafter, my lord, Roman 3, that on 26th of September 2023, the land acquisition collector Purvo Bardhaman, being the appellant number 1, again wrote a letter by his office memo number such and such dated 26th of September 2023 to the Superintending Engineer Public Works Directorate Bhavani Bhavan, thereby again requesting him to for placement of fund as per original LA case records. Thereafter, my lord, that on 10th of October 2023, appellant number 1 has received a letter from the Superintending Engineer PWD issued under memo number such and such dated 20th of September 2023, which has been addressed to the Deputy Secretary LA Branch PWD Khadya Bhavan for placement of fund. In the said letter, reference of office memo number such and such dated 20th of August 2023 of the appellant number was mentioned. That on 22nd of December 2023, a reminder letter was issued to the Superintending Engineer PWD Directorate Bhavani Bhavan by office memo number such and such dated 22nd of December 2023, thereby again requesting for placement of fund. Thereafter, my lord, that on 18th of January 2024, the appellant number 1 has.
Very well. After at the end, page 10, para Roman 8, you have stated that the funds have been received
Yes, ma'am.
on 22nd of March 2024. We are now, what is today's date? We are on 27th of January 2025, which is 9 months after. What were you doing in the meantime?
10th June, my lord, we have filed this application. 10th
Why did you file the application? 22nd of March, whenever it came, you should have deposited.
Unless the order.
Very well.
time is
Deposit it by
extended.
tomorrow. Deposit by tomorrow because you have the funds now.
The fund is, my lord,
So
there.
tomorrow deposit the amount. We'll direct you.
Day after tomorrow.
We are giving the
have to, my lord,
extension
issue
till
the-
tomorrow.
we have to
Day after
issue-
tomorrow.
Day after tomorrow.
The present application has been filed for deposit of the shortfall amount as directed by the order dated August 18, 2023 by a coordinate bench. Full stop, next para. Several excuses have been given in the application for extension for not depositing the amount. Full stop. Although we are satisfied that the appellant number, that the land acquisition collector, Purva Bardhaman, has done his duty in seeking to obtain the funds from the appropriate authorities, we are surprised at the lackadaisical attitude in the on the part of the different departments of the state, which create an impression in the mind of the court that the state is not serious in complying with court's order. Full stop. Be that as it may, we find from paragraph number 8 within bracket Roman 8 that the appellants have now received the amount of rupees 1, 40, 43, 600 on March 22, 2024. বলেছে কি? On March 22, 2024. Full stop, next para. Accordingly, Can 5 of 2024 is allowed, granting extension of the time for depositing the said shortfall amount in terms of the order dated August 18, 2023 by January 31, 2025 positively. Full stop. Next para. The office shall furnish a report as to deposit of such amount, which shall be tagged with the main file and be placed before this court under the heading to be mentioned on February 6, 2025. We are granting you more time till the end of this week. Deposit it. Office will give a report. It will come as to be mentioned on 6th of February.
We shall pray revival of the on
Pardon?
order of stay.
Can't hear you. Use the microphone.
There is a direction order of stay, my lord. But that has been vacated due to non depositing the.
Oh, it remains vacated. It remains vacated. Please execute. Yes.
Then on the next date, my lord, your lawsuit will consider.
We'll consider. We'll consider. Next. Yes.
Item number 8, my lord, I am appearing behalf of the
Yes, please.
applicant, my lord. This is my
I am appearing
pursuant to your lordship
on behalf of
direction,
the
I am
respondent.
filing the affidavit in reply, my lord.
You have not filed a no objection, Bakaratnama. That was the office report. That Ms. Zotto and Mr. Malakar have entered appearance on behalf of the sole respondent, but there was someone else appearing previously. On scrutiny, officers found no objection on that. Without a no objection, you cannot enter appearance. Then you will have to proceed without the respondent. Either ask him to ask your client to have a no objection certificate from the erstwhile advocate, or ask your client to write in terms of the provisions of the Code of Civil Procedure that I want to take a change from you. Send it by registered post with AD. When the track report returns, when good service has been effected, if there is no reply, seek an order from the court. We will release him and appoint you as advocates. That's the procedure governing the. You are quite an experienced advocate, Ms. Datta. You know the procedure. We find your application is for substitution.
My lord, substitution, they have filed written objection. Your lordship direction was there to file written reply. I have filed reply. And one application can for, I have also filed, my lord, for leave to proceed with the appeal, my lord.
Why
Scan for my
Just now, I have received just now.
yes, because
He
on
said
last
just now.
when
you don't have any authority? Your receipt is unimportant.
though I
File
have
a no
tried to contact my learned friend, but he was not
Ms.
able
Datta,
to
please
contact-
ensure that a no objection is filed. We'll give you 1 week's time for that. But 1 week, not more. Thank you. You are Mr. Malakar.
I'm Malakar.
Please ensure that it's done. Otherwise, she will be in embarrassment. The office report suggests that that the wakalatnama filed by the current learned advocates for the respondent is bereft of any no objection certificate from the erstwhile advocate. Push up next para. The respondent is directed to file. Now, the learned advocates having instruction to appear for the respondent now are requested to file a proper no objection certificate along with their wakalatnama within a week from date. Push up, the matter be listed next on February 12, 2025 under the same heading.
Much.
এরপরে ক্যান 3, 4 দুটোই অ্যাপিয়ার আজকে কি অ্যাপিয়ার করে 3, 4
Yes, yes, my
ঠিক
Four
very
is also
very very
I have served copy.
Please ensure that at least.
Yes, I have served.
Number 9.
My lord, I'm for the appellant. And this is a matrimonial appeal. I was praying for opportunity to file informal paper book that LCR may be brought by.
You are the
special
appellant?
messenger. I'm the appellant. I'm for the appellant.
You are the wife.
Yes, for the wife, she had filed for divorce and it was refused by the learned ADG.
Acha.
Against that, we filed.
So you want usual. The stay of operation you have already obtained.
No, stay not yet obtained. It is filed, but not yet moved, my lord. If your lordship desires, I can.
So you
serve
serve copy of this also. First, the application has to be disposed of.
Yes, my lord. I'll serve copy upon the husband.
One is can 1.
Can.
The other application is there is no other application.
No, only one.
When we dispose of the stay application, then we'll also do that.
Yes, my lord. Then I will
But
serve.
stay we don't generally grant. You have to ask for injunction. I mean,
And then let me serve.
We'll do it on this. Very well. The appellant wife shall serve a copy of the application on the respondent, indicating that the application shall be listed under the heading application on February 17, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Much obliged.
Thank you. You should have these things move as early as possible. If the other side contracts a marriage in between, then you have no. I mean, you know what happens.
I'll start mine.
Item number 10.
I don't remember for the appellant. Pursuant to lordship direction, I've served it to the respondent, my lord.
Proper service effected. Effected.
20th of January, my lord, can.
One is section 5.
One is section
You have
5.
served copies of both the
Both
applications.
appeal and memorandum of.
Oh, that was the
application and
direction.
memorandum of appeal also.
So you are sure they have received?
On 20th of January, they have received. That's what the affidavit of service says.
Very well.
My lord, my can 1 is section 5 application. It is a delay of 33 days.
In
My lord,
filing the appeal.
filing the appeal. My lord, it is the order under section 24 of Hindu Marriage Act. Divorce petition was filed by me before the learned court in Jammu.
Section 24 is not.
Yes.
24 of what? Civil procedure?
Hindu Marriage Act. She filed the application for maintenance.
That's not an appealable order.
My lord, I will say, my lord, it is governed by Family Court Act.
Achha.
Because this adjudication has been done by Family Court, which is, my lord, in Metropolitan Magistrate.
Family Courts Act aren't only final orders appealable.
Section 19, if my lord kindly sees.
Just place the section before us.
Section 19.
এই ফ্যামিলি কোর্টস একটা আছে কিনা দেখুন তো, তার একটা আনিয়ে নিতে হবে পরে, এখন আপাতত আছে।
My lord, I'll just hand over.
এখানে
Sorry, I have only one.
No, we'll check up whether we have copies. Family courts একবার করে আনানো হয়েছে। Hmm. 19. Not being an interlocutory. Section 24 is an interlocutory. Sorry, not being an interlocutory order. 24 is an interlocutory order.
My lord, that final, he has disposed of the section 24 application.
No, interlocutory order is in the context of the suit, not interlocutory. Then every application, suppose we make an amendment application, amendment of plaint. If that application is decided, that's a final order for that application. No, we'll give you liberty to prefer a revision.
I'm just humbly praying, my lord, I'm led by Mr. Tanmoy Mukherjee in this.
No,
He has some submission to make. My lord,
No.
for some personal difficulty,
No,
he's
no,
not
no.
in
No,
town
no.
this week, my lord.
Whatever.
My lord, kindly keeps it next
No,
Monday,
no,
my
no,
lord,
no,
we'll
no
try to
adjournment.
satisfy, my
No
lord.
adjournment.
If my lord, then kindly sees the order once, my lord.
Let us see the order.
My lord, court has awarded
Yes,
40,000 and 50,000, my lord. My income is 40,000, my lord.
We cannot look into the order. File a proper revision.
My lord, kindly, my lord, sees section 19 once, my lord.
We are reading that. Not being an interlocutory order. And that's the procedure. Otherwise, that will be contradictory to suppose we are giving you an example. If a matrimonial suit is filed in a civil court, then a revision will lie. And family court, then an appeal will lie.
My lord,
Cannot
that
be.
That is what the act says, my lord.
Cannot be the intention of the legislature, sir. It's a patently absurd interpretation you are lending to the
My
statute.
lord, it is saying that any order or
No,
judgment.
just
my
by
lord,
choosing a forum, you can then get an appeal instead of a revision.
it is saying, my lord,
We'll
it is
interpret this.
applicable, my lord.
And the present applications arise out of an appeal filed against an order passed by the trial court under section 24 of the Hindu Marriage Act. Full stop, next para, learned counsel for the appellant, comma, upon being posed a query by the court in that regard, comma, submits that since the order was passed by the concerned family court, comma, the governing provision for an appeal would be section 19 of the Family Courts Act, comma, 1984. Full stop, next para. Learned counsel seeks to impress upon the court that since the application under section 24 was disposed of finally, comma, it is not an interlocutory but a final order. Full stop, next para. However, comma, we are unable to impress ourselves with such contention. Full stop. It would be an absurd interpretation to section 19 of the Family Courts Act to say that orders which are passed of an interlocutory nature during the pendency of a suit shall acquire the character of a final order for the purpose of preferring an appeal under the said act. Full stop. If such proposition is to be entertained, comma, an absurd situation would arise to the effect that simply by a matrimonial suit being filed before a family court and another filed before a regular civil court, comma, the remedy would differ inasmuch as orders passed under the self-same provision under the concerned matrimonial statute would, comma, in one case, comma, be appellable and in the other be revisable. Full stop, next para. Even the language of section 19 of the 1984 Act does not permit of such an interpretation. Full stop. Subsection 1 of section 19 provides that an appeal shall lie from every judgment or order, comma, tarpor italic say, not being an interlocutory order, italic shesh, comma, of a family court to the High Court, both on facts and on law. Full stop. Next para. The expression within double inverted not being an interlocutory order, double inverted clause, should obviously be construed in the context of the main matrimonial suit stroke proceeding and not the application itself, not the interlocutory application itself. Full stop. In the event the expression within double inverted interlocutory double inverted clause would mean only ad interim orders passed in connection with interlocutory applications, and when interlocutory applications were finally disposed of, comma, those were to be construed as a final order, comma, the concept of finality would be eschewed, ESCHEWED. Full stop, next para. Hence, comma, we find it very obvious that the expression double inverted interlocutory in section 19 within bracket 1 of the 1984 Act is meant in the context of the suit itself. Full stop, next para. The present impugned order is one disposing of an application of an interlocutory nature under section 24 of the Hindu Marriage Act, and as such, comma, is itself an interlocutory order for the purpose of the suit, comma, although passed finally in connection with the section 24 application. Full stop, next para. Hence, comma, this court is of the specific view that the statute does not provide for an appeal against the present impugned order. Full stop. Accordingly, what is this? FCA? Achha, what is FCA?
Family Court Appeal.
Achha. Accordingly, FCA 1 of 2024, along with the connected applications bearing CAN 1 of 2024 and CAN 2 of 2024 are dismissed as not maintainable, with liberty to the appellant to approach with a properly constituted challenge before the appropriate bench having determination. Full stop, next para. It is made clear that nothing in this order shall be deemed to be a final adjudication by this court on any of the issues involved, and it will be open to the bench where the appropriate challenge is preferred to decide all questions independently in accordance with law, irrespective of any finding made herein. Push up next para. The learned advocate on record for the appellant is granted leave to take back the certified copy annexed with the memorandum of appeal upon furnishing a proper photostat copy of the same for the records. Do it as early as possible. আচ্ছা, যেটা লাস্ট কথাটা শেষ করলাম ফুল স্টপের জায়গায় ফ্রম দ্য ডিপার্টমেন্ট হবে, এটা সেন্ড ডাউন করে দেবেন ডিপার্টমেন্টে, কালেক্টেড ফ্রম দ্য ডিপার্টমেন্ট আপন ফার্নিশিং অফ সোসাইটি। বইটা ওনার, হ্যাঁ হ্যাঁ, প্লিজ টেক ইউ। আর এই ফ্যামিলি কোর্স একটা আনিয়ে নেবেন, একটু রিকুয়েশন করে রেখে সাইড থেকে।
I'm for the appellant petitioner.
Yes, please.
Yes, directed to file a reply, affidavit in reply against affidavit in opposition. I have already affirmed, a copy of this, handed over to.
Now if you hand over, how can you get ready?
Matter was directed matter to be appear on 30th. Yes, your lordship. The inadvertent mistake, my lord, the.
Then let it come on 30th.
30th.
The matter is অনিন্দিত, এটা কি করে 30th অ্যাপিয়ার করার ডিরেকশন ছিল, but 25th it is stated.
21st matter was hard. When matter lordship was there.
25th was a Saturday.
Yes. No, 1 week, but 21st of January, matter was hard. When matter the lordship was granted liberty to file affidavit in reply within a week.
Application was directed to listed on Saturday, on a Saturday. That's the mistake we committed. So they have done the right thing, given it on the next day. Not on 30th. It was never directed to appear. Oh, it went down in the order wrongly as Jan.
30th.
Learned, acha, you are filing your opposition reply today.
Yes, because I was directed
Understood.
to reply 1 week.
The affidavit in reply filed today be kept on record. Push up a copy thereof is handed over to the learned advocate for the respondents. Push up next para. Learned counsel for both parties submit that in the order dated January 21, 2025, comma, the returnable date was erroneously mentioned as January 25, 2025, comma, although this court had actually directed the matter to be listed on January 30, 2025. Push up next para. Accepting such contention of learned counsel, comma, let the matter be placed in the list under the same heading on January 30, 2025. Please come on. Thank you for pointing out. Next.
Your Lordship, item number 12, Mr. Surya Prasad Chattopadhyay is appearing. Has not been able to come today, has gone to Mahakumbh, Your Lordship. We're praying for a very short adjournment.
No difficulty, but there is no application pending. Your Lordship have disposed of that application.
No, Your Lordship, Your Lordship.
একবার দেখে নিতে দিন, কোনো অসুবিধা নেই।
Can 2 is appearing, that has been disposed of.
Can
2 is appearing today.
we have not been subjected. Can one Your Lordship have disposed it?
No, today in the list, you have your list with you.
They have not served me any.
That is a different submission, Mr. Gupta. You are saying the application has been disposed of.
Can one has been disposed of? There.
Don't you have a list? The cause list says can 2 is appearing. You are saying it has been disposed of. It is a wrong submission then.
No, yes, my lord, wrong.
No copy is a different submission.
Yes, Your Lordship is
Give a copy.
Lordship, it has been affirmed already, Your Lordship. We will serve.
Can 2 of 2024 is appearing today before the court, and an adjournment is sought on behalf of the petitioner. An adjournment is sought by the appellant petitioner. You are the appellant in the appeal. Appellant petitioner. Push up next part. In any event, comma, learned counsel for the respondent opposite party points out that no copy of the application has been served on them. Push up, the appellant shall serve a copy of the application on the learned advocate for the respondent during the course of the day.
Lordship, kindly extend it to tomorrow.
Very well. By tomorrow. Push up next para. When should you keep the matter, Mr. Gupta?
May I only pray that let them give me the copy of memo of appeal also. I have been restrained
Direct
from
that.
marrying.
When should I?
Unfortunately.
Very well. When shall we keep it?
After a week, Your Lordship, if
Very
it is
well.
suitable to proceed.
The learned advocate for the appellant, comma,
একসঙ্গে opposition করে না।
comma, the learned advocate for the appellant shall also serve a copy of the memorandum of appeal on the learned advocate for the respondent to expedite matters. Full stop. You want to use an affidavit. This is for
Yes.
enhancement.
Then the
Very well.
time may be to some extent
True,
extended.
true,
sir.
true. The respondent is directed to file their affidavit in opposition, if any, within fortnight. Within, then it has to be a fortnight from tomorrow, because
Yes, tomorrow
uh,
service.
within February 11, 2025.
Right.
Stop. Reply, if any, shall be filed within February 18, 2025. The application, that is scan 2 of 2024, shall be listed next on February 20, 2025.
Right.
Thank you, Mr. Gupta.
Sorry,
Why should you be sorry?
I thought that
No,
only
no,
one-
you are not supposed to look, but
No,
you,
really.
your learnedness
It's
should
my,
point out.
it's my.
Yes. Yes.
There's a section 5 application.
In filing the main appeal. For the first time, then serve a copy and come back. Only the principal defendant is required to be served. What is the
The suit, well, the others have filed written statement. But
then you should serve all.
Yes, but they are supporting sort of.
Then get them appeared to
Yes.
somebody. But we have to direct it to, this is a partition suit.
No, this is a suit for injunction and active. This is a parking fee collector in the Bara Bazar area. She claims that her husband was initially doing that service.
You have an injunction application also, Mr.
Yes, yes, yes.
So in that you seek an injunction only on the respondent number 1.
Yes.
Yes.
And also the police, because they are party to the mischief. The agents of the defendant number 1.
Then they will also be affected. Then Mr. Chatterjee, please serve copy of the
Yes.
section 5. I will direct you to serve copy of both the applications and the memo on all the parties to expedite matters.
Let there be a injunction of
Cannot be.
that.
Section 5 is, you shouldn't submit
12
this.
days, only 10 days.
Even 1 day, nothing doing. You are late, you should suffer. You have to
Late
suffer.
because I was almost hospitalized by the injuries I suffered.
Your
And
client.
also a minor daughter, my minor daughter, while discharging my duty as parking fee collector.
Oh,
These are the medical certificates, my lord.
no, but we cannot allow expert.
No,
Unless we allow the application, we cannot pass it. We'll make it fast. How soon can you serve? Tell us. I mean, it has to be reasonable.
If I serve I'll serve the parties. My lord, after 2
No,
weeks.
you have asked for an injunction only in respect of opposite party number 1.
One.
So we'll direct you to.
Once
No.
there's a
In the
injunction,
suit, what is the relief claimed against the other defendants?
nothing. The police, because they'll aid any injunction.
All right, very well. Then we are directed to serve only on 1. The appellant shall serve copies of Can 1 of 2024 and Can 2 of 2024 along with a copy of the memorandum of the appeal on the principal defendant stroke respondent number 1, indicating that that both the applications shall be listed for hearing on February 17, 2025. When an affidavit of service to that effect shall be filed by the appellant, service of copies of the applications and the memo are dispensed with insofar as the pro forma respondent numbers 2 to 6 are concerned, for the time being.
Well, let me serve pro forma respondent number 2 because their presence will be necessary to clarify which side of the road is the lawful parking space.
First, let us pass an ad interim injunction, then they'll clarify. Let the respondent number 1 speak for itself. And police is not a necessary party here. Your relief is against them. So if you pass a direction, you can always seek police help also.
Absolutely. Well, the matter will be returnable.
17th on the same heading.
Obliged.
We give you approximately 3 weeks time. Yes.
This is my application praying for modification of my lord's order concerning lord the quantum of the occupational charges. Now, my lord, at page 11 of lord the application, lord, your lordship was pleased to pass an order, my lord.
Mr. Mukherjee, the deficit court fees and all have been paid. I will just take
order,
up.
yes, lord, because orders were passed on this, lord.
Yes,
at least 2 or 3 orders are there.
You will just check up from the memo.
Lord, I'll do that.
We don't find anything, any report to suggest that it has been done. That's why.
Lord, on instruction, I say, lord, yes.
Has been.
Date
We'll just check up. No, the memo should also reflect. Yes, done. Mr. Mukherjee, done.
22nd August.
Done.
This is the
What is the
evidence.
preliminary objection first?
But,
Then we have-
Lord, there are two things. Lord, apart from this, Lord,
Yes.
I need to file a supplementary affidavit because, Lord, I could not lay my hands on, Lord, the valuer's report. Your Lordship passed the order based upon, Lord, the report that they have submitted and the documents which, Lord, shows that they have subleased the property, Lord, to other entities. On the basis of that, your Lordship was of the opinion that this particular property will fetch, Lord, 137 rupees per square feet. It is 5,000 and, Lord, 6,85,000 to be paid. Our calculation as it comes, Lord, on the basis of the valuation, as on the status of, Lord, the property as we find, and the amenities that they do not provide us, Lord, it will not be more than, Lord, 73 rupees to 80 rupees at the most, which takes us to, Lord, 4 lakhs and not per month. Lord, on that basis, Lord, I have taken out an application, Lord, to say that these are the reasons why, Lord, it should not fetch, Lord, the amount.
But it was not an ex parte order.
No, it was on contest. I filed, Lord, an affidavit in reply. I could not, Lord,
Then, Mr. Mukherjee,
produce, Lord, the
what is
documents
scope of
which are.
recalling or modification of
Lord,
that order?
because, Lord, the materials are forthcoming before your Lordship, which might alter, Lord, the determination of the quantum
But you
of, Lord,
could
the
produce them
occupation
at the respective point of time. Otherwise, there will be no finality to orders.
Lord, your Lordship will kindly, Lord, consider, Lord, the documents. If your Lordship finds, Lord, those have some substance, then your Lordship will revisit, Lord, the
recall
quantum.
application because there is a scope of recall or modification.
Lord, it is a modification
Or
application.
even if modification, if it's on basis of new, you can file a review application.
Lord,
But review discovered, this is not discovery of new
no,
matter.
Lord, this is,
So, and
Lord,
error apparent.
materials are not there before your Lordship. To be very
Yes,
candid
and
and
error
honest.
apparent, therefore, also not, we cannot say
Okay.
that. So there is a scope for modification of an order.
But your Lordship will kindly consider, Lord, that these are
We
the
will
materials.
consider since you have filed an application and it's thick, and you already one appearance of yours is gone. So we'll.
Lord, there's only one leave that I'll pray, Lord. By 5th of February, Lord, I'll file a supplementary to this.
Then we hear it along with that. Give a copy.
And in the meantime, Lord, if my learned friend wishes to use an affidavit, Lord, he can file some, Lord.
5th
And
February.
honor,
If they can, they can.
and without prejudice, my Lord, I'll put in, Lord, some money, my Lord, before the court as a deposit.
No, you have to. We don't stay our previous order in the meantime.
Lordship.
We are not staying it. We can direct them to file opposition and ensure that will not
I'll
pass any
take
stay.
an
You have to
extension.
pay in the meantime at the previous.
Lord, then kindly grant me, Lord, 10 days extension to put in the money. I took out the application within time, not beyond my Lord's the first date of Lord putting in the deposit.
No, you have to go on making the payments, Mr. Mukherjee. We will adjust that if you allow your.
No, Lord, I will do that. Certainly, I've also told them. But
But
Lord,
that has
your
not been-
Lordship said the first payment should be made by 15th. I took out an application on 15th. Kindly extend that period for 10 days. I'll put in the money, Lord.
In an
without
application
prejudice.
for modification.
Without prejudice, Lord, I'll go on.
Not 15 days, Mr. Mukherjee. A week.
1 week.
Today we are on 27th. We'll give you till
Very
3rd of
good. I bow
February.
down to your Lordship.
The present application has, you take a preliminary objection for that reason, that modification does not lie. They were heard.
And Milord, this is really in the nature of a review.
All right. The present application,
One more thing, Milord, almost Milord 30 lakh is lying payable.
30 lakh is?
Lying payable, Milord, by my learned senior friends client, Milord, to us. As per my Lord's order.
So
30
they'll do
lakh.
that within a week. We are extending the
Lord,
time.
that is, yes, Lord, whatever, Lord, the first installment shall be paid
No, this is from
by,
the date
Lord, the
of, Milord,
15th of
30th.
January.
From the date of.
Yes, along with arrears must be.
Yes.
Yes, your Lordship had directed that.
No, Mr.
Paragraph
Mukherjee is
30.
asking for extension of whatever we have directed. There has to. The present application bearing Can 2 of 2025 has been filed by the respondent. Sorry, by the appellant must be. You're the appellant.
I'm the appellant.
The appellant for recall of an order dated December 18, 2024, by which stay was granted to the appellant subject to imposition of occupation charges. For sub next para, learned senior counsel submits that certain documents have been annexed to the present application to show that the occupation charges were not a correct occupation charges granted by this court were not a correct reflection of the actual payables in respect of the disputed property. For sub next para, learned counsel for the respondent takes a preliminary objection to the maintainability of the present application and submits that the order of this court has not been complied with. For sub next para, learned senior counsel for the appellant seeks an extension of time to put in the first installment and the first current deposit as per direction of this court, subject to the outcome of the present application. Push up next para. Accordingly, we extend the time for putting in the first current installment as well as the first monthly deposit, as well as the current installment of the as well as the first installment of the arrears occupation charges till February 3, 2025. Full stop. It is made clear that such deposit shall be without prejudice to the rights and contentions of the parties in Can 2 of 2024. Full stop. Next para. Will direct affidavits also? Should we direct affidavit? You'll
Your
file
Lordship,
supplementary affidavit within 5th.
Yes.
Give a copy of that also.
Yes,
We'll
but so
do
that
everything.
in one hearing.
Yes, yes, yes. On the prayer of learned senior counsel appearing for the appellant, leave is granted to the appellant to file a supplementary affidavit on the next returnable date with an advance copy thereof to the learned advocate for the respondent by February 6, 2025. Full stop. A composite affidavit in opposition shall be filed to the application bearing Can 2 of 2024, as well as the supplementary affidavit by
1 week.
Thank you very much. Within February 13, 2025. Full stop. Reply, if any, shall be filed by February 20, 2025. The application shall be listed next on February 24, 2025 under the same.
Agreed.
Two things, my lord. By that time, the second installment would also become due because 15th of February will pass.
My lord,
So, my lord,
that will be my lord covered because
So,
my
my
lord,
lord, kindly indicate. Kindly, my lord, indicate. Very good. And my lord, the application number would be of 2025.
Everything of 2025.
Yes.
Two of 2024. Sorry. 2024 is written here.
So it's filed, my lord, in February.
Yes, must be 2025. It's a wrong. In the application, it's mentioned. To 22 of 2025 হবে সব জায়গায় মেনে যাবে। না, ওদের application এ print আছে ভুল। Application তাতে blank of 2024 করা আছে। Very good. No, it was prepared in 2024 probably before the order was passed.
Grateful. Thank you.
15. Yes, Mr. Banerjee. What is the matter? Necessary correction, pin code and all have been done.
Yes, done. Affidavit of service, my lord.
The respondent, my lord. I am
Very
paying
good.
for a week's accommodation, my lord.
Refused.
My lord,
Why? On what ground?
client wants to engage a senior, my lord.
My lord, even my senior is, my lord, out of station, my lord, your lordship.
Kindly,
Well,
Your
I'm-
senior is also in the same place.
Mr. Banerjee is out of station.
Who is your senior?
Arindam Banerjee.
Mr. Arindam Banerjee has also gone to Kumbh.
No, my lord, not with Mr. Roy.
What are you doing? The court will be a better and more holy place now. What will you
Well,
do
there are-
with so many puppy judges?
There are two applications, my lord. One is, my lord, for section 5, my lord, of 29 days delay.
Whatever. If you have gone to Mahakumbh, then you should remain there for the rest of the time.
My lord, I'm not
Acquired
praying for
stuff-
adjournment, my lord, on that.
I am praying for a week's accommodation.
Very well, granted. Very well, come back after a week. Is on the prayer of the respondent, the matter is adjourned till February 5, 2025.
6th February, my lord, kindly.
February 6, 2025? Yes, next. But on that date, you have to be prepared if Mr. Banerjee is not there. That's the understanding. I'll remember. My learned brother will also remember. Yes.
Grateful.
Next. Please give your appearances, both of you.
Yes.
Mr. Banerjee and you. Yes, who is appearing in the next matter?
For the respondent.
Respondent.
This application is barred by limitation.
This is a Section 5 application.
Appeal against an order granting probation.
This must be a condonation application then. What is the delay?
45 days is what they are saying. 41 days is what they are saying. Paragraph 8.
What is the reason given? Who is appearing for them? In these matters, why don't they appear? I don't understand.
Registered will, my lord.
Serious heart disease and kidney damage.
This is the grounds for challenge where I am the.
So what is your objection to that?
The objection is on the point of limitation first, man.
Limitation, condonation application is that your objection is of limitation. What are you submitting? We are on the delay application now. Unless we condone the delay, we cannot take up any other application.
I am for the respondent. I am opposing their application.
On what ground? I mean, yes, why shouldn't we grant this? Because he has taken a ground of serious heart disease and kidney damage.
He has taken a ground of serious heart disease and kidney damage. My lord, the appellant, unless this order is recalled, appellant will suffer irreparable loss and damage. But
You will also suffer heart disease and kidney damage. Kidney may not be affected. Heart may be, yes.
But the ground is that the testatrix was suffering.
Testatrix was suffering.
Testatrix was a patient of serious heart disease and kidney damage, physical inability to move. But that cannot be a ground for the delay in this case.
We missed this out. This is very interesting. Shabash.
That sees paragraph 2.
Yes, yes, you're right. We didn't imagine even this could.
My lord, and sees if the my lord takes the main application, it's not.
Testatrix
Copy that
was
was served to
suffering.
me is not paginated, my lord. There, the certified copy was ready on 1st October.
Delays more. What is the delay according to you?
The judgment was passed on 28th August 2000.
Do the mathematics and what is the
90
delay?
days, 3rd October is still 3rd January. Not even 3rd January, it's still
And the interregnum, their deposit
1st
and the
January,
code.
31 days. So then they
The delay should be then?
they filed 14 days. And then if we calculate from beforehand, from 28th of August.
Add up and tell us what is the total.
28th of August, my lord, that's
Use your pen and or calculator. Phone calculator you can use. কি রে ভাই?
the only thing is that they've not even said when they had applied for.
No, they have said nothing actually.
That is what.
What is the delay, just?
They, my lord, if the it's a filed on 20th of August, then 90 days from 20th of August is November 26th, my lord, effectively.
When did they file?
They have filed on 14th of January, man. They've also mischievously filed an application for injunction.
No, that is different. But then the delay is less. You said something in September or November, you said.
26th of November should be the date. 90 days from the date of the.
If 26th of November is that date, then the delay is less than 49 days.
41 days is what they have said, man.
49 written here in the copy.
Well, this paragraph.
Anyway, but then the delay is less than that. 26th November to. It was
31 days.
It was filed before that. It was filed on 25th of November. It was filed. Then it was filed within time. You're arguing against yourself then. Let us see the judgment date. We'll calculate for ourselves.
That has been served to me as
Let us see. Let us see. Let us see. Let us see. Yes, you don't have a copy of the impugned judgment. You cannot have a copy. That's it.
Judgment is here, man.
It's annexed. You have got a copy of the memo.
Yes, my lord, but again, it's not paginated, my lord. Memo that has been served.
Need not be. I mean, they have annexed the entire certified copy. Where is the judgment? That is fine. They have yes, 28th August. 20th August. Okay. When did they apply? সেখানে 3 দিন গেল 3 দিন অক্টোবর 3 দিন গেছে এখানে 28 days অক্টোবর 3 দিন 28 দিন গেল 31 দিন হ্যাঁ 31 দিন হয়ে গেল it's within time. It's within time. We'll dismiss the application as academic. We'll grant them stay then.
The copy that has been served to me already does not show the date when they had applied for the certified copy when it was ready. Not paginated.
Let us check again once. Now, so 20. We are giving you the dates also. You can also help us. You can add up. 28th of August, judgment was passed. 31st of August, they filed the application for certified copy. So 3 days gone.
Yes, my lord.
Achha. The requisites were notified to them on a particular date, 30th of September. They deposited on that date, so that time they're not losing. Now, the certified copy was made ready on 3rd of October. If it's 3rd of October, they have lost 3 days there. So October is of 31 or 30? 31. So 28 days further in October. 3 plus 28, 31. 31 at the end of October.
61 days, November.
And they file it in November sometime. 25th of November they file. So It's within, in fact, much within limitation, much within limitation.
Not opposed on this ground.
So then we accept your opposition to the Section 5 application and we dismiss it because it is academic, unnecessary. We find from a calculation, let us see whether the SAMP report has given a report. That would be interesting to us. No report is there. No. No, there is some of the defendants are not parties here, made parties to the appeal. ওরা বলছে যে appellant-এর কাজ আমাদের। We'll direct them to cure the defect, whatever the defect is, because defect is 3 of the parties are not made included here. So we'll look into that. We are definitely not granting stay without them being present. No, we won't do that. Can 1 of 2024 is an application for condonation, is an application purportedly for condonation of the delay in preferring the appeal. Push up. Upon a perusal of the certified copy, we find that the impugned judgment was passed on August 28, 2024, and the certified copy was applied for on October 31, 2024. Pushed up. The requisites were notified and deposited on the same date, that is on September 30, 2024, by the concerned department of the trial court. Push up next para. The certified copy was made ready thereafter on October 3, 2024, and the appeal was filed on or about November 25, 2024. Push up hence, it is evident that the appeal has been filed well within the limitation period, and the condonation application is a redundant exercise. Push up. Accordingly, can 1 of 2024, being an unnecessary and academic application, is dismissed without any orders to cost. Push up next para. We find from the office report in the memorandum of appeal by the additional stamp reporter that defendant numbers 2, 3, and 4 in the impugned decree have not been impleaded as appellants herein. Push up. Accordingly, the learned advocate for the appellant is directed to take immediate steps for curing such defect within a fortnight from date. Pushed up. Liberty to the parties to mention the other pending applications for inclusion in the list after removal of the defects. Thank you. Please give your name. So you are appearing. প্রথম লাইনে একটা দিয়ে দেবে, মেঘনাথ একটা দিয়ে দেবেন। ওই যা বললাম সবকিছুর আগে, heard learned counsel for the respondent, push up, the appellant is not represented. এটা দিয়ে তারপর বাকি যাবে। Yes.
Item 17 appear for the appellant, my lord.
Yes.
We must first see the affidavit of service. It says insufficient address. Now the difficulties I suffer eviction decree. Within 7 months, in 7 days, the suit was decreed. 7 months, 7 days. I appear on the 3rd day with a 151 application for giving some time. Rejected, or she will kindly come.
So this is a good court then. The judgment must also be good. Fast court, good court.
Proactive court.
Should be.
It's a proactive.
Should be because of the dilatory tactics taken by learned counsel.
Now, Lordship, kindly see 168, page 168 once.
Yes.
4 orders, only 4 orders. Page 166, sorry. 166 is the first order which starts for order number 1. They filed
eviction under the Rent Control Act?
Yes,
97
because yes.
As per the plaint also?
As per the plaint also. 106 notice was given.
The 106 then is TP Act?
No, this says the Ghor Bharatia. But under TP Act with 106 because my rent
then
was
under TP Act, not rent
more than a lakh.
Not
more than a lakh. Now here
TP Act 106 prove if they prove that is sufficient.
They have, but I have a chance of defending the case, my lord.
You did not appear at all.
I'll tell you, Lordship. The order number 1 is 9th of April, which is now fixed on 11th of June, page 166.
Has been delivered.
Yes, has been delivered.
On the 11th June has been delivered, but you don't appear. You choose not to.
I didn't appear on that day. I appeared on the 3rd day only, my lord. It was put for ex parte. On the very first day, it was set for ex parte vote. On the first day, when this SRAD did it, it was they let the suit run ex parte against the defendant. Third day, evidence over.
Why shouldn't the court do that?
I know, my lord. Now I appear.
One reason.
No. Up to this is okay. I appeared because didn't appear. I appeared on the third day. Is page 168. I appeared on that day. I appeared. Entered appearance was done on my behalf. I filed a petition for time petition. Can they give me time? It was kept on record, and then the court proceeds for hearing of the plaintiff. The hearing was done on the fourth day. Now thereafter, the order page 206. This haphazardly added, my lord, is annexed. It's 206 is the next order, where I file only a time petition. On 206, my lord,
So you appeared twice, you filed time petitions.
no, then
Don't even
151.
ask for removal of the suit from the expertise board.
No, 151 years I have done it in 151. This on the order. This is on 3rd of October. On 3rd of
Recalling
October,
order dated 11th. Yes.
on 3rd of October, I filed a
Yes, you have
151
done it.
petition. Page 06. Now on 3rd October, what they do, my lord, this was kept with the record. And then nothing was done.
Oh.
And then, my lord, the next date is fixed for, the next date is 12th of November. Lord, she will kindly see 12th of November. What happens in 12th of November? 12th on page 208. The hearing of the application of 151, page 208. Now, the learned judge was of the view that the ground shown is not sufficient.
Due to ignorance, you failed to appear means?
Ignorance is on the
Summons was served.
first day is already, one day I missed, which I showed to your lordship at page 166, 167.
You are educated people.
No, I am, but one day I missed the court. I missed the court on the second day of the order, which is page 167. I missed 1 day. 2 days rather. In
2 days.
month of June and November.
After summons 2 days.
After summons 2 days. I
We
missed
cannot take this for granted any longer because we are short of time and we have a heavy pendency of cases. Now the attitude of the court and the litigants have to change.
I know.
Only 2 days, my lord, only 3 days, my lord. Even 1 day, court can.
Court can.
I should.
But court can, and if I don't
You don't appear, you go on not appearing, twice fixed for ex parte. It was your duty after service of summons to engage an advocate,
Yes.
to go to the court, to ask for what is the next date.
On the very first, on the very
Yes.
next. I have
2
not
dates
done.
elapsed. You did not appear.
Kindly, lordship.
We encourage this. Mr. Mitra.
Now, my lord, page
So,
206.
Let's say you have no prior.
Page 206, my lord, and then at page 206, it is now fixed on 12th of November. Now on 12th
Yes,
of
yes.
November, page 208, my 151 was dismissed.
It is recorded today also the defendant did not file WS.
No,
You made an
WS
effort to file a written statement.
No,
You should have come prepared with a written statement at least.
written statement was not on I was not carrying the written statement on because it was already
Then
put
it was a
ex parte.
miscarriage of justice and written statement.
No,
if you are not
it was
carrying.
already ex parte. Unless it is recalled, man, it is already put ex parte in the second day. At this order,
You may say that because it's fixed for ex parte, you
Yes.
need not be prepared with the
no, it is already ex parte. Man,
Alright.
12th of November, is it due to ignorance? He failed to appear before this.
Ignorance of what? Ignorance
Ignorance-
that you have to appear after getting summons of a court. This is
That
not
is
even
my
ignorance
fault.
of
That is our fault. I cannot say that is our fault. 2 days in June, not only consecutive June and November, it's our fault. Now, my lord, and then
And this is over a period of 7 months, you say.
7 months.
Not one.
November, April to November. April to November, and then it's fixed for 28th of November is the impugned order. The decree was passed.
Serve a copy and come back.
But I attempted to serve, my lord.
We had directed you.
No,
Ah,
there was no direction. But the difficulty is I served on the plain address. There's no direction, no caveat. Also, we served, my advocate on record served it. But the only difficulty is as returned as insufficient.
So we are not taking that because we did not direct you.
Yes,
This is
that
a substitute of rule, you know.
Yes, yes.
Unless you direct, we cannot take any
Has to,
affidavit service. Affidavit service that return করে দাও.
Yeah.
Insufficient address.
Yes. We have served on the address in the plaint only. Maybe
Try
served
to
an
make a
advocate,
proper service.
advocate on record of the
What is the stage of the execution?
the just filed. Tomorrow is the second date. That I'm not on. I'm not.
The petitioner is directed to file copies of serve copies of the application on the respondents, indicating that the application shall be listed for hearing on February 17, 2025, when the appellant shall file an affidavit of service to that effect.
But liberty be given to serve the advocate on the trial.
Hence, learned counsel for the appellant that a previous attempt to serve met with the outcome that the appellant's appellants had apparently been served at a wrong address, comma, although the notice was sent to the address as given in the plaint, comma, the appellant is also directed to serve, comma, along with directly on the respondents, comma, on the learned advocate appearing for the respondents in the executing court, indicating the next returnable date. Full stop. An affidavit of service to that effect shall be filed on the next date. The learned advocate appearing in the executing court, because may be different from trial court.
I am for the respondent wife, my lord.
My lord, I am for the appellant.
As a husband, what happened? Your divorce should dismissed or their divorce should allowed, decreed?
My lord, I would like to mention on the previous occasion of
No. What is the challenge against?
uh,
What happened in the court below? Your
Correct.
divorce suit was dismissed.
yes, Your Honor.
All right. Yes. So, now next what?
My lord,
50,000.
on the last occasion of
50,000 paid.
Yes, my lordship, it is already paid. But your lordship, today I just filed the fresh wakalatnama,
Oh,
and that's why I couldn't able to.
you are appearing on change.
Yes, Your Honor.
So have you obtained a no objection?
Yes, I have also filed that.
Filed it in the department.
Yes.
So what do you want now?
I want a few time, your lordship.
Opposition has not been filed.
No, your lordship. And I have received the wakalatnama after 17th of January. That's on 20th of January, I received the NOC.
You are ready with the opposition, Mr. Mukherjee?
My lord, I am filing. I have stopped them on 15. I've already
This is against what? The challenge is against.
challenge is, no, my application is for alimony pendente lighted.
Ah.
Can their stay application, lordship already dismissed?
Yes, sir. Yes, rightly.
So
Oh, the order was passed on your application. So do you have to file the opposition?
Your lordship, I couldn't able to prepare the same.
We'll give you one further week, not more than that.
Lordship,
Your lordship, at
today I
least
am filing this my supplementary affidavit and affidavit of assets.
We directed you that.
Yes.
Have you given copies to them?
Yes. Already
Then
filed.
we'll give them some more time to file a comprehensive affidavit. File that. The affidavit. আপনি কিছু বলছিলেন, sorry. বলছেন? ওই জন্য আমরা state agree.
my lord, only one submission. Can you please grant at least 2 weeks time for me?
We'll give you 2 weeks. We'll give you 2 weeks time. File a comprehensive opposition to the supplementary affidavit as well as the main alimony application. You are filing your supplementary affidavit and affidavit of assets.
Affidavit of assets.
The supplementary affidavit and affidavit of assets filed by the respondent wife in support of her alimony application today be kept on record. Full stop. Copies thereof, comma, it is submitted, comma, have already been served on the appellant. Full stop. On the prayer of the appellant, comma, the time for filing affidavit in opposition, the time for filing a composite affidavit in opposition to the alimony application as well as the affidavit of asset and supplementary affidavit is extended till February 10, 2025. Full stop. Along with his affidavit of asset, comma, the appellant husband, sorry, along with his affidavit in opposition, comma, the appellant husband shall also file his independent affidavit of assets by the said date. Full stop. Next para. The respondent wife shall file her affidavit in reply, comma, controverting the allegations made in the husband's affidavit of asset, comma, if necessary, comma, within February 17, 2025. The application shall be listed next on February 19, 2025.
Much obliged.
We'll take up the next matter after some minutes.
Item 19, I'm for the applicant, my lord.
Yes.
I'm led by Mr. Kamlesh Jha, my lord. Your lordship on earlier occasion directed to file supplementary affidavit, my lord. It is filed, but it has not been settled, my lord. The mother of learned senior advocate is ill, my lord, in critical condition. He is in Delhi, my lord, for the last 15 days. I'm praying for a week's time so that it can be settled and filed and served upon the opposite party, my lord. Only a week's time, my lord.
And everything gets postponed, opposition and everything.
And another Malot development has happened in the meantime. Malot, the opposite party number 3 had died.
Oh,
Substitution has to be Malot.
so you give the particulars to them?
Yes, I have.
Party number 3.
Learned counsel for the appellant seeks a week apostrophes time to file the supplementary affidavit as directed earlier. Full stop. The time for filing supplementary affidavit is accordingly extended till February 5, 2025. Stop. Next para, learned counsel for the respondent submits that the respondent number 3 has died in the meantime. Full stop. The particulars of the deceased respondents, the particulars of the heirs and legal representatives of the deceased respondents shall be furnished in writing to the learned advocate for the appellant by the learned advocate on record for the respondents by tomorrow.
Malot,
I have received,
I have given.
Just now.
Acha. Shall be na kore has been filed, has been furnished to the learned advocate for the appellant here and now. Full stop. Leave is granted to the appellant to take steps accordingly for implement of such heirs and representatives of the deceased respondent. Full stop. The matter shall next be listed on February 12, 2025. In between, file your substitution application and give a copy to them also so that, and mention that on next Monday so that we can.
We are also intending to file Malot opposition with regard to Malot it.
Very well. Affidavit in opposition to the application, present application shall be filed within February 6, 2025. Reply, if any, shall be filed on the returnable date.
And Malot, another issue, Malot has given the liberty to them to Malot to file a supplementary affidavit in connection with the stay. Malot, then Malot, if they are supplementary, they will file by 5th Malot.
Acha, an line add an advance copy of the supplementary affidavit shall be given to the learned advocate for the respondent by January 31, 2025.
Right.
Do that.
May it please, Your Lordship.
Yes. Yes, sir.
The interesting question of law, which is, my lord, before my lord today,
yes,
is that
this is order 41 we have
order
started.
41.
All right.
Second.
Affirmance?
No. Both
Yours.
court lost. Suit under 106.
Then affirmance. Both court.
Now, the interesting
You are
question.
the respondent, must be. Defendant must be.
The interesting question of law, my lord, before my lord, is that a Muslim man, a tenant, dying intestate, will the heirs be tenants in common or joint tenants?
Notice was served only on one.
Only on 3 of the defendants.
Not all.
Not all.
How was it dealt with by the court?
Court said it is tenant in, it was joint tenancy, so one service upon.
Why do you say it is not? Cite something or
well, I will
satisfy us on that.
Well, our court has dealt. Well, may I first submit? This is 1990, AI 1998, Calcutta 221. I will straight away come to paragraph 27. 28.
Yes.
28 says in Mullah's Treatise of Transferable Property Act, edition so and so, the position of joint tenants and tenants in common has been discussed in very lucid manner. It is stated inter alia that there is a rule of English law to presume that transferability of persons, joint tenancy with survivorship, unless the word severance was held in Moray versus Bird, the principle is adopted in 106 of Succession Act replacing so and so. A joint tenancy has been recognized. by gift by will of an Indian Christian
Wait,
Parsi
wait.
Muslim.
The rule of English is to presume that a transfer to a plurality of persons. There it's a transfer. That creates a joint tenancy.
Joint tenancy.
Here it's not a transfer.
Now, only in case of a will, gift by a will to an Indian Christian Parsi or Muslim, then it becomes joint tenancy. Tenants in joint tenancy.
No, the succession does not differ between a Hindu and a Muslim. Apart from the line of the people who are getting it.
Kindly takes now paragraph 33.
Yes. 33.
It would not be out of context to mention that only in Hindu law, not only in Hindu law, under the Hindu law, but under Mohammedan law, when a person dies, instead estate develops on heirs who succeed estate as tenants in common in specific shares and not as joint tenants.
So the same law applies to Hindus. There are several.
Muslims.
Yes,
So
here it is said
tenants in
that the
common.
same law applies, the same principle applies to Hindus and Muslims. And
they
in
are-
Hindus, in case of Hindus, regularly orders are being passed.
No, but here also it says only in Mitakshara it's joint tenants in common, joint tenancy.
So what
only
will be
in
the
case of
effect
Mitakshara, it is joint tenancy. Preceding, this is a case of a Hindu tenant.
This is this reported judgment.
Reported judgment. But in this case, although it was said that the tenants are tenants in common, but ultimately the court found that one was representing the estate of the tenants in common. Therefore, the notice was sufficient.
What is this distinction in this respect between a tenant in common and a joint tenant?
Joint tenants are tenants who are equally responsible. That paragraph 27 says what is a joint tenant.
Yes.
The salient feature of a joint tenancy is that it follows unity to title, possession and interest in commencement to title. But in case of tenancy in common or co-tenancy, there may be a unity of possession and commencement to title, but two other features are absent. Now, decided on Ram Avtab versus Jatashankar has explained the difference of joint tenancy and tenancy in common in a very lucid way in paragraph 41. According to Hasbury's laws of England, joint tenants are those who form a body of ownership. Each tenant has identical interest in whole and every part of it. The title of each arises of the same act. Interest in same to the extent of nature and duration. The joint tenancy connotes four ideas: unity of title, possession, interest, and unity of commencement of title. In tenancy of common, there must be unity of possession. And whereas the title derived from a common sale deed or of inheritance from one person might well be commenced from one, but at the same time. However, other ingredients which would be the main ingredients of joint tenancy would be missing.
So what is missing is unity of title, but what remains is unity of possession and commencement of title.
Yes.
So if unity of possession is there and one is served a notice.
The law is clear. If it's a joint tenancy, notice to one is notice to all. But if it's a tenancy in common, then notice has to be served upon all.
Show us something on that.
But now, this judgment, my lord, regarding the portion where regarding this judgment said that even if it's a tenancy in common, since one was representing all, then notice was duly served. This was distinguished in 2005 Calcutta Online.
This means Justice Mitra's judgment.
Yes, Mr.
Achha. Let us see that.
Kindly takes paragraph 14 onwards.
Yes.
15 says about HON'BLE Krishna.
Yes.
Mr. Tandon, in his contention, placed strong reliance upon decision of division bench of this court in HON'BLE Krishna, where it said the division bench followed principles laid on Bodu Venkatesh, but thereafter facts on the same case can the court different after the death of father became sole tenant under the plaintiff and his brothers, though not in writing, legally speaking, had relinquished their rights as tenants in respect of the suit premises by good conduct appear in paragraph 53. The next paragraph, the Lordship, however, observed, even assuming what the argument the other years did not relinquish principle of representation, will apply and action taken as a defendant alone will bind other co-tenants. D. Aforesaid observation in paragraph 54 in our view is direct conflict with the decision of the Supreme Court in Textile Association. Madam, I will also place Textile Association, madam.
Let us complete with this first.
Textile Association was unable to follow the aforesaid observation of the division bench. The said decision of the division bench also referred to observation of Apex Court in Javed Ahmed, where the bench consists of 2 judges, observed the Supreme Court sits in division bench of 2 judges. The sake of convenience, it would be appropriate by the division bench of 3 judges to purport to overrule the decision. But this is because of overruling. But it has held in this judgment in paragraph 19,
Yes.
18. In case of Suraya Begum, consists of 2 judges of the Supreme Court, even noticing the case of textile was of the view the principal representation of interest of person not implicated in a judicial proceeding, though named or a party is not known. The Lordship referred to cases of Karta for Hindu family, the cases governed in Order 1, Rule 8, and Explanation 4 of Section 11 observed that the example could be multiple. Their Lordship, however, made it clear that such principles will be subject to essential conditions, the interest of person concerned really been represented by others. In other words, continued, his interest will be looked after bona fide manner. Then, in our opinion, aforesaid view explains the statement is direct contradiction with the decision of Textile Association where the plea of representation put forward by the Landed Council appearing for the landlord was turned down as would appear from paragraph 4. Whether paragraph 4 is quoted, and here, my lord, the Honorable Supreme Court referred to the earlier to the judgments of Kanji Manji and H.C. Pandey. Now, paragraph 22. As the Supreme Court in case of Textile Association Supra and considering the earlier decision of Supreme Court in case of Kanji Manji and H.C. Pandey specifically to conclusion that principle laid down in those cases led to service of notice cannot have application when the question of making all joint tenants parties in a suit of eviction as well. We are bound by the decision and the said decision is not to upset the subsequent decision by the landlord. So it has to be a notice to all the.
You took a specific point in your case also. That it is not mentioned.
Yes.
Let us see the Textile Association first, then move on.
The Textile Association paragraph 4 has been quoted extensively. So I've just brought that judgment.
That's a very good.
Court went on that is joint tenant. So notice on 1 is notice.
Right. Here, do you by any chance have a copy of the notice? No. Let us see the findings of the court. There's a section 5.
No, not section 5. It was dismissed for default, then restored.
Those stages are over.
It is over only. Stay application, my lord, will not hear because once admits, it goes to a single bench.
Yes. No, stay we can hear for the purpose. If we admit, then we can hear for the purpose of editing also. Because we have order 41 and connected applications. And let us see how the courts, both the courts dealt with it.
Well, kindly takes the
banks upon the notice.
Trial court judgment. Issue number 5. No, not issue number 5, my lord. Issue number 6. Internal page 8.
What is issue number 5?
Issue number 6 is the
notice. Eviction notice, sir, yes.
Then internal page number 8.
8, yes.
It is true that the defaulters have challenged the notice of eviction. From the pleading dispute, beyond dispute, the defaulter become tenant by operation of law after demise of Abdul Malik. The plaintiffs, in order to prove service of eviction notice, filed documents which are marked Exhibit 4. Exhibit 4 says proof the notice of eviction was served upon defaulters. Exhibit 4A, 4B, 4C. So there are 3 notices, 3 service out of 6. And then one goes on. Very specifically proof defaulters received the notice of eviction.
No, but from Exhibit 4 series, it is well proved that the notice for eviction was served upon the defaulters. They live in the same premises.
Yes, it has to be on all the defendants. So only 3 has been served.
Live in the same premises, I mean, let us see.
Specifically, the defaulter received notice, only challenge the notice, but defaulters have not taken step to prove none of the defaulters have signed the ID card document of the plaintiff overriding effect. Depending on the facts, I am the concept of eviction notice served of any of the defendants sufficient service. In such type of knowledge of one defendant implies knowledge of other defaulters. The defaulters by oral evidence could not destroy the case of the plaintiff. Hypothecalities cannot negate 106. Defaulters nothing but tenants. True owners of the plaintiffs are required. Then it goes on requirement. Now the plaintiff serving notice upon defaulters while the suit entire evidence on record and hold the notice served upon properly upon the defaulters. So more the materials available on record clear the evidence legal and properly. The appeal court.
Yes.
Paragraph 4, page 4 is internal page 4 is findings.
Mhm.
And then paragraph page 5. Page 5 last due to refusal on part of the no, page 6 is the better type. Due to refusal on the part of the plaintiffs, the defaulters, it is true that defaulters challenge the notice of eviction. From the pleadings of the beyond the dispute, defendant become tenants of operation of law after demise of Abdul Malik. Plaintiff, in order to prove the service of notice, filed some documents, exhibit 4 series. 4 series as well proved the notice of it served upon defendants. Exhibit 4A, B, C, very specific defendant received the eviction, challenged the notice, but also taken steps to prove none of the defendant not signed. So the documents of plaintiff overriding effect, depending on the facts in I am considered view that
But
eviction
courts,
notice.
both the courts say that all the defendants received.
No, ABC, there are 3 notices. Goes on the premise that served upon one is served upon. Is served upon. I am of the considered view that if eviction is served upon one of the defendants, so sufficiently served, type of notice implied knowledge of other defendants.
We'll admit on this one. The present second appeal will be heard on the following substantial question of law. Colon the next para. Whether, in view of the notice under Section 106 of the Transfer of Property Act, which was the premise of the eviction decree granted by both the courts, was validly served, since the exhibits show that service was effected only on 3 of the total 5 defendants.
6
of the total 6 defendants, all of whom were tenants in common on the demise of the original tenant of whom they were heirs. Next, Roman 1 হলো এটা, Roman 2 আর substantial questions হবে. Whether on the demise of a Mohammedan male, his heirs becomes joint tenants or tenants in common in respect of the tenanted premises. Questions of law গুলোর part of. Next para. You are appealing for the respondent.
My lord, I have not been served with the memo of appeal, my lord.
You are not required to under the law.
My lord,
Have you lodged a caveat?
No caveat, my lord.
Then no, memo in any event you are not entitled. Copy will direct them to serve on you.
Yes, I understand.
What is your full name, please?
Muhammad Shakil, my lord.
Mr. Next para. When the stay application is sought to be moved, Mr. Muhammad Shakil appears and submits that he has instruction to appear for the respondents, who shall accordingly a copy of the stay application be served on the said learned advocate. Full stop. There will be stay of, you have levied execution.
Yes,
Yes, my lord.
Eviction.
My lord, even, my lord, they preferred section 47 application, my lord. That has also been dismissed, my lord, before the law.
Section 47 is on completely different footing than a second appeal. What is the CAN number of the stay?
Filed in 2015, must be 1 of 2015.
ক্যানটা লিস্টে অ্যাপিয়ার করছে আজ দেখুন তো লিস্টে নেই, যেটা বললাম ওটা থাকবে, ওই কপি সার্ভ করবো। লিবার্টি টু দ্য appellant to mention the stay application before the appropriate learned single judge having determination to take up such matters. We cannot pass in order, it's not in the list.
Obliged, my lord.
Thank you. অ্যাপিলটা শুধু ওই অর্ডারটা শুধু এসএটি নাম্বারটার উপর হবে। হ্যাঁ, স্টে অ্যাপ্লিকেশনটা আমরা বলেছি সার্ভ করতে, কিন্তু স্টে অ্যাপ্লিকেশনের উপর কোনো অর্ডার দিইনি, কানেক্টেড স্টে অ্যাপ্লিকেশন বলেছি, সুতরাং ওটা ওই থাকবে।
I have to go down department SA number, then I have to move the can.
Not strictly, before hearing it has to be done. Previously it used to be done that way, but since the time taken now is prolonged, therefore we don't insist on that much. Before hearing it has to be allotted.
I'm old school.
No, you are old school, but the procedure has become so. Yes, before hearing we are also old school. But regarding moving of a stay application, at least I can speak for myself. I am new school. Yes. Next.
21 minute time for the appellant.
Yes, Mr. Dev, what is the matter?
This is a suit for eviction. I am the defendant appellant. My lord.
Lost in both the courts?
Lost in both the courts. My lord, evicted on the ground of default in payment of rent.
Only?
Only, my lord. The ground.
There were other grounds in the plaint also?
There are other, no, my lord, only this ground. But my contention is, my lord, the defendant, my lord, is a bharatiya under the Thika tenant. And it is admitted by the plaintiff in their cross-examination. Well, the suit between a bharatiya and a Thika tenant cannot be decided
Supposed
by
before the
civil court.
controller, Thika controller, but what is the finding of the courts below on this?
Well, at court below,
It's
they
a factual
decided that
question.
they have the jurisdiction to try. But in the,
Despite observing that you are a Bharatiya?
my lord, kindly see
If
the.
it's a factual finding, we cannot interfere. Let us see whether you have been held to
My
be a
lord,
Bharatiya.
Issue number 1 is the suit maintainable in its present form in law or not. The trial court's judgment, my lord. 1 and 2, my lord. Issue number 1 and 2, page number 5 of the internal page, my lord.
Yes.
At the bottom, my lord. These issues pertaining to the maintainability of the instant suit are taken up together for adjudication. The suit for eviction, recovery, khas possession, mean profit, and incidental reliefs from the facts enunciated in the plaint. It is crystal clear the plaintiff has a valid cause of action and prima facie case to proceed with the defendant. Plaintiff filed the suit within the time specified.
You did not press on these particular issues.
My lord.
During the course of argument, the advocate for defendant did not press on these particular issues.
Did not press the particular issues, my lord.
So what is the point taken that you were a ticket owner?
But point taken in the written statement, my lord,
did not press that point at the time of
my
hearing.
lord, kindly see issue number 3 and 3A in paragraph number 7 in the last line. Kindly
3
see.
and 3 is plaintiff is the plaintiff owner. Relationship of landlord
Yes,
tenant.
yes. And the kindly see page number 7, bottom, during the course of his cross-examination.
Yes.
On 22nd December 2008, he specifically admitted they are the Thika tenant in respect to suit property under the KMC.
He means?
He means, my lord, the
PW1 is
PW1.
continuing. Yes.
But that is clear, my lord. It came to the fore that the suit is not yet been mutated in the name of the records of the KMC. And my lord, the number of the suit property is B by 11 by 1 by H by 2. My lord.
H.
H.
So let us see how it is dealt with.
May I read for my lord?
Continue with how the court dealt with this.
My lord.
The admission is recorded then.
Yes, the defendant brought forward the assistant assessor collector. My lord, he was a defendant's witness number 2 on perusal of the cross-examination such and such. It appears that one Topeshwar Shah, father of the original plaintiff of the instant suit, it was recorded owner of the B by 11 by 1 by H by 2 Topsia Road. On the very day, DW2 specifically admitted KMC records the property taxes from the Topeshwar Shah in respect of the above mentioned property. This it is further pertinent to mention that during the cross-examination, DW2 certain documents were marked as exhibits on the part of the plaintiffs. On perusal and upon consideration of the documents marks at 5 to 7 series, and the fact mentioned that I am satisfied with the contention of the plaintiff regarding the right of the ownership of the suit property. But he is a Thika tenant only.
Thika tenant, even if he admits,
my lord,
in course of cross-examination, he admits that they are Thika tenants.
Yes, yes, my lord. So there's a dispute between the two, my lord. The
But
Bharati
the documentary evidence prevails over oral evidence even.
oral evidence and my lord, the documents of the KMC was there.
You admitted
It
that
was-
KMC collects property tax and all.
Yes, my lord. It is the in the exhibit number 7, my lord. It is the inspection book copy, the copy of the inspection book, which also says there is a Thika property. But it kindly see. It was exhibited. It is also said Thika tenant and on the next page. It's a long, my lord.
Where is it in Thika?
Thika tenant at the top, my lord. Thika tenant oblique owner. The column, my lord. The first column.
Mark that portion.
My lord. No, this the top shows of the plaintiff. Top man.
Oh, the that.
Yes, yes. Occupied Thika tenant.
The present second appeal will be heard on the following substantial question of law. Whether, comma, in view of the defendant stroke appellant being admittedly a Thika tenant, comma, the civil courts had jurisdiction to pass an eviction decree, comma, in view of the Thika controller being the appropriate authority to decide such issues in accordance with law. Your stay application?
Yes, my lord. 2675, my lord. 2675 stay of the operation of the my lord.
Any execution has been levied?
Yes, yes, execution, my lord, is proceeded with.
Can 2675 of 2020 is an application for stay of operation of the impugned judgment and decree? Full stop. Next para. Impugned judgment and decree. Stay of execution of all further proceedings of the connected execution case. Full
My lord,
stop.
title execution case number 9 of
There shall
2007.
be stay of all further proceedings in title execution case number 9 of 2017 pending before the learned civil judge bracket junior division second court at Shialda. This is South 24 Parganas.
Yes, ma'am.
District South 24 Parganas till disposal of the application. Full stop. It is made clear, comma, however, comma, that the question of imposition of occupation charges for occupying the property is kept open for being decided at the final hearing of the stay application by the appropriate bench. Full stop. Next para. The appellant shall serve copies of the present application on the respondents' opposite parties, indicating that the matter shall be listed before the appropriate bench in the appropriate learned single judge having determination in the monthly list of March 2025, subject to the convenience of the said bench.
Public.
Mr. De, we are directing affidavits also in the meantime. Affidavit in opposition, if any, shall be filed by February 14, 2025. Reply, if any, shall be filed on the returnable day.
Okay. My lord, I am appearing on behalf of the appellant, my lord.
আচ্ছা আগেরটা একটা ডিফেক্টিভ ছিল দেখছি দেখতে আগেরটা দেখি 1 সেকেন্ড এই আগেরটা যেটা হলো ফাইলটা কোথায় The defect shall be cured by the learned advocate for the appellant within a fortnight from date. ব্রতিনদের কি ওখানে ইয়ে আছে ফোন নাম্বার আছে দেখুন তো কোথাও অ্যাডভোকেট অন রেকর্ডে অ্যাপেলেন্টে যার নাম আছে ওই মেয়েটি ছিল, ওর ফোন নাম্বার আছে? একটু নোট করে রাখুন, ওকে ফোন করে জানিয়ে দেবেন যে আমরা ফোর্টনাইটের মধ্যে বললাম, ফোর্টনাইটের মধ্যে ডিফেক্ট কিওর করতে বলেছি, বুঝেছেন? ফোন করে জানিয়ে what is the defect in your matter?
My lord, there is a application for condonation of delay, my lord.
That is the defect, delay.
My lord.
Let us see if there is some other defect. Copy of the decree of the lower appellate court has not been filed.
My lord, we have, my instruction is we have filed, the advocate only got filed the court fee, deficit court fee as well as
Deficit
the.
court fee has been filed. Acha na. Name of the parties are found to be very. What is the matter?
My lord, it's a second appeal, my lord, and there's a delay of 14 days, my lord.
Oh, that. You're for the other side.
I'm for the respondent.
What is the reason for the delay?
My lord, to taking out the certified copy, my lord, the department.
Will be allowed. In view of sufficient cause for the delay having been shown, Can 2 of 2024 is allowed, comma, thereby condoning the delay in preferring SAT number 160 of 2024, full stop. No arrest to cost. Yes, move the appeal.
My lord, kindly may I prepare for and judges, my lord, and advocate on record is sick, my lord. He instruct me to appear, my lord. Kindly fix any day, my lord.
No, then you recall that order. We order together. We do it together. An adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day.
Your lordship, one thing, the section 5 application has not been served upon us. If your lordship will be hearing in the next date.
Acha, very well. An adjournment is sought on behalf of the appellant. Let the matter stand over till February 10, 2025, full stop. Sorry, February 5, 2025, full stop. A copy of the application for condonation of delay shall be served on the learned advocate for the respondent by tomorrow.
Good, your lordship.
Delay condemn করলে জীবনে order করতে মুক্ত হবে। Yes, please.
My lord, this is my appeal.
Has to admit it first against what?
My lord, the point has been raised. I have the respondent number 1 has filed order 39 rule 1 and 2 application that has been disposed of by granting an injunction. That order has been.
What is the suit for?
The suit for partition.
You are the defendant in the suit, obviously.
I am the defendant number 2.
What injunction has been granted?
The injunction has been granted not to alienate the property. But the point involved the schedule B, C, and D property. It's entirely of my property.
That will be decided in the suit.
That is a benami. They are considered that the property is a benami property of my father. No document, nothing has been filed. No document. Only 3 documents have been filed: trade license, death certificate, and trade license and death certificate. No document, nothing. The court has granted the injunction.
They claim by inheritance from the father.
No, but this is my property. The deed has been granted.
What is the relation between you and them?
We both are brother. Full blood brother.
So you say you have purchase of your own?
Own. Well, I have a deed. I have a document. All the transaction has been
deed
made
showing that it is purchased from a third party.
Yes, well, the purchase in my name from the third party. I have purchased. The deed schedule B, C, and D property is in my name. Absolutely in my name. And my lord, in respect of schedule A property, the separate suit has been filed. They have also prayed for the partition in this suit also. That is why the learned court below not granted any injunction in respect of schedule A property.
The schedule A property, they have filed a partition suit also.
Also.
Here the dispute your sale deed.
The sale, well, the sale did not. They are claiming that the partition may be granted in respect of B, C, and D. They are
no, B, C, and D. There must be a reason because they have only filed schedule A, the other suit also regarding schedule A. They have segregated schedule B, C, and D. Obviously, for some reason. What is the reason that they in this suit they must challenge your sale deed also, your ownership?
No, my lord, A, B, C, and D both are covered in this suit. My lord, the separate.
Oh, here also.
Correct, my lord. My lord, point involved.
And what is the other suit? They have filed the other suit.
They have filed the other suit. They have filed the other suit.
What is the relief claim?
Suit for partition. Well, kindly see the impugn order. The other brothers, my other brothers are also claiming that this is my property. They are also giving me a consent that it's my property. Only the plaintiff claiming that no, this is the property of my father.
You are Mr.
Well, I am the appellant. I am the brother.
Your name?
Mr. Shubham Gupta.
Mr. Gupta, we will definitely admit the appeal on these points, but it's very difficult to pass an order of stay of operation. That
let the
we'll admit the appeal immediately. and will direct you to serve a copy of the memo and the application. You have annexed all documents. Their opposition is also annexed in
There of affidavit, my
plaint,
written of plaint injunction application, my affidavit in opposition.
There is
If required, I will file also the affidavit which the other brothers have filed. They have given me a consent that is not annexed with the
no, if
application.
those are not part, those are not before
But-
the trial court, then we
But
cannot.
it is a part of the trial court, and
Trial
it has also mentioned in the order they have given me a consent that I am the absolute owner, and they do not want any partition in respect of my B, C, and D property. Only the plaintiff wants.
No discussion at all on that aspect.
That is the point. And my lord, no ad interim has been prayed for. After 6 years, they have moved the injunction application. Court said there is no prima facie case, but this is a partition suit. It is required to be granted an injunction.
What does it say? No prima facie case?
Perhaps my lord, it's subject to correction.
Let us see.
Hello.
No urgency.
No urgency. I beg your pardon. No urgency. Be that as it may, considering the above discussion, I do not find the urgency of the plaintiff, as he will suffer irreparable loss on refusal of his prayer for injunction. But it appeared that the plaintiff is able to make out his prima facie case, where convenience and inconvenience lies in his favor. Thus, for sake of the proper adjudication and the interest of natural justice, both parties are directed to maintain status quo. In
How does
respect
it
of,
deal with this, your contention that it was purchased from your property?
hello, man, nothing has been dealt with. Hello, I have a document that B, C, and D property is my name. I am the absolute owner.
You annex that with your
that I have annexed. I have annexed in the application.
The present appeal has been preferred against an order granting temporary injunction in a suit for partition filed by the plaintiff stroke respondent in respect of 4 properties, designated as schedules A, B, C, and D of the plaintiff. Who's the next para? Learned counsel. You're Mr. Gupta, you said.
Yes.
Learned counsel, Mr. Gupta, learned counsel for the appellant, submits that the learned trial judge committed a patent error of law in completely overlooking the title deeds produced by the defendant appellant, which go on to show that the properties designated as Schedule B, C, and D in the plaint were own and exclusive properties of the appellant, purchased by him by registered sale deeds from strangers. Next para, that apart, the learned trial judge, despite noting that there was no urgency, since the injunction application was moved after about 6 years from the first filing thereof, without there being any ad interim order subsisting at any stage, injunction was granted mechanically merely because it arose in connection with a partition suit. Full stop. The appeal is required to be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Full stop. In view of the limited scope of the appeal, the trial court records need not be called for the present. Full stop. Next para. The appellant shall serve copies of the memorandum of appeal as well as the connected application on the respondent. Which respondent?
The respondent, only one respondent. The respondent, only one respondent. The others are proper.
On the plaintiff respondent number 1, indicating that the appeal itself shall be placed for hearing in the combined list of cases for the month of February 2025. Full stop. Next para. The notice, the notice regarding the application and the memo as directed above shall be deemed to be a service of notice of the appeal as well. Full stop. In view of all the connected papers being annexed substantially to the injunction application, the appeal will be heard out on the basis of the memorandum and the injunction application and their annexures, which are already on record, without preparation of a formal paper book. Full stop. This much.
I'm grateful.
Come back, it will be in the monthly list of February.
I'm grateful.
But serve immediately as
will
early as
serve,
possible
I
so
will
that they
serve.
cannot take a plea that they.
I'm grateful.
Oh, Arakta line at the service of notice on the other respondents is dispensed with.
I'm grateful.
Well argued, Mr. Yes. Yes, Mr. Banerjee.
For my lord, I'm for the appellate.
Yes. That matter.
Lordship, my lord, remembers, my lord.
So whether beyond or how are you aggrieved? I mean, we don't
Yes,
find it.
my lord. The difficulty, my lord, I'll just indicate, my lord. My lord, kindly sees, my lord, the scope of remand, my lord, in that particular, my lord, order of remand, my lord, was very limited and very particular. The scope was very particular. Now, my lord, unless, my lord, that is being, my lord, made by the learned appellate court, my lord, while, my lord, considering the, my lord, the suit
The appellate court reiterated what was finally concluded
the
by
trial
the
court.
by the sorry, the other way around. The trial court after remand. So finally, I mean, reiterated whatever was held by the appeal court in
Yes.
remand. Finally concluded.
Yes. Now, my lord,
So what else was to be done?
however, my lord, I am aggrieved is, my lord, kindly considers, my lord, if the learned trial court, so far as the direction of the appellate court is, my lord, concerned, does not, my lord, comply to that, and my lord comes to a particular finding from whose share, my lord, the number of shares, my lord, that I am entitled to, and the number of shares, my lord, that or the quantum that I am entitled to, or the quantum, my lord, is the plaintiff entitled to. Like tomorrow, my lord, there would be, my lord, multiplicity of proceedings, and my lord, I'll be, my lord, my lord, I'll be in threat of facing a partition suit because I cannot go beyond the declaration.
No, you cannot.
I cannot go beyond the
The
declaration.
final degree.
So this, my lord, is the final decree. And my lord,
This is the remand was in connection with the preliminary degree of partition.
not partition suit at all. It's a, my lord, declaratory suit. It's a declaratory suit.
Declaration of the shares only.
Declaration of the shares.
An injunction.
An injunction. Now, my lord, kindly, my lord, I'll just, my lord, take your lordship once more, my lord, to the particular, my lord, comment of the appellate court and, my lord, the scope of remand once more, my lord. Lordship 164, my lord.
Yes. Yes.
Yes, my lord, I'll just.
Oh.
My lord, 166, my lord, kindly comes to, my lord, 166. From the beginning, from the top, my lord, reading. Once we hold that the plaintiffs did not receive fifth share in the property, as my lord has already been, my lord, held by the learned, my lord, this honorable court. It is the duty of the defendants, being the heirs of Swarup Bikash Sheth, to account for the assets dealt with him by virtue of succession certificate granted in his favor on the death of Sushil. Although the learned advocate for the parties argued considerably on the question whether original shares held by Sushil were really transferred in the name of Swarup Bikash, we find from the record that sufficient evidence had not been adduced at the time of hearing, so as to exact number of shares and securities held either in the name of Sushil or Swarup. And the learned trial judge did not come to a specific definite conclusion whether those shares were really transferred in the name of Swarup or are still appearing in the name of Sushil. Therefore, my lord, this adjudication was to be done, my lord, by the learned trial court.
The schedule does not describe the shares?
Yes, the schedule, my lord, says everything, my lord, that is that, my lord, is part of the extended succession certificate.
Are the shares not described in the names of their holders?
My lord, along with 8 more. The extended succession certificate at 42 number of shares.
And 8 more was never a contention before the appellate court also.
That is what, my lord, the schedule, that's apparent from the schedule of the plaintiff.
Yes, but apart from that, the rest, the names of the holders were not there, not a part of the extended certificate.
Yes, but
must
my lord,
have been.
Yes.
Those are in the name of Swarup.
Yes, but my lord, the learned appellate court specifically, my lord,
if it's an admitted question that those are in the name of Swarup, this is a redundant finding.
My lord, learned appellate court, my lord, specifically directs the learned trial court to come to this finding upon taking evidence.
If you did not give evidence, adduce evidence, none of you, then what happens? Then what is the scope
whether,
of
my lord, under the provisions of, my lord, order 43, my lord, 21, my lord, whether, my lord, this can be, my lord, termed as, my lord, whether the this order is itself maintainable, my lord, if it does not, my lord, follows the mandate of the appellate court. On an order of remand, if it does not follow the mandate of the learned appellate court, my lord,
the parties cannot take advantage if they don't adduce evidence, further evidence. Whatever was there, was there. So probably opportunity was given to you parties also to give adduce evidence.
Yes, in such a situation, we hold that the
yes
plaintiffs are
this is the
fifth, sixth, and, my lord, In this,
Parties are free to say next page.
in this proceeding, as the original shares could not be produced by either of the parties, indicating whether those have been really changed in the name of Swarup or not, we are of the view that the matter should be remanded back to the learned trial judge for the purpose of giving opportunity to the parties to lead further evidence on the aforesaid question.
Whether in the name of Swarup or not.
Yes, that was
Now, do both of you admit that all are in the name of Swarup? Mr. Banerjee, do you say all are in the name of Swarup?
Well,
Yes or no? If either not in yes or no, then we'll hear you later.
Lord, all are in the name of Swarup.
Take your
Answer
seat,
is, and Lord, the
We'll hear you
subsequent
later on,
in
Miss.
the name of Swarup.
We'll hear you
Lord,
later
these
on.
are all, because all are in the name of the Sushil, not Swarup. Sushil.
All are in the name of Sushil.
Name of Sushil.
None is in the name of Swarup.
None is in the name of Swarup. Now, in the name of Swarup, they are exhibit 22 to 31. Lord, they are.
We'll hear you on the minutes.
Lord,
Please,
they are
please take your seat, Mr. Banerjee. Yes. Complete.
My lord, as such, my lord, this was the specific, my lord, point of remand, my lord. Whether, my lord, the
What is your stand? Those are in the name of whom?
these,
The
my lord,
shares?
my lord, all the schedules in the plaint, most of this has come, my lord, from Sushil.
Look at the shares, will show the name of their holders.
Most of this, my lord, at this very moment, my lord, they are in the name of Swarup.
All.
Certainly, my lord,
No.
kindly, my lord, considers. My lord, kindly considers the schedule of the plaint, my lord, once. Then
We don't still find the necessity of this observation of the remand court. I mean, what was the necessity of adducing further evidence?
my lord, until and unless, my lord, it is segregated, which are, my lord, procured in the name of, my lord,
That
which
was
are-
not the purpose. The purpose was remanded back to the for the purpose of continuing what aforesaid, whether those have been really been changed in the name of Swarup Vikas.
Swarup Vikas.
So court has to see whether those have been changed in the name of Swarup Vikas or not.
No, the learned, my lord, this honorable court, my lord, while observing this, my lord, considers, my lord, that the origin
Previous page also, whether those were transferred in the name of Swarup.
Swarup, the original shares. The original shares. Now, my lord, after the
What is the plain schedule? Show us there.
page 25, it starts.
You are claiming to Swarup.
No, Swarup. I am the legal heirs of, my lord, I am the wife and the daughter of Swarup.
But whatever way it goes, I mean, the shares have been decided now.
So far as shares have been decided. Shares, my lord, kindly considers this aspect, my lord, shares. Now, my
in
lord,
the
this
shares.
needs to be segregated.
Shares in the shares have been decided.
Yes. Now, my lord, it needs to be, unless and until it's segregated, my lord, as of today, my lord, the difficulty, my lord, I'll just indicate. As of today, none of the parties can touch the shares. It's still lying in the exact, my lord, situation.
So why didn't you adduce evidence by calling the companies? You had to do so then.
Both
You
the
are
parties,
agreed.
both the parties.
They did not, they're not even challenging in appeal. They sit tightly over that. If you did not ask for summon the companies, then you are to suffer the consequences. You cannot prefer an appeal and say, I did not adduce evidence as per the remand court's order, but I take advantage of that. You are also free to produce. They don't challenge the appeal.
My lord,
They
kindly
challenge the
considers
judgment.
only one aspect, my lord. The learned trial judge, my lord, was given a mandate. Whether, my lord,
Mandate, you are also given a mandate. You are given liberty to adduce evidence. Only if you adduce that evidence, trial judge could go otherwise. The order clearly says that liberty is given. Trial court summer probably held that none of you adduced evidence. Was it held anywhere?
Yes.
Then what else could be done? And page 174 it says exhibits 22 to 31 show that Swarup Vikas said during his lifetime purchased a big number of new shares.
Lordship, is that page?
Sorry, page 174. Internal page 30 of the trial court.
Right. 174, my lord, is all the.
Let us start from internal page 29 of the trial court.
Yes.
Page 174, sorry,
That is
174 CC. Page 29. Please read from the second paragraph of that page, 29, internal page 29.
In this case,
yes.
In this case, no oral testimony has been filed by the defendants to show
You are the defendant.
I'm the defendant.
Yes.
In this case, no oral testimony has been filed by the defendants to show that Swarup Vikas had purchased the share and securities from his personal fund. Exhibit A does not help defense at all. All the documents of the plaintiffs are more than 30 years old. Exhibit 1 to 30 supports the plaintiff's case very much and corroborate the plaintiff case. From those documents and evidence of PW1 and 2, it is to be found that Swarup Vikas did not purchase those shares, etc., from his income. It is found clearly that he purchased those shares and dividends, etc., from the income of the estate.
So this presupposes that he purchased the shares in those are in his names.
His name.
One and this 1 to 32.
1 to 32. The evidence of PW1 is genuine and trustworthy.
No, Exhibit 6 and 7 support the plaintiff case. 30 and 31 show the total purchase. So 30 and 31 show the total purchase of Swarup share. What are 30 and 31? The exhibits have been mentioned anywhere. Let us see.
30 and 31.
Exhibit list is a part of the paper book.
Yes, yes. His lordship is
you find that
30 and 31 lordship, the second volume. Second volume, page 1215.
Second volume.
And
Uti. What? Which page?
30 is 1215. So 1225, 15, 1215.
Swarup Vikas Seth. Yes. Everything in the name of Swarup Vikas Seth.
As well as the dividend of the year, so in the name of Swarup Vikas Seth. And 131 is 1223. It's also in the name of Swarup Vikas Seth.
You find all in the name of Swarup Vikas Seth. And that appears from the trial court's findings also. Trial court finds that it's in the name of Swarup Vikas. So 1 to 31 and this 1 to 31 covers everything actually.
All the shares and dividends, my lord, everything, my lord, that is my lord, part of the schedule.
So from page 29 and 30, it is clear that 1 to 31 are in the name of Swarup.
Swarup Vikas Seth.
So that was the direction of the trial court. You had to produce, summon the companies and show in whose name they are standing. But the shares themselves show that they are in the name of Swarup.
But even my lord, my lord, I had not adduced any, my lord, further evidence. My lord, the trial court had my lord had an obligation rather than, my lord,
trial court will show more to call the companies.
No, certainly not, my lord. But rather than,
Do
my
what?
lord, declaring the share,
direct that 3 lashes will be given to the defendant for not calling the witness, or the defendant should be hanged for not calling the witness. That could be the only other procedure. You could be compelled to call those companies. It's like going to the court and say that the trial court wrongly did not punish me.
but only considers the
If you want punishment, we can dismiss the appeal. That is your sufficient.
No. Kindly consider, my lord. Only, my lord, the only, my lord, my humble submission to, my lord, this order of remand, my lord.
Kept this pending for so long. You were not even an advocate probably when this was filed. Or?
No. It was filed in way back in 2008. I was in.
No, you are not. You are an advocate.
Still, my lord, in my school.
Oh, in school. That's very well. All right. To understand your grievance, Mr. Gandhi.
Well, it's very specific, my lord. I have taken instruction on this, my lord. So far as, my lord, segregation was the only thing, my lord, for which it was to be remanded back. Otherwise, my lord,
if the parties don't lead evidence, then what can be done in terms of the what is the fault of the trial?
Share is already declared. I have not, my lord, preferred an appeal against that, my lord, order of this honorable court. I have accepted that. It has, my lord, gone back, my lord, to the learned trial court. But the learned trial court, only thing left, my lord, for the learned trial court was to segregate it. And, my lord,
segregate means what do you mean?
Come to a my lord,
which shares are in whose name?
Yes, and come to a quantum. My lord, if at all, my lord,
quantum, there is no direction of quantum.
Yes,
there is no direction.
Because the learned appeal court, my lord.
Appeal court nowhere says that.
Learned appeal court, my lord, at my lord, one point holds that whether, my lord, Swarup Vikas Seth was, my lord, at all entitled, my lord, the legal heirs of Swarup Vikas Seth, my lord, they were entitled, my lord, to pay the
two findings on which the remand is based, page 160, as you rightly pointed out, 166 and 167 as well as 168 will also go. 166, second paragraph says that although learned advocate for the parties argued considerably the question whether original shares held by Sushil were really transferred in the name of Swarup, we find from the record that sufficient evidence has not been adduced at the time of hearing as to exact number of shares and securities held either in the name of Sushil or Swarup. And the learned trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Swarup or are still appearing in the name of Sushil. So no evidence, no conclusion. Next page, appellate court says, then declares 5, 6 and all. And then page 167, in this proceeding, as the original shares could not be produced by either of the parties, indicating whether those have been really changed in the name of Swarup Seth or not, we are of the view that the matter should be remanded back to the trial judge for purpose of why? Not for doing something, for giving opportunity to the parties to lead further evidence. The trial judge was only to give you opportunity to both the parties to lead evidence. That was the mandate of the appellate court, not to do something. It was not. And next paragraph supplements that parties are free to summon the concerned company. The appeal court also shows you how to do it. Just stop short of calling the companies itself. Free to summon the concerned companies where the shares are lying for the purpose of showing the strength of the disputed shares stands today, appears to the court on the such and such, that original shares Sushila still continue in his name, such and such.
Now, my lord, kindly, my lord, come
Now,
to the
that if does not come in because you are free to summon. The trial court was to give you opportunity to do that.
kindly,
Did
my
not
lord,
do that.
comes to the next paragraph, my lord.
Yes, read it.
If it appears that any new share was purchased in the name of Swarup Bikash and the same is not in continuation of the original one standing in the name of Sushil, nor is such a share a bonus share or a right issue arising out of the share standing in the name of Sushil, nor was such share even purchased at a premium on the basis of the benefit conferred on the share standing in the name of Sushil, the plaintiff will not have any right in those shares.
But this, if it appears that any new share, this if it appears is qualified by the previous paragraphs.
Yes.
If it appears after you leading those evidence, only then. Definitely, yes.
Therefore, my lord,
But however, the plaintiffs will be entitled to get 5/6 share of the amount of money already realized by
already
Swarup.
realized by Swarup. That's why
If you don't adduce evidence, Mr. Banerjee, nothing can be done.
That's why, my lord, quantum of money, my lord, I'm talking about, my lord.
So
The
what
plaintiff
can
will
be
be
done?
entitled to get 5/6, my lord, of the amount already realized.
You don't adduce evidence, then nothing can be done. You frustrated the remand order. Because it's your case, 5/6 share has been declared already. This opening was given not to them, but to you. Yes, you are right. If it appears that any new share was purchased in the name of Swarup Bikash Seth, how will the court find it if you don't?
That is why the segregation and, my lord, the quantification.
But that is only if new share was purchased.
After I lead I'm getting, my lord, what is falling from your lordship.
The trial court, what does the trial court say on that? Page 30.
The difficulty is, my lord, the trial court doesn't even say that you do not lead evidence, I cannot.
Exhibits 22 to 31 show that the said Swarup Bikash Seth during his lifetime purchase. Now this appeal court's finding that if it appears that, take page 167 along with 174 DD. Appeal court says if it appears that any new share was purchased in the name of Swarup and same was not in the continuation of the original one, then bonus right issue arising out of shares and such and such. So if Sushil, you had to show that Sushil had purchased new shares, not in continuation of the original one.
Original shares.
But the previous ones that has already, original shares have already been dealt with. So these new shares do not refer to the original shares. Original shares are the subject matter of the suit, right? So if new shares, this was an extra avenue given.
New shares which are not in continuation of the original and not out of the dividend of those.
If new shares are coming.
If.
Original shares, subject matter of the suit, the schedule is original shares. 5616 declared in the original shares. Court gave evidence just to show whether those have been transferred in the name of Swarup, which it appears from the trial court's finding, it was from the exhibits themselves, it is seen that those stand in the name of Swarup. Despite that, so that is the best thing you could have in the name of Swarup. If it was found in the name of Sushil, then it automatically goes. So your best case could be it was in the name of Swarup, but that has been taken care of by the appeal court regarding the original shares. Even if it's the name of Swarup, 5616, that goes. This is in addition to that, if it appears that in a new share, apart from the original shares, what was purchased, not a single iota of evidence is there that any new share was purchased apart from those original shares. You are to lead evidence on that. You are Swarup shares. You claim to Swarup. No new shares have come in also. So there is no scope of any order on that.
Well, the schedule of the plaint and the
those are the original shares.
Schedule of the plaint and from the extended succession certificate from where they have to, from where their claim arises. Their claim, my lord, arises from the fact that the extended succession certificate, which I, my lord, from where I procured the benefits, those were, my lord, moved ex parte without, my lord, their knowledge, and in suppressing the fact that I have already given up my rights in those shares. In, my lord, the extended.
You had given up your right.
Yes, certainly. So, my lord, therefore, my lord, the extended succession certificate and, my lord, the plaint of the schedule of the plaint, my lord.
Extended succession certificate is the origin, is not the original share. You're saying those are new shares.
No, those are, my lord, purchased by Sushil.
Original
According
shares.
to them.
Yes.
According to them, the original shares.
Extended share certificate is the subject matter of the suit, which are again the original shares.
My lord, along with some more, a few more. What am I, lord?
Few more have not been dealt with anywhere. It's a new point you are taking for the first time in appeal against judgment passed after remand. So you never took this point before the trial judge in the first instance, not before the appellate court file in remand, nor before the trial judge at any point. For the first time, Mr. Dutiman Banerjee is arguing this before the High Court in this appeal.
My lord, it's apparent, my lord, from the schedule of the plaint. My lord, both the schedules are before your lord.
You cannot help that.
And my lord, and my lord, finally, my lord, if my lord, even if my lord, considering the fact, my lord, I did not read any evidence. My lord, whether my lord, any act, my lord, if there's specific my lord, point of remand involved, if the learned trial court, my lord, does not deal with those points of remand, whether my lord, that can be, my lord, called a, that judgment, my lord, is at all maintainable in provisions of my lord order for.
Yes, yes. Opportunity was given to you to read evidence, you did not give. So he reiterated whatever was. Remand does not mean he has to pass a degree in a particular way. Anyway, you have heard of Mr. Banerjee? Anything else?
Yes,
because we will be repeating after. We'll hear Mr. Banerjee immediately after the recess. Then we'll continue with this short arguments of you, as you said.
Everything is clear.
Huh.
1516.
Yes, Mr. Rani.
It's only my lord, a single thing, my lord. But I'll just refer to a judgment, my lord. My lord, the copy of the judgment, my lord, I have, my lord, getting in print, my lord. Petition is, my lord, I'll just. This is, my lord, 2023, volume 13, SCC 1. I'll just, my lord, get the copy.
2013 SCC, 3 SCC?
2023,
Oh, 20
13 SCC, page 1.
Right.
But only on the scope of remand, my lord, I'll just, my lord, paragraph number 13 I'm placing. Before proceeding with the matter further, we may think it appropriate to reconsider the impact of such an order of remand, as it would certainly deconvolute consideration of the appeal. There can be no doubt with respect to the settled position that the court to which the case is remanded has to comply with the order of remand, and acting contrary to the order of remand is contrary to law. In other words, an order of remand has to be followed in its true spirit. That is it, my lord. True spirit is the word, my lord, I'm, my lord, relying on. Therefore, my lord, whether that may depend on my leading evidence, may not depend on my evidence, but the court has to, my lord, come to a finding on its own. Grateful.
Yes, Mr. Rani.
Lord, first of all, it is not contrary to remand, in conformity with the order of remand. Lord, second, Lord, if your lordship kindly come to at page 239.
Yes.
Lord, 370. Lord, application to page 239. Here, my lord, and relevant at page 244, my lord. 244 schedule. Lord, A, B, C,
This is
D.
application for extension of success.
No, application for having a succession certificate.
Original one.
Original one. Page 244.
Yes.
Lord, their admission is 16 shares of the following shares.
Yes.
A, B, C, D. Lord, these are the schedules. E. A, B, C, D, E. Lord, they are taking adjournments. Therefore, Lord, we said very well. With regard to A, B, let there be a consent. Order be passed.
Where is ABCD? We don't find.
C, D, and
Where are the schedule numbers? Oh, A, achha, small a.
yes. All A, B.
All right. Where does B start? D, we can find. C. B is probably page 254, yes. Very well. So they admit in 1/6 share in all the schedules.
But my lord, in order to avoid Lord trial of the Lord case, we admitted. Let there be a consent with regard to AB.
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 All right.
Lord AB. Now, Lord, AB certificate given in favor of Sarup. That does not mean he is
AB
entitled-
certificate means 1/6 shares, they said.
1/6 share.
So 1/6 should be given to them.
Yes, 1/6 would be given to them, and 5/6.
1/6 of AB were given to them.
1/6 AB was given to them, and 5/6 AB was given to ourselves.
Right.
On consent. Lord, now, Lord, your lordship knows if the consent order is deviated, then Lord, another consent is required. Otherwise, fraud, undue influence, all these things are required to be stated. Otherwise, consent order will be binding on them. Now, Lord, what they did, after 20 years, they file an application for extended succession certificate in respect of AB.
They claim the entire share of AB.
This is application.
That was granted. You filed the suit for declaration
Then
that
I
regarding
filed-
AB, we have
I
fixed.
filed an application, my lord, for setting aside revocation, but my lord, question of revocation of
Revocation was refused because that's a question of title.
question of title, and secondly, my lord,
Yes.
Succession Act does not permit for revocation like section
Like probate, no.
263.
Yes, 263.
Like
not-
section 263.
Very good. So then
Therefore,
we
my
filed a
lord,
suit, sought for your 5-6 declaration,
Lordship.
and that has been granted. Against that, they preferred appeal or refused and you preferred appeal.
No, my suit was dismissed.
Dismissed why?
Dismissed, not on the flimsy grounds, my lord, perverse finding.
Anyway, finally it went up to appeal and appeal court remanded on the judgment which you already
Yes,
saw.
now, my lord, your lordship kindly come to the order of remand.
Hmm.
Only the relevant part.
Yes.
Lord, page 164 towards the bottom.
Right.
Therefore, the findings of the learned trial judge that 5/6 share of the plaintiff realized by Swarup was paid by granting a receipt. Lord, that was the reason for which, Lord, my suit was dismissed. This was disbelieved in appeal. This is a perverse finding. Refused by Swarup, paid by granting receipt is a perverse finding of fact. Lord, because your lordship query was why it was dismissed. Lord, because of that. Lord, then your lordship kindly come to at page 165. The fact that such share was not given to the plaintiff would appear also from the conduct of the defendant. It appears after the death of her husband, she applied for fresh succession certificate for receiving the dates and securities standing in his name. In that application, the schedule A and B were the shares and securities which are subject matter of the present suit. In the said application, she specifically claimed 1/6 share in respect of A and B schedule. Lord, because of that admission in that, so far as schedule C and D, E are concerned, she claimed to be the full owner along with his daughter. In the way of objection raised by the plaintiff, she abandoned her claim in the share and securities mentioned in schedule A and B and was satisfied with items mentioned in C, D, and E.
C, D, and E, her claim on their claim was granted.
16.5.
Full share.
Yes, but his claim was 1/6.
ABC admitted 1/6. You agreed?
Yes,
That was
I
granted.
agreed.
Yes.
Therefore, that is why Lord, this
Right,
finding was
right.
recorded. Was
After
that
20 years, they tried to reopen by seeking an extension of certificate.
without giving any notice, without making me as a party.
Achha.
Therefore, we filed a suit, not only that part, the extended succession certificate is a nullity fraud without giving any notice. That was my case.
Yes, yes.
Yes. Now, Lord, your lordship, then kindly come to. It is now settled law, now towards the bottom, page 165.
Found it, yes. We're ready to.
Now settled law that mere grant of succession certificate in favor of co-sharer does not vest such co-sharer with the title of the property and at the duty of the certificate to distribute the assets of the heir in accordance with their shares. Then, my lord, your lordship, page 166. Although the learned advocate for the parties argued considerably on the question whether original shares held by Sushil were really transferred in the name of Parupika said, we find from the record sufficient evidence has not been adduced at the time of hearing as to exact number of shares and securities held either in the name of Sushil or Swarup. And the trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Swarup Vikas Seth or are still appearing in the name of Sushil. Even the actual amount of money realized by Swarup by virtue of succession certificate is not brought to the notice of the court. Now, Lord, for this, my Lord, they did not, Lord, adduce any evidence. We submitted further examination in chief after remand, showing that the further certificate exhibit 21 to 32, barring 2-3 documents, were purchased by Sushil from the or purchased by Sushil, that was in the name of, because those amounts, dividend and the shares, those have from the schedule A and B, those have come from the bank account. It appears we submitted the bank account because he purchased through the broker. We submitted the broker's document for purchasing that, and the purchase money is coming out in continuation of the earlier shares from the dividend. And my lord, only LIC policy, my lord, is there that has been encashed by him in his own name. But
Mr. Banerjee, there's a finding in the remand order also, page 166, second paragraph. Even the actual amount of money realized by Swarup by virtue of succession certificate is not brought to the notice of
that
you would have to do.
That from the bank account, my lord, it shows. Everything has come in a bank account.
Those have been exhibited?
Those have been exhibited.
After remand, you exhibited
After
those?
remand, exhibited.
You remanded, you exhibited those after remand?
Exhibited those documents.
What are the exhibit numbers? Can you tell?
Yes, my lord, exhibit numbers, my lord.
The trial court must have considered that. We'll look into that.
Yes. Trial court, my lord, absolutely consider all those exhibited documents.
We'll go into that. Let us complete this.
Then, my lord. Therefore, this is the purpose for remand.
Yes.
Because, my lord, lordship knows, my lord, remand order is conferred under Order 41, Rule 23 and 24.
25.
Now, lord, if materials are available before the appellate court, then appellate court cannot remand it.
No.
Only in a case where materials are further required.
No, appellate court held.
Yes,
You have
yes.
held.
Lord,
Did not
then kindly come to page 167.
spend time on that also.
Yes. Page 167. These are the questions, my lord.
Good question was whether the shares were transferred in the name of Swarup.
Yes.
So what
Now,
was
my lord,
found out? Those were transferred in the name of Swarup.
Now, my lord, I am coming to that straightway, my lord. Then, my lord, page 168, towards the middle.
Yes.
The learned judge will further grant interest in favor of the plaintiff over 5-6 years Sushil that will be found to be due from the date of realization of the amount by Swarup Vikatse till date of actual payment at the rate of fixed by him. Now, Lord, with regard to A and B, Lord, declaration has already been given 1-6 and 5-6. Now, Lord, I need not re-argue with regard to that. Now, Lord, why finding is required? Because some certificates, Lordship, kindly come to page Lord, paper book 2, my lord.
Yes.
Lord, exhibit 23. Lord, first page, exhibit 23, rent collection.
Page?
Page 20, page 642 of the part 2 paper.
First page.
Yes. Lord, 4 books containing counterparts of paying slip showing deposit of cash.
These were exhibited after remand?
After remand.
Exhibit 23 onwards?
Lordship. Lord, these are the documents after remand. Our lawyer thought that when admission is there between the parties in terms of section 58, therefore I need not produce those. Only after the remand, my lord, this document we have produced. Then, my lord, lordship, from the bank account, we exhibited the bank account. 6 counterpart books of pay-in slip showing deposit of checks. 8 counterpart books of checks, chartered bank, which were issued. Lord, these are the checks issued on account of dividend.
Yes.
Not of the share.
Right.
Lord,
AB shares.
Yes. In continuation of the original shares.
All right.
Then, my lord, 26, a statement of account issued by the chartered bank. Then, my lord, 2 building containing 2 bundles containing 16 of relevant counterpart of pay-in slips. Lord, checks, not at the dividend. 2 passbooks of the United Bank of India and Swarup Vikas. And then, my lord, 8 counterfoils of dividend confirmation letters of various companies. Lord, dividend which has been, my lord, thrown into a
Understood.
account.
From AB,
Confirmation has been given by the company.
Yes, Mr. Vani. What next?
75 of purchase bills and acquisition letters.
We have,
of
se-
various companies.
we have seen all this. And the last one is income tax assessment to show that Swarup did not have any substantial income of his own.
Only 10,000.
Very well.
No. Then, my lord, there was the income tax, my lord, because the state duty, under the state duty, once the certificate is obtained, Lord, you obtain a certificate, your lordship kindly come to
Yes.
page 235 and 236 of the paper book. Lord, later of the LIC, given to Swarup Vikas. Lord, LIC stands in the name of Sushil. He obtained a succession certificate. Lord, on the basis of that, my lord, it was given in the name of Swarup Vikas. Then, my lord, 28/1/1967, it came 7,824. Then, my lord, your lordship.
But LIC policy was also subject matter of that obvious suit.
No, that was also part of A, Schedule A. LIC policy and company shares. LIC policy and company shares.
So it's evident that it was taken by Swarup.
Yes.
And the appeal court's finding is that nothing was given paid to you.
Lordship, I shall show that. I conclude with
We shall show you that. Page 167, 166, 7 and 8.
Yes.
There are 3 pages,
Yes.
specific findings. 166, a remand court says, we hold that the plaintiffs are entitled to get 5/6 share of money already realized by Swarup Shet by virtue of succession certificate granted in his favor, as nothing has been paid to them. And page 167, it is held. It appears that if any new share is purchased, your share is declared there also. And court also holds, we have decided the issue as regards share of plaintiffs in Sushil's property to the extent of 5/6, as we further hold that neither Swarup Vikas nor his legal heirs have paid anything to the plaintiffs after realization of the amount, if any.
Yes.
So it was remanded to see what amount was realized by Swarup from those shares, and if the transfer of names could be substantiated. Regarding transfer of names, is it an admitted position that all the shares now stand in the name of Swarup?
All shares are there. Not only the dividend, company dividend is given.
No, Mr. Banerjee, one of the other points of remand was that both of you may call the companies also, and you may adduce evidence on parties are free to summon the concerned companies where those shares are lying for the purpose of showing the strength of the disputed share as it stands today, and whether it stands in the name of Sushil or Swarup. Now,
Lord,
you did not also have
now,
this.
Lord, with regard to that part, my lord, it was in the name of Swarup. They admitted at the time of, my lord.
So why was this part remand court? Nobody pointed out to the appellate court that nothing is standing. So nothing is standing in the name of Sushil as of today.
Nothing stands in the name of Swarup.
Everything is standing in the name of Swarup.
No, everything stands in the name of Sushil.
So no evidence was laid on that. That liberty was given.
That evidence was laid by me, my lord, after the demand.
Where is
and
that?
No cross-examination. I shall come back.
So was that because that remains only?
Yes. Lord, only this part, 235, then 236.
Yes. 236, yes.
Lord, reflection in the account.
Yes, yes.
Lord, he collected rent and he collected, my lord, tax, municipal tax from the tenants, respective tenants. Now, my lord, all those amounts came here, and then, my lord, dividend came here, came to his account. From the dividend collection of rents, Lord, he purchased new shares in his own name.
Rent and all those were also part of the suit schedule.
Yes. Now it is in continuation of the Lord earlier shares, not earlier shares in the name of Sushil.
Always.
whether it is in continuation or it is not in continuation. There was no new shares purchased by the defendant.
So this is in consonance with the latter portion, page 168, first paragraph, last sentence of the appeal court. Page 168, the parties will also be entitled to lead further evidence on the question as to the amount of money actually realized by Swarup by virtue of succession certificate granted in his favor.
Yes, yes.
So by virtue of that succession, how much money he has actually realized, which you are saying regarding rent,
That will show from
LIC.
yes,
So those evidence have led.
yes, that will show Lord, from the accounts itself.
So that part two of the remand order was satisfied by the trial court. You adduced evidence, trial court held.
Yes.
And what about the change of name? We don't find any reflection of that in the
Change of
trial.
name because the certificate, your lordship, kindly come to volume 2 paper book.
Page.
Lord, page 1227 to 1269. Lord, first of all, page 1215 to 1226, dividend from different companies is out of the existing shares of the company.
No,
In
what
the
about
name
the
of-
change of name?
In the name of Lord Sushil.
Where do we find that?
Lord, that your lordship.
Companies
will
were never
find.
called by you.
Kindly come to 1215.
We are there, 1215.
Lordship. Lord, before that, your lordship kindly come to the dividend has come in the bank statements.
No, whether the shares have been transferred in the name of Swarup or remain in the name
No,
of
not
Sushil.
share was transferred, dividend.
Appeal court says otherwise. Appeal court says
Yes, share was also transferred.
whether if it appears to the court on the basis of say that original shares of Sushil are still continuing in his name. And originals in this proceeding, the original shares could not be produced by either of the parties, indicating whether they are standing in the name of Swarup or Sushil.
Because, my lord, the question was whether it is in the name of whether
Sushil or Swarup.
purchased or not.
No,
In the shares.
the appellate court clearly says whether those shares are today standing in the name of Sushil or Swarup. You
Lord,
can call the companies to
For
prove
that,
that.
after the my lord, remand order
What
was
is the
given,
proof of the evidence on that?
we submitted evidence. Lord,
What
your
evidence?
lordship kindly come to the evidence part.
Show us that.
Yes.
We are asking for that only.
Yes.
Regarding the change of name.
Yes.
Whether the shares are still standing in the name of Sushil or have come in the name of Swarup.
Not see. Kindly come to that page, my lord. Evidence. Yes, my lord, page 73, my lord.
Page?
Page 73.
73.
Yes. After remand.
Yes.
Lord, paragraph 2.
Yes, 2.
Lord, we specifically said it was in the name of Sushil.
What have you said? Does it say anything about whose name it is standing on?
Then paragraph 3. Lord, they did not. Various shares and securities must schedule A in the standing in the name of A, B standing in the name of Sushil. No dispute with regard to that. Those documents were marked exhibit.
Unless there was a dispute, how could the remand court say, appellate court say that the court is to ascertain you have to lead evidence on in whose name shares are standing?
That is why, my lord, in support of that, my lord, that document was marked exhibit with regard to his application.
What application?
Application for succession certificate. There he admitted it. And it was marked exhibit. And in support of that,
He
my lord,
admitted 1/6 share, that he has 1/6 share.
in the name of
But in whose name the shares
in
are
the name
standing?
of Sushil. according to his application, my lord, in the name of Sushil. His whole case is Sushil. Property belonging to Sushil. Then, my lord, paragraph 3. Paragraph 4, my lord. Lord, here a specific name is given, Sushil. Municipal tax, succession certificate having obtained the defendant's predecessor and title, Farooq Vikas Seth, who was also my elder brother.
No, see para 4, page
Para 4.
75.
Yes.
Para 4 continues. You have stated subsequently transferred those shares and securities, including the amount of such money, in his personal name.
Yes. And in support of that, my lord, the bank account.
Banerjee, in your evidence, para 4, continuing at page 75. The second sentence, please come to page 75.
Yes. He also used to collect dividend.
He means Swarup.
As well as sale proceeds of various shares and securities of different companies, which were originally standing in the name of Father Sushil, since deceased, subsequently transferred those shares and securities, including amount of such money, in his personal name.
So therefore, you have alleged that Swarup transferred the name in his personal name.
That's right. That is why, my lord.
You are all along arguing that it is still standing in the name of Sushil, all the shares. That was your answer. At least 6 times we asked you. But your own witness says he subsequently transferred those shares, including the amount of money in his personal name.
Yes, yes, my lord.
So which portion was transferred, which was not? The same thing must have been argued before the appellate court also.
That was specifically which portion was transferred. That was specifically in Exhibit 21 to 32, barring 2-3 numbers.
So where do you prove those documents in your evidence?
Yes,
Let us see
kindly
that
come
portion
to
of the evidence.
Lord, then your lordship kindly skip over. Then paragraph 5. Paragraph 5.
These are there, you have already shown us. Counterfoils and all he has been collecting, and appeal court has said that whatever money is collected, it is that you have proved that he has been collecting money, and you have 5-6 share in that. We don't have any doubt on that part.
Yes, paragraph then 8. Kindly page 7.
We are focusing, Mr. Banerjee, only on there are 2 aspects of the remand. One is that if monies have been collected by Sushil, Swarup, those also has to be distributed in 5-6 and 1-6 share. You say you have produced several documents, including those LIC certificate, rent receipt, whatever, to show that he has collected money. So that portion you have taken care of. Regarding the other portion, which portion of the shares still stand in the name of Sushil, and which portion of those now has been transferred to the name of Swarup? That was to be proved by calling the companies as witness. You have not called the companies, none of you.
Practically, Lord, there is no shares.
This practically won't do because your paragraph 4 of your PW1 says.
Yes.
You say
Yes,
that
on
they
the
has been
basis of
transferred.
Paragraph 4, my lord, says that the entire share.
Not
was
entire.
transferred.
You are vague on that also. Paragraph 4 says entire word is not used, but yes. You say that other receiver as well as sale proceeds of various shares and securities of different companies, which were originally standing in the name of Father Sushil, and subsequently those shares, apparently all. So all along you have been arguing still everything is standing in the name of Sushil, but we have been asking you the question, no, it should be standing in the name of Swarup. Your witness says all has been transferred in the name of Swarup.
That is the original, in continuation of the original. That is our case.
In continuation, not whether the shares have been transferred. That was the limited
Yes,
scope of remand.
yes, that was the
So everything now stands in the name of Swarup.
Swarup.
So you did not call any company. How do we know that your statement is correct?
No, because, my lord, the company certificate, Lord, extended succession certificate also in the schedule.
Extended certificate was there much before the suit even. Appeal court remands the matter.
Before the suit. The extended certificate, my lord, with regard to AB, in the name of Lord Sushil.
There is no doubt on that, Mr.
And
Banerjee.
he has no other.
There is no. We are coming back to the same point.
Now,
again.
Lord, your lordship
Succession certificate is history.
Yes.
Succession certificates all in the name of Sushil. No doubt on that. Thereafter, much water passed through the Ganges. 20 years spent. They come up with this extended succession certificate. They get extended certificate in their name A and B. You come up with a suit. In that suit, you claim 5616.
Now, Lord,
That has been directed. Now, when the matter came up, initially dismissed your suit. When it came up to the appellate court says yes, 5616. But those shares and the money derived therefrom has to be ascertained. On this, we are remanding. Now, regarding the monies collected, you have apparently adduced evidence, LIC dividend and all dividend regarding those. That much we can understand. But which portion of your witness comes and says all the shares have been transferred to Sharup? If all the shares have been transferred to Sharup, then why does the LIC dividend and all, the dividend of that company and all refer to Sushil? This is Sushil, then etc.
No, before transferring.
We want to see your evidence on which shares are standing in the name of Sharup, which are in the name of Sushil still.
Yes, Lordship, kindly come to this. Lord, paragraph 9. Page 79, madam. Because checks were issued. Lord, here we said paragraph 10. Yes, Chartered Bank having its branch office in relation to account number showing the relevant transaction made during the period 7/11/64 to 21/6/71 by my elder brother Swarup Vikas said from these documents of accounts, it is evident various transactions of estate of Sushil Kumar Seth were made showing purchase of shares, sale of shares, collection of LIC, maturity money, etc. These statements are issued by the Chartered Bank of India in usual course of the official business. And those are duly and signed by the competent officer. These are the statement of accounts which are more than 30 years, collectively Exhibit 26. Lord, the amount, whatever money, my Lord, in the name of Sushil, Lord, that has come.
So Banerjee, there is no doubt on that. We clarified twice to you. There are two components of remand. One is that whatever money has been extracted by Sharup from the estate of Sushil, that has to be ascertained, for which you say these evidence were laid by you. The other component is in whose name the shares are standing today. Your witness
that's
says
right.
all the years have come to the name of Sharup. What is the proof on that?
I shall, yes, proof on that.
Only we are wanting to see that. Please come to that first. All these are regarding the money. All these are regarding money. That Sushil says
shares have been transferred. All those shares have been transferred. Paragraph 10.
What share? Which share? What are the details?
Lord, from the accounts of
paragraph 10.
Paragraph 10.
Which sentence?
There are bunch of a statement of account containing 26 sheets issued by the said Chartered Bank having its branch office at so-and-so in relation to account showing the relevant transaction made during the period by my elder brother Swarup Vikas said. From these statements of account, it is evident various transactions of the estates Sushil Kumar said were made showing purchase of shares, sale of shares, collection of LIC maturity. These statements are issued by the concerned bank authority in the usual course of official business, and those are duly and properly signed by the competent officers of the said bank. These are the statements of account which are more than 30 years. Then, my Lord, counterpart receipts of in sleep. Lord,
this does not say in
11.
whose name it is standing. This apparently says it is standing in the name of Sushil.
Sushil.
So, but your witness says all have been transferred in the name of Sharup. Para 4.
No. It has been said, my Lord. It was showing that the relevant transaction during this period, my elder brother Swarup, from this statement, it is evident various transactions of estate were made showing purchase of shares.
What does this mean?
What does it mean that he purchased these shares in the name of?
In the name of whom?
In the name of the defendant.
In the name of Sharup.
In the name of Swarup.
Sharup. But para 4, your witness says shares and securities of different companies which were originally standing in the name of Sushil subsequently transferred those shares and securities, including the amount of money, in his personal name.
Yes, this is the Lord 4 and 10 should be read together.
Reading together, we are finding contradiction in between those. 4 says all the shares have been transferred in the name of Swarup, and 10 says he has purchased shares from the estate of Sushil. This has no
From those accounts, my lord. Those accounts, my lord, came here. Lord, he did not cross-examine.
This is subsequent. This is not the original share. Here you say that from
Original
this statement
share.
of account, it is evident that various transactions of asset were made showing purchase of Severuel. So this purchase was in the name of Swarup.
Swarup.
But then they never stood. Para 10 says from the estate, from the money obtained from the estate of Sushil, Swarup purchased the shares in his own name. But para 4 says shares were originally standing in the name of Sushil.
Yes.
These are contradictory
Lord,
because
originally in the name of Sushil.
but you say in para 10,
Lord, may I tell your lordship, AB, Lord, these shares originally to Sushil.
Mr. Banerjee, we are getting mixed up here. Para 10 says, from these statement of accounts, it is evident that various transactions of the estate of Sushil Kumar Seth were made, showing purchase of shares, sale of shares, collection of LIC maturity monies. These statements are issued by the concerned bank authority. So, do you mean to say that then from the various transactions of the estate of Sushil, estate was in the name of Sushil, from that, the money derived from that estate, various transactions and shares were purchased in the name of Swarup.
Yes, that is my.
So, therefore, if from estate of Sushil, shares are purchased in the name of Swarup, when the shares are purchased, they are purchased for the first time originally in the name of Swarup. The shares could not have stood in the name of Sushil.
In the name of Swarup.
This statement we cannot find in any other way.
AB, my lord, is the schedule in toto, my lord, in terms of the succession certificate.
Para 10 says otherwise. Para 10 says that the shares were purchased in the name of Swarup from the estate of Sushil.
Which were purchased with the money supplied from the fund of estate Sushil. Sushil Kumar Seth.
Precisely.
Precisely.
Shares were purchased from the funds from the estate of Sushil, not from the shares of Sushil. Mr. Banerjee, I don't think this is a rocket science question. If you are deliberately not understanding, that's a different proposition. But if you are really not understanding, we fail to understand why you are not understanding. Because we are very clear on this. Shares, remand code says, shares were standing in the name of Sushil. Court has to find out on evidence being laid by both of you whether how many of the shares in the name of Sushil were transferred in the name of Swarup, right? So shares of Sushil, shares of Swarup, which stand in the name of whom? This was to be found. Here you lead evidence in paragraph 10 saying not that the shares which were standing in the name of Sushil were transferred in the name of Swarup. No, you don't say that. You say Swarup purchased in his own name those shares for the first time from the estate of Swarup. That means the money of Sushil, sorry. So, para 10 says Swarup purchased the shares in his own name.
From the yes, from the fund.
Not from the funds of Sushil. But that is different from saying that shares standing in the name of Sushil were transferred to Swarup.
Fund of Sushil, my lord, shares.
Fund of Sushil shares. Funds of Sushil has shares. Sushil gets rent from his tenant, that is a share of a company.
Lord, that has been transferred.
Mr. Banerjee,
kindly look.
Sorry, you are deliberately not understanding. We won't put a further question to you.
No.
We'll draw adverse inference against your client on this. Because you are deliberately not answering.
I will have to answer to
We have to stop somewhere. We cannot repeat our questions.
No, I cannot.
I have repeated thrice at least. So I won't ask this question to you. We'll make our own deductions. Please continue with our argument. There is nothing to show that shares were transferred from Sushil to Swarup. Nothing. Show us something. Whenever we are asking to show you something, you are saying this, that. Once your witness says all the shares were transferred from Sushil to Swarup. If all the shares were transferred from Sushil to Swarup, how can Swarup then purchase further shares from the estate of Swarup, Sushil? And some of the shares were not transferred. We cannot go on this. All of these paragraphs say that yes, funds were taken from Sushil and shares purchased in the name of Swarup. But remand appellate court says shares originally stood in the name of Sushil. Those were transferred in the name of Swarup. Where is the proof on that?
Lord, we have kindly.
And who are you to say that? The company has to come and say.
Paragraph 7.
You are a nobody. You are neither Sushil nor Swarup. You are a busybody. You are an heir of Sushil. Sushil.
Yes.
So you are neither Sushil nor Swarup nor the company. The company is the only competent person, the juristic entity through its agents, which can say these shares stand in the name of Sushil or Swarup. Because it's their shares. They know who is the owner. That liberty was given by the appellate court. You did not take care of that. Neither of you. So what about that portion? If the court is not sure which shares are standing in the name of whom, how can a vague degree be passed?
Lord, your lordship kindly come to the cross-examination part. It
Yes.
has been clear made.
Let us see that.
83A.
Page
83A, my lord. Lord, mark the document 22 to 31 collectively, and I have filed another document.
This is not
which
cross-examination. This is
mark
chief.
exhibit 32. I know contents of examination in on affidavit. Then my lord cross-examination.
Yes.
I have gone through the plaint before filing my examination in chief on affidavit. My prayers in plaint are confined to shares and dividend only. I have all the allegations against succession certificate, so and so. Then, my lord, this is the letting drafted of my advocate to so and so. Then, my lord, no other cross-examination. Then they declined.
So what do we find? Which shares are standing in whose name? Now, today, after remand. Any evidence after remand?
From the, my lord, extended succession certificate, my lord. These are the amount, total amount.
Extended certificate was there 20 years, not 20 years. Extended certificates were there much before even your suit was filed.
Right, my lord.
After the extended certificate, suit was filed, you lost, preferred appeal, remanded. Remand order says we have to ascertain on evidence which share stands in whose name. So if the remand court, appellate court says this at this point of time, you cannot fall back upon the extended certificate, succession certificate, which was the genesis of all this. Because the extended certificate was the genesis of your suit. Then suit filed, you lost, appeal, remand. After extended succession certificate, so much happened. And then at a subsequent point of time, the appellate court says, we want to ascertain by evidence which share stands in name of Swarup and which still in Sushil's name. Now, therefore, you cannot now say, please look at the extended certificate again. The appeal court had the extended certificate before it. Your suit was on the basis of the extended certificate. Knowing fully well the extended certificate, appeal court said that no, evidence has to be laid on which share stands now in whose name.
My submission is, my lord, that when, Lord, this original succession certificate, Lord, has been marked exhibit. That is, my lord, the state admission, a state of exhibit A and B. Exhibit A and B is in perimeter to exhibit A and B of my suit. In which, my lord, the declaration has been granted in my favor. Now, my lord, they are to show before the court by giving a certificate, by giving an evidence, by showing that no, in addition to that, some other certificate or new certificate were purchased. New certificate was purchased with the own fund of the defendant. Lord, that he did not lay any evidence with regard to that part. And my lord, A and B, Lord, he declared, my lord, in respect of A and B. Trial court, your lordship, kindly come to the trial court finding.
Yes.
Lord, at page 174.
DD.
Lordship.
174 DD.
Yes.
We are there.
174.
Findings are at DD.
Lord, page, my lord, 174 ADD.
Internal page 30.
Internal page 30.
We are there all along.
Yes.
That has been kept open throughout the arguments of both parties.
Yes. It is fine from exhibit 22 to 31 that the entire amount income derived from a state of Sushil Kumar Seth was duly credited to the personal bank account of Sarup Vikas Seth, and subsequently to the help of that amount, all the shares and securities were purchased in his personal name. It is also found from those documents that by collecting monthly rental, other charges from different tenants of a state of Sushil Kumar Seth, and by collecting other profits from different companies, and with the help of sale proceeds of selling various shares, and by matured value of LIC's policies standing in the name of Sushil, and Sarup Vikas Seth credited those amounts in those banks in his personal name, and with the help of those income, all new shares and securities of different companies were purchased in his personal name from time to time. The contents of exhibit have not been challenged by the defendant either by oral or documentary evidence or by cross-examination, the PW1.
Purpose is subsequently transferred in the name of Sarup. আমি তো বোঝাচ্ছি উনি ইচ্ছে করে বুঝছেন না কি করা যাবে ডেলিভারেটলি না বুঝলে তো একজন সিনিয়র লোককে বোঝানো যায় Yes, sir.
Now, my lord, AEE, my lord.
Yes, AEE.
AEE. The two passbooks, exhibit 29, and the statement of accounts, exhibit so and so, in support of the plaintiff's case. And it is true, and from Sarup Vikas Seth, during his lifetime, procured all those shares and securities in his personal name out of income of the total income of the estate of Sushil Kumar Seth.
কোনো ডাউট নেই
Section 383B of the Indian Succession Act supports the plaintiff's case. It is found that exhibit 16, defendant deliberately made false statement by concealing such material facts. Then, my lord, ultimately, blood declaration that it was void, and therefore, my lord, so far extended certificate is concerned, that was declared void. Now, my lord, my respectful submission that the dates and securities mentioned in exhibit A and B, in schedule A and B, on the basis of which declaration in respect of A and B has already been given by this court. Save and except, my lord, any new shares purchased by Sushil, Lord, is required to be proved by Sushil. Now, Lord, we proved it. Lord, your lordship, kindly come to volume 2, my lord, of the paper book.
Sir Banerjee, there is no doubt on that. Please come back to page 166 once. Page 166, in the second paragraph, the appellate court says, although learned advocate for the parties argued considerably the question whether original shares held by Sushil were really transferred in the name of Sarup Vikas Seth, we find from the record that sufficient evidence has not been adduced at the time of hearing. This is being held much after the extended succession certificate. Adduced at the time of hearing as to exact number of shares and securities held means that on that date, either in the name of Sushil or Sarup. And learned trial judge did not come to a definite conclusion whether those shares are really transferred in the name of Sarup or are still appearing in the name of Sushil. Then it says, even the actual amount of money realized by Sarup by virtue of succession certificate is not brought to the notice of the court. There are two components. Shares standing originally in the name of Sushil. Second, the money derived from those shares, like dividends and all, which you are pointing out. These two components were to be ascertained. This was the nature of remand. 5-6 share of yours declared in everything. But to pass up a decree with a teeth, with teeth, not a toothless decree. there has to be specification of these shares are standing in the name of Sushil. Otherwise, if court even passes a decree today in your favor, you won't be getting a decree, effective decree. You won't be able to execute because unless it's enumerated, these shares are standing in the name of this person. These two parts, one part was satisfied by you and the trial court after remand. Which was that part? That the money, the dividends, the money, actual amount of money realized by Swarup by virtue of succession certificate. That means from those shares, that how that has been utilized. You have produced ample evidence. We are satisfied that appeal court should not interfere with the discretion of the trial court on that. You have shown by elaborate evidence that dividends obtained from the shares standing in the name of Sushil were obtained by Swarup, and Swarup invested those in purchasing fresh shares, etc., etc., etc.
And those are exhibited.
Those are exhibited. So those are of the second category. These new shares are purchased by Swarup from the dividends of the old shares which are standing in the name of Sushil, right? So unless the shares still stand in the name of Sushil, Swarup, there is no question of Swarup getting dividends from those shares and buying his new shares. Otherwise, they would be his shares.
Because, my lord, he
No.
he
Let us
got
complete.
he got the succession certificate on the
Obviously,
basis of that.
let us not discuss obvious things. Everything is on the basis of succession certificate.
Lordship.
Now, therefore, this part has been satisfied. That what did Swarup do with the money derived from those original shares standing in the name of Sushil?
Right.
The other component is, we find from the record that sufficient evidence has not been adduced regarding what? Whether original shares held by Sushil were really transferred in the name of Swarup. Now, regarding original shares being transferred in the name of Swarup, liberty was given for the companies to be called, companies to come, companies officials to say that these shares, which originally stood in the name of Sushil, have now been transferred to someone else, Swarup, or still retain the name of Sushil. This was to be done. This was not done. We do not find any evidence, although we find ample evidence to show that from the money derived from the income of Sushil's shares, the dividend and all, those were utilized by Swarup to buy new shares in his name and all these things, and you get a degree on this. But whether those original shares, unless the original shares still stand in the name of Sushil, where is the question of Swarup taking dividend from there and purchasing new shares? So those, where is the proof of transfer of those shares in the name from Sushil to Swarup? Show us one company certificate, one evidence, any witness from a company, or any certificate by any company to say that shares which were standing in the name of Sushil has now been transferred to Swarup. Your certificate says dividend from Sushil's share is being given to Swarup. That is what your certificate says. That dividends coming from Sushil are being given to Swarup. Swarup is earning dividends from the shares of Sushil and utilizing them, and you get a degree on that. But what about those original shares? How many of those original shares were actually transferred in the name of Swarup? There is nothing on record. So you say, once you said that all shares are standing in the name of Sushil, which we could understand that yes, succession certificate up to that stage, all shares were standing in the name of Sushil. Up to that extended certificate stage, all shares standing in the name of Sushil. When you file the suit, maybe all shares were standing in the name of Sushil. So therefore, that much we are clear. But this other part, how many of those shares and have been, so if I go by you, till date all shares should be standing in the name of Sushil, because you are showing that Swarup purchased other shares in his name, new shares, from that money derived from Sushil's dividend. So by natural corollary, Sushil shares should be transferred, shares should be standing in the name of Sushil. But where do your witness comes and says all those shares have now been transferred in the name of Swarup? Where is that proof?
Lord, there is no cross-examination on that.
There is no examination on that. How can it be a cross-examination?
We say.
You never say.
Lord, we say state of
no oral evidence won't do. You are given, the companies have to come with some documentary evidence, or the company must come and say.
But if he admit, my lord, why don't cross-examining? Lordship kindly consider that.
No, shares are in the name of a company.
Admits in cross-examination.
Even then, by collusion, you cannot change the reality.
Appellate court, my lord, the trial court after remand granted a decree.
See the perversity in the trial court judgment. Yeah. Now let us come back to that. You are saying that is what we are showing you. Page 30, please come there.
Page
30, Internet 30, 174 DD. or ADD, whatever. Now come there.
31
30, internal page 30.
or 30 of the appeal court judgment.
Trial court
Judgment.
page 174 ADD. You put placed before us.
174. Lordship. Internal page 30.
Yes.
Lordship.
Please come there. If you see the second paragraph, exhibits 22 to 31, the entire finding in that paragraph is that Swarup Bikash during his lifetime purchased a good number of new shares and securities in his personal name by making payment out of the income of the estate of late Sushil. So Swarup purchased new shares in his own name from the estate of Sushil. That means from the dividend of Sushil's shares and other estate of Sushil. So shares still stand in the name of Sushil. Entire paragraph says that, and the paragraph ends with the contents of exhibits have not been challenged, so believed. Yes. Everything.
Entire income.
It is also found from the documents that Swarup has been collecting monthly rental and other charges from different tenants of Sushil, collecting other profit and profits from different companies. That means Sushil must still retain the shares in his name. Unless the shares are in the name of Sushil still in those companies, how can Swarup earn income from the estate of Sushil? For it to be held that Swarup is buying new shares from the money derived from the estate of Sushil, if that is said, then the estate has still to be of Sushil. The estate means the shares also. Then the shares must still be in the name of Sushil. Otherwise, it wouldn't be his estate at all. If the shares were transferred in the name of Swarup, then it would be Swarup's estate. So Swarup is purchasing new shares from the money derived from the dividends of Sushil's shares. That is what the entire paragraph says. It ends. Please come to the last paragraph now. Just see the jump. From the documents marked as exhibits, it is found that all the shares and securities originally standing in the name of Sushil were subsequently transferred in the name of Swarup Sheth on the strength of succession certificate. How does it get it? The previous paragraph is quite contrary. Previous paragraph, all along it is said that you have proved that Swarup has collected money from Sushil's shares and purchased new shares in his name. That does not mean that those shares are transferred. The dividends from those Sushil's shares are used for this new purchase. If I say you have got a house, if I prove before the court that from the income from that house, from the rental income, I have purchased a new house, does it mean that the old house has been transferred in my name? Here, instead of house, place shares. So where is the proof? Where does it get this finding that the shares of Sushil have been transferred in his name? And that was one of the points of remand which we repeatedly placed before you. Page 166.
Basically, A and B, my lord, we got a decree in respect of A and B.
We are now at Z. We have crossed Z now. You are still at A and B.
No. Your lordship, my lord, reasonings may be incorrect, but lordship kindly look to that reasonings may be modified by your lordship.
There is no proof to modify.
No, yes, my lord, that is why I am.
There is no evidence led by you. How can we modify it from our wish?
I am placing before your lordship the documents, exhibited documents. Kindly.
All exhibited documents we are believing. As we said, Mr. Banerjee, again we are repeating. All the exhibits which you have produced after remand go on to show that Swarup has utilized dividends from Sushil's shares and rent income and other income from the estate of Sushil, utilized that to buy these new shares and all. And court has held these exhibits show that the money has been utilized by Swarup to purchase his own things. So you have a share, 5-6 share in that. But page 166 court gives two grounds of remand. One is that question whether original shares held by Sushil were really transferred in the name of Swarup. We find from the record no evidence. So leave was given to you in the next page. Parties are free to summon the concerned companies where those shares are lying. What? For the purpose of showing the strength of the disputed shares as it stands today. And if it appears to the court on the basis of such evidence that the original shares of Sushil are still continuing in his name and that those were not transferred in the name of Swarup pursuant to the succession certificate, the court will declare 5/6 share of the plaintiffs and 1/6 of the defendants in those shares. But if it is still standing in the name of Sushil, that has to be ascertained.
Lord, there is no shares, Lord, now remaining, Lord, still in the standing in the name of Sushil.
Rather, all the shares should be standing in the name of Sushil. If your other plea is correct, otherwise your entire evidence should be disbelieved, because you have been continuing to lead evidence to show that the dividends from Sushil's shares have been utilized by Swarup to purchase new shares.
Yes, that is my case.
If that is your case, how can
That is one of my case.
that if that is your case, then how can, if the shares have been transferred in the name of Swarup, then Swarup is using his own shares, the dividends of his own estate, to purchase new shares. It would not be that Swarup is using the dividend of Sushil's estate. Those shares remain Sushil's estate if they stand in the name of Sushil still. And you are saying no. In the same breath, you are saying all shares of Sushil have been transferred in the name of Swarup. And you are saying no. Swarup is deriving share income from Sushil's estate. If it has been transferred to the name of Swarup, all the dividends are being collected by Swarup from his own estate and purchasing new shares from his own estate now. So it no longer remains the estate of Sushil. None of the companies have been brought. How do we know that the shares have been transferred in the name of Sushil? So how can the court grant a decree? The court has to grant a decree on a particular share, knowing whose name it is standing in.
Yes.
That
Now,
is the
Lord,
difficulty.
standing in the name of Sushil, Lord,
Sure. Sure.
at the time of
Today.
Now, today, my Lord.
Are you so sure?
Lord, let me have a
conversation with your client. You would be more confused, I can assure you.
Let me, my Lord.
Let you do what? Papers are before us, Mr. Banerjee. Your contradictory
No, we
stand
have
is
to-
before us.
Lord, if there is a contradiction, my Lord, of course I will. Lord, if there is a contradiction, contradiction is there.
We have been hearing this matter for 3 days, 4 days. So we will conclude it today.
Yes, my respectful submission before your Lordship is this. Lord, kindly look to the documents. Maybe, my Lord, that you
We believe entire documents. We say that we won't disturb the trial court's finding on those documents. It's right. Swarup Bikash has utilized the estate of Sushil and purchased so many things, which
But
was
Lord,
one of the
Swarup
components of.
Bikash, my Lord, did not adduce any evidence by showing that no, these are not the yield or these are not the shares of Sushil. Lord Swarup Bikash did not come forward and say.
So is the cat in the
Even Swarup Bikash did not cross-examine.
is the cat in the Schrödinger's box alive or dead?
Lord, because
Are the
Lord,
shares standing in the name of either they can stand in the name of Sushil or stand in the name of Swarup? If they stand in the name of
question would be, my Lord, whether
No,
the
what is your
purchase-
answer? They are standing in the name of Swarup.
It is a standing in the name of Swarup.
Swarup.
Because
So
for
therefore,
the-
your case fails that Swarup is enjoying dividend, drawing dividend from
No,
the
not
shares of
only
Sushil.
dividend, but shares also transferred. Share also transferred in the name of share was also
Share is transferred in the name of Swarup, Mr. Banerjee, then Swarup has to pay for that, not get money for that. If share is standing in the name of Sushil and Swarup gets his transferred to
Lord,
his.
my submission is.
No, you are not letting us complete our sentence.
Lordship.
Let us complete one sentence, then you complete your 10 sentences. If Swarup is to transfer the share from Sushil's name to his name, he has to pay a nominal amount to the stock exchange and others. He does not get anything. He gets only the shares transferred in his name. But your case is that he is utilizing the dividends and income from the estate of Sushil, which is comprised primarily of shares. He is utilizing the dividends from those shares and purchasing new separate shares in his name. So aren't these two contradictory? If
But
the
my-
shares are not standing in the name of Sushil, how can he take those? How can he take dividend and purchase his own share? If it is standing in his own name, then he is taking dividend from his own shares and purchasing new shares.
But practically in the remand order, it has been clearly said, Lord, that the kindly look to this, my Lord, that when declaration was given, remand order was passed.
Yes.
Before that, my Lord, your Lordship, kindly look to the remand order.
Remand order page 166, bottom paragraph, you can come there. That you have established. Page 166, bottom line, bottom paragraph.
Yes.
Yes. Come to the last paragraph of page 166, Mr. Banerjee, that has been established by you.
Because, my lord, he obtained a succession certificate. On the basis of that, my lord, he collected the shares value. On the basis of that, my lord, he collected the shares value,
All right.
including the dividend.
So that was very obvious. Why did the appeal court then remand it on that ground? What was the purpose of the appeal court? You had argued before the appeal court also. Or you had not argued before the appeal court?
No, they argued, my lord, that there are.
No, you, Mr. Banerjee, you personally did not argue before the appeal court. Did you?
That question would not arise, my lord. At that time, I was not. Mr. Dasgupta was there.
Yes. So we don't know what was argued actually before.
He admitted, my lord, the case AB, whether it is in conformity with the AB or not. Lord, if the admission is there, then I need not prove it. Lordship knows section 58.
Yes.
Is it not his case, my lord, that AB is not the property, shares belonging to.
You are saying that the entire shares of Sushil have been transferred to Swarup, right? Where are the documents to show that?
Lord, that is why
you want
I
a document
I
to show
wanted
that
to-
these shares are transferred, either a certificate by the
Page
company.
1227, Lordship 1227 to 1269. From the bank account, my lord, it has been transferred. The shares, dividend, everything, my lord, has come on the basis of
Shares and dividends are different things. If the dividend is transferred, the share cannot be transferred. If the share is transferred, the dividend is not transferred. How can it?
Dividend will not.
Share dividend is the income from the share,
Right.
rather income arising out of the share.
Right, my lord. That dividend at the
If the
time
share itself is transferred, how can the
before encashment of the shares?
where is the transfer of the shares? Let us see. Page 1227. Yes.
1227.
We want to see only those transfer certificate of the shares.
Yes.
There is a certificate of the transfer. Show us that. All regarding dividends. And on the strength of the succession certificate, Swarup has been taking the dividends. On the strength of the succession certificate, Swarup has been taking the dividends from Sushil's shares. Because he has a succession certificate.
Dividend, my lord, those shares have been purchased.
But the shares still remain in the name of Sushil. Otherwise, how can he get the dividends from those? Succession certificate is what? Succession certificate means you get a right to operate the estate of somebody. The estate of that somebody is the shares of Sushil for our present purpose. He is getting dividends from that. Show us something, at least one document to show that the shares were also transferred. He could have got those shares transferred also by virtue of the succession certificate. We agree. We want to see one document on that the shares were. He could very well do that, because if succession certificate gives right to me to have succession to an estate, definitely I have a right, also corresponding right, to get the shares transferred in my name. Where was it done? That was why this was remanded on that ground also. Court wanted to see that and gave you liberty to call the companies for that. Summon the company.
Lord.
Or that the Swarup's name was entered into as a member or what, something, a shareholder. There are companies that provide several provisions for entering the name of a shareholder in its records.
Lord, page 1227, my lord.
27, yes.
Lord, these are all purchased through GM Vasu.
These are part of the A and B schedule shares.
Yes.
Let us see from that schedule. What is that schedule? That schedule you are showing regarding the succession certificate?
Schedule, my lord, at page.
Yes. But then why does he pay money for that? These are charges.
Yes.
No, he purchases those shares. He purchases the shares of Sushil.
Yes, then money came back to the account of Sarup Vikas. And source of money is from the Schedule A and B. Because I mentioned Schedule A and B in my plaint. And it is not his case. No, there are other properties which is exclusively belonging
No,
to
these are not purchase receipts. These are transfer receipts.
transfer, yes. That was transferred.
All right. And the income which was utilized was from the estate, I mean, from the rent and other things.
Yes, entire.
All right.
And
very
Lord, not only that, your Lordship kindly look to the Lord, Lord, page 278, Lord, 268 first. Lord, this is the order passed by the Income Tax Department, his state duty, page 267. Lord, these are the shares which have been mentioned, upon which 16 share, Lord, which has been mentioned, my Lord, from page 267 to page 275, in which, my Lord, he paid estate duty to the extent of 16. Now, Lord, income tax return, my Lord, he has no income.
Yeah, this is estate duty was paid by Swarup by virtue of the succession certificate.
By virtue of the, because succession certificate.
He does not speak about the shares in the company. Estate duty is not payable on shares.
Yes, my Lord, estate duty is payable on the basis of succession certificate, the amount of money which is entitled. Lord, accordingly, 16 share, my Lord, he is entitled. Accordingly, order was passed to that effect. By
Is Section 57 of Estate Duty Act contemplates
Assistant Controller
contemplates estate duty being paid for shares.
Yes, on the basis of that amount.
Do you have a
the
copy of the
succession
Estate Duty Act? Let us see Section 57.
Lord, page 267, my Lord. It is hereby certified that the estate duty payable on provisional assessment under subsection 1 of Section 57 of the Estate Duty Act, 1953, in respect of the property, where after described in or as passing on the date of Sushil Kumar, it is Sushil Abe, Sushil Kumar Seth, Sushil Seth, not Swarup Vikas. Lord, in the original, my Lord, let me look into that. Under Section 57 of the Estate Duty Act.
This is a Central Act, Estate Duty Act?
Lord,
yes.
Certificate, my Lord, under Section 65 and Rule 26(2) of the Estate Duty Act. My Lord, the company shares, my Lord, have been mentioned therein.
Where?
Lord, your Lordship, kindly page 268, schedule, my Lord.
Yes, yes.
A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P.
All these were produced after remand.
After remand.
This is what we are wanting.
Yes, Lordship, exactly.
Yes. So estate duty was paid by Swarup on his own estate, showing those shares also.
Yes. In respect of these shares, therefore it has come. And these amounts, my Lord,
Very well,
have come Lord, in the account, my lord,
No,
maintained.
rest
by
is
him.
there. Accounts,
Yes.
dividends have come and all.
And including, my lord, the
Very well.
document, income tax department document, we have assessment order, we have submitted.
And bank statements also.
And bank statement also.
Very well.
Lord, we wanted, my lord, not to continue 70, 20, near about 27 years.
Unnecessarily.
Yes, unnecessarily. Lord,
What could you do? They came after 20 years.
We avoided, my lord, to contest for which, my lord, they admitted 1/6 of the entire estate. Otherwise, there will be no dispute. Lord, we wanted, we do not
understand
want,
that,
Lord,
yes.
to contest in this way. That is why we have, Lord, forgiven, waived our right with regard to C, D, and E.
Yes, what do you say? Mr. Vanjitikis.
Lordship.
Any judgment you want to, they have cited a judgment.
Lord,
Judgment
that
is on the
judgment,
scope of
Lord,
remand.
Lord,
Which is-
my respectful submission before your Lordship is this.
Yes.
So far the judgment he has relied
Yes.
on, Lord, judgment is no longer, Lord, section is no longer raised in section itself. Section 23, 23A, 24, and 25.
24 is
Procedure
if the appeal court
24
can.
court itself
23
decide.
and 25.
24 itself could decide. 25 itself. And remand, my lord, only in the case of 23A. And that is why, my lord, those are lacking, and that is why, my lord, remanded 23A.
Very well.
They were quote on the basis of the documents on record, and he did not. And only my submission before your lordship, apart from this document, he did not adduce any evidence.
No,
Number
that
one.
is always there. He did not. He
produce
did
any
nothing.
documents.
He did nothing.
Number three, my lord, he did not cross-examine the witnesses. Now, my lord, Carapet, your lordship knows. Carapet, my lord, approved by
Non-traverse.
Supreme Court,
Non-traverse.
2016 Supreme Court. Carapet.
Yes. Well,
And
yes.
so far the judgment is concerned, it is not new, my lord.
That is a well settled.
Yes,
proposition.
well settled.
Yes, Mr. Dutiman Manji.
My lord, may
What
I only,
reply?
my lord,
Yes.
a copy of this judgment? Sir, paragraph 13 I was referring to, my lord. I'll not trouble your lordship, my lord, with it again.
Yes, in reply, apparently so much document has been produced. Swarup Bikas has been paying estate duty on showing those shares as his estate, and so much proof has been given. The bank statements have been produced before the court, everything to show how the money was canalized to Swarup's account. So sufficient compliance of the remand order. Why not?
My lord,
Court
produced-
relied on that, page 30, internal page
My
30.
lord, even if my lord produced by them, what was my lord after that, my lord, what did, whether my lord, I'm putting this question to myself, whether my lord, the learned trial court, my lord, came to any conclusion.
Yes, yes,
And
page
my lord,
30.
whether my lord, the learned trial court, my lord, did consider all these documents at all.
Did come to page 30, internal page 30. Where is that? We lost that. 177, yes, 177 ADD.
Yes.
Complete consideration.
My lord, exhibits 22 to 31 shows that the state Swarupika during his lifetime purchased a good number of new shares and securities in his personal.
And in fact, from the previous page also, exhibits 1 to 32 support the plaintiff's case, corroborate the plaintiff case. And then it is said from those documents, it is clear that it is found that Swarupika did not purchase those shares from his income. Clearly that he purchased the shares and dividend from the income of the estate. 30 and 31 shows the total purchase of Swarup as Karta. Then what you are reading, that Swarup Bikas during his lifetime purchased a good number of new shares and securities in his personal name by making payment out of the income of the estate of late Sushil Kumar Seth. So many things. Entire amount of income derived from the estate of Sushil was duly credited and person. So everything, he got the names transferred also, which is apparent from the documents shown by Mr. Banerjee, 1227. That the estate duty was paid by Swarup also on that. And court says the contents of exhibits not challenged by you from documents. It is found that all the shares and securities originally standing in the name of Sushil have been transferred.
My lord, itself, their plaint case was that Swarup Bikas duly reinvested the entire amount, so realized by him. Whether my more than transfer, my lord, my lord, the case was of reinvestment.
The court can go by the the plain schedule and declare that they have 5/6 and 1/6, which has been done in consonance. And regarding the rest of the amount, it has also been said let us see the finding of the court, the ultimate decree. Page 33, internal page 33. Please read that, the ordering portion. It is hereby declared.
It is hereby declared that the plaintiffs are jointly lawful owners to the extent of 5/6 share of the total shares and securities left by the said Sharupika Shed, the predecessor interest and title of the defendants, who are jointly entitled to have their share to the extent of remaining 1/6 of the 1/6 share of such total shares and securities left by Sharupika Shed, as more fully and particularly described in the schedule. Therefore, my lord, what pertains to the schedule, not beyond that. Schedule given in the plaint of the suit, as those shares and securities had been acquired by the said Sharupika Shed in his capacity as a Korta of the Hindu undivided joint family of Sushil Kumar Shed, and further declare that the defendant numbers 1 and 2 have got no manner of right to have those shares and securities as absolute owners thereof on the strength of impugned extended succession certificate granted in Act 39 case number such and such, which is a product of fraud, misrepresentation and suppression of the material facts, and as such the same is absolutely ineffective, inoperative and having no legal effect, and the same is not binding upon the plaintiffs, and the same is hereby revoked. And the defendant numbers 1 and 2, the remaining agents and employees are
But if it
permanently-
goes against them. Because the remand court, appellate court said parties are also entitled to read further evidence on the question as to amount of money actually realized by Sharup by virtue of succession certificate granted in his favor. So it was for them to show that this amount was actually realized, and they were to get a degree, further degree on that. They were to amend their plaint. They have, so it goes against them, not against you.
And my lord,
Sharup earned further money from those.
This question was, my lord, put by me, my lord, to my client. My lord, why are
They
you
should have preferred an appeal.
Why are you acting? My lord, the question was, but the answer was that, my lord, until segregation, my lord, a definite conclusion and segregation is made. As of today, those shares are lying in a stalemate condition. Nobody is in a condition to touch them. And even if, my lord, my clients do touch them, they will be facing, my lord, a suit for partition, my lord.
Take it in your section 47 application. But it is Mr. Hadun's client who is suffering.
To put this into execution.
Nothing was left for remand. Only two things were left. One is whether the shares have been transferred. They have produced estate duty certificate and all those things.
But that is parametrically to our Schedule A and B.
Schedule A and B. But
nothing.
Mr.
Question of segregation does not arise.
No, Mr. Banerjee, what was given to you, you could not utilize. Page 168, the appeal court said that the parties will also be entitled to lead further evidence on the question as to amount of money actually realized by Sharup by virtue of the succession certificate granted in his favor. After that, what amount he has realized, you produced evidence on that, but you did not amend your plaint, nor was any further degree granted on that. Your share has been declared in respect of the shares as per Schedule A and B. You are satisfied with that.
That will suffice on the basis of
He
that
earned
declaration.
much income from those in the interregnum. You are not getting any degree on that.
Because, Lord, the much income means, Lord, the dividend and other.
No degree has been granted on that.
Dividend and other things, my lord, at this moment, my lord, cannot be touched again.
No degree has been granted on that.
Cannot
That is
be,
what
my lord, reopened.
you had to establish that this is the amount which has been derived by Sharup from that estate. That you are entitled to a degree on 5/6 degree on that also. But here there is no degree on the additional income gained by Sharup over so many years, Mr. Banerjee. Not only from the extended succession certificate, let us take that. Before that, he did not have
But
that.
if the declaration is given, my lord, on the basis of that, we can ask the Lord.
Ask whom to? Payment already made.
No.
New payments you will get.
But the amount which is also in the name of Swarup Vikas, that is the property of Sushil.
5/6 share.
Yeah, 5/6 share.
True.
We pay that.
But the income which he has already earned, the matter is
That
pending.
was also, my lord, no, that was attached. My lord, those properties have been attached. They could not be able to, in view of the interim order.
That goes now. Attachment
That goes now.
But those
That's
properties
right.
are not sold, not given to
Yes,
you.
yes. Lord, that
Title
goes
suit of
now.
1997, we are in 2024.
Yes.
So over
Before
these
it-
years and before that, from the extended succession certificate, Sharup Vikas earned so much.
Now, my lord, my respectful submission.
You don't get a
before your
degree on
lordship
that.
is
You
this:
should have
when
challenged.
company share declaration is given, automatically, my lord, I am entitled to dividend and others.
You don't get what we are
To
saying.
the extent of
Dividend,
5/6.
my lord, future dividend.
No, future dividend.
Present and future.
Present and
We are
future.
including present also.
Yes.
What about past? What he has already earned? So much money. Sharup gets enriched by that.
That amount, my lord, in the in the estate, under the Estate Duty Act that has been mentioned.
That's that amount, whatever amount was earned by Swarup.
Was earned.
Maybe in the form of a new house, maybe in the form of a new car, a new furniture. We don't know.
That amount, my lord, is in the passbook. That has been mentioned.
But no degree has been passed on that. You see? Anyway, you are happy with
Lord,
that? Yes.
point is this, my lord, I cannot develop it, my lord.
No.
Whatever is there,
You
I
cannot
can
file an
argue.
appeal from a
Lord,
degree
I
of
cannot-
1997.
I cannot argue, my lord.
2008
that.
degree.
I
You cannot
cannot
file.
argue beyond that. Lord, only I can.
No, this
argue
order we are
your
with you.
lordship, Order 41, Rule 33, my lord, the relief may be granted.
No, new degree
So far
cannot be
that-
granted. Degree you have not asked for.
Lord,
We cannot grant you a degree. Order 41 to
most, my lord,
33,
omnibus
whatever trial could do, we can do. 41, 33 is that.
Lord, only one thing your
Trial could
lordship
even
knows
could not
that.
do that.
Lord, your lordship knows that omnibus prayer is there in the plaint. So far, the my lord, yield are concerned. Yield I am entitled.
No, omnibus prayer does not mean anything.
Yield I am
Or we can
entitled.
remand it to
Court
the
can
trial court
grant the
further,
relief.
for that matter, and direct it to be decided within 20 years. We can
Lord,
do that
court
also.
can grant the relief, my lord. So far, that party is concerned.
Relief not asked for cannot be granted.
Lord,
Definitely. not.
omnibus prayer only 52 Supreme Court, my lord, I shall.
Omnibus, you have missed the omnibus.
52 Supreme Court there, my lord. The relief was granted within the campus of omnibus prayer.
Don't take undue advantage of your erudition and throw
No.
52, 50.
Lord, I am
does not appeal here.
lordship
We don't
knows
know of
that.
any law that any decree which has not been asked for can be granted by the court. Show us 51, 52, 53, whatever. Anything after 1908. Any judgment which says that plaintiff did not ask for a degree, it can be granted by virtue of the omnibus prayer. Then omnibus prayer would, one would make only an omnibus prayer. Whatever relief I am entitled grant. Why should one make a prayer?
Because
What is the question of Section 34 of Specific Relief Act? Declaration is sought.
Lord, practically,
Any
I
other
cannot-
relief? Omnibus prayer. No
practically, I
suit to be
cannot
barred
go
under
and
Section
file
34
a suit
provision.
for recovery of that amount.
You have not
That
filed.
will be order to Rule 2 hit.
No.
It will hit by.
No, you could amend your plaint during pendency because that's a subsequent cause of action. You are much more experienced than us, so now it's too late in the day. Interfere করছি না. The president.
Lord, that can be your lordship.
So we have
kindly-
shown a lute to
Only
you.
with regard to.
Forget it. We have not said that.
Yield, my lord, and interest. That is.
No.
That dividend and other.
We will not pass any further degree. We will affirm this degree. He will lose his case and win his case. Please take a seat. The present appeal has been preferred against a judgment declaring the shares of the parties in the estate of one Sushil Seth, Sushil Kumar Seth. Sushil Kumar Seth, since deceased, primarily comprised of the shares in different companies standing in the name of the Seth Sushil Kumar Seth. Seth hoche AC-double-T. Push up, next para. The brief background of the case is that initially the present appellant had filed a succession certificate, dividing the subject property of the said proceeding into 5 schedules, namely schedules A, B, C, D and E. Full stop. Insofar as the schedules C, D and E are concerned, the plaintiffs / respondents herein conceded to the exclusive title of the present appellant to the said properties. Full stop. Next para. However, insofar as the property within bracket primarily shares of Sushil in different companies bracket closed, covered by schedules A and B of the succession certificate application is concerned, it was an admitted position that the present defendant / appellant was entitled only to 1/6 share therein, whereas the plaintiffs had 5/6 share. Full stop. Next para. The succession certificate was granted accordingly, granting exclusive interest stroke title of the defendant appellant in schedules C, D, and E, whereas only 1/6 interest of the defendant appellant was granted in respect of the schedule A and B of the said application. Full stop, next para. However, comma, after the chapter closed, comma, about 2 decades later, comma, the defendant stroke appellant reopened the issue by applying for grant of an extended succession certificate, full stop, without notice to or any hearing being given to the present plaintiff stroke respondents, comma, such extended succession certificate was granted, comma, now in respect of schedules A and B properties also. Full stop, next para. Naturally, comma, the plaintiff's respondents sought a revocation of the same, which failed on technical grounds, comma, since revocation of a succession certificate is not specifically provided for in the Indian Succession Act, and also as in the opinion of the court, comma, questions relating to title cannot be gone into in revocation of a succession certificate. Full stop, next para. The plaintiffs, comma, as the natural second option, comma, filed a suit seeking declaration of their title to the extent of 5/6 share in the properties within bracket primarily shares standing in the name of Sushil bracket closed, comprised of the subject matter of the extended succession certificate, comma, which correlates with the schedules A and B of the original succession certificate application. Full stop, next para. The said suit was dismissed on contest. Full stop. An appeal was preferred by the plaintiff's plaintiff's respondents herein, comma, which culminated in a judgment and order of remand being passed. Full stop, next para. The present chapter of the dispute starts thereafter. Full stop, next para. The learned trial judge permitted parties to lead evidence, full stop. However, comma, it is the plaintiff's respondents alone and not the defendant appellant who led evidence, full stop. Several documents were exhibited by the plaintiff's respondent after remand, full stop. The learned trial judge, comma, after going through those and hearing the parties, comma, adjudicated the suit after remand, comma, thereby declaring 5/6 share of the plaintiffs in respect of the suit property, which was the subject matter of the extended succession certificate, and 1/6 share of the defendants. Full stop. Next para. Learned counsel appearing for the appellant contends that appellants for the appellants contends that the learned trial judge did not adhere to the points on which the matter was remanded and rather acted without jurisdiction in going contrary to the same by redeciding certain issues which were already decided finally by the appellate court and passing and taking into consideration certain extraneous factors which were not a part of the remand order. Full stop. In support of his submission that it is beyond the power of the trial court on remand to go beyond the remand order, comma, learned counsel cites such a judgment in namta diye, reported at 2023 13 SCC page 1. Full stop. Particularly placing reliance on paragraph 13 of the said judgment, comma, learned counsel argues that the court to which the case is remanded has to comply with the order of remand, and acting contrary to the order of remand is contrary to law. Full stop. In other words, comma, it was held, comma, an order of remand has to be followed in its true spirit. Full stop. Next para. It is submitted by learned counsel for the appellants that no evidence was led by the parties by summoning the concerned companies whose shares were the subject matter of the dispute for the purpose of showing the strength of the disputed shares and as to whether the and as to whether and which of the shares stand transferred in the name of Swarup Bikash Seth, comma, the predecessor in interest of the plaintiffs, of the defendants, and which of them still stand in the name of the original owner, Sushil Kumar Seth. Full stop. Next para. As such, comma, it is submitted that the impugned judgment and decree does not stipulate the exact ownership of the shares, comma, for which it is bad in law and contrary to the remand order. Full stop. Accordingly, comma, it is submitted that the appeal may be allowed and the impugned judgment and decree be set aside. Full stop. Next para. Learned senior counsel appearing for the plaintiff's respondents takes the court through several documents which were exhibited before the learned trial judge after the order of remand. Full stop. Learned senior counsel contends that from such elaborate evidence, comma, regarding which no suggestions were put in cross-examination by the defendant stroke appellants, comma, it is amply clear that the money derived from the estate of late Sushil Kumar Seth was usurped and appropriated by Swarup Bikash by purchasing shares and other properties. Full stop. Next para. It is pointed out that bank statements, comma, check counterparts, comma, slip books, comma, passbooks, and counterfiles of dividend confirmation letters of various companies have been produced after remand on the part of the plaintiff's respondents to show that Swarup Bikash has also paid estate duty, showing that his estate comprises also of the shares which stood originally in the name of Sushil, comma, thereby indicating that the shares have, for all practical purposes, been transferred in the name of Swarup Bikash. Full stop. Next para. It is thus submitted that the defendants appellants did not adduce any evidence and cannot now be heard on the issue that the remand order was not complied with by the learned trial judge, semicolon, rather, comma, it is the plaintiffs, comma, who satisfied the remand order by substantive evidence on the basis of which the impugned judgment and decree were passed. Full stop. Next para. Upon hearing learned counsel, comma, we find that a glance at the salient points of remand in the judgment of remand of this court, comma, which is the crux of the consideration, comma, dated December 9, 2005, is required to be looked into. Full stop. Next para. Before going into such endeavor, comma, we are to observe that the shares of the parties in the subject matter of the dispute was clearly and finally decided by the learned appellate court in its remand order itself and cannot now be reopened. Full stop. In the said judgment of remand, comma, the division bench held that the plaintiffs are entitled to get 5/6 share of money already realized by Swarup Bikash Seth, Swarup Bikash Seth, by virtue of succession certificate granted in his favor, as nothing has been paid to them. Full stop. Next para. The division bench further found that the findings of the learned trial judge that the 5/6 share of the plaintiffs realized by Swarup was paid after granting a receipt is perverse finding of fact, and no reasonable man could come to such conclusion from the materials on record. Full stop. The division bench further held that it is now settled law that mere grant of succession certificate in favor of a co-sharer does not vest such co-sharer with the title of the property, and it is the duty of the certificate holder to distribute the assets to the heirs in accordance with their shares. Full stop. In furtherance of such ratio, comma, the division bench, comma, in the remand order, comma, also concluded that the issue as regards share of plaintiffs in Sushil's property to the extent of 5/6. Sentence ki bolam? In furtherance of
such right, the division bench in the remand order
also concluded that it had decided the issue. It had decided the issue as regards share of plaintiffs in Sushil's property to the extent of 5/6, and further held that neither Swarup Vikas Seth nor his heirs have paid anything to the plaintiffs after realization of amount, if any, on the basis of succession certificate granted in his favor, and the court will proceed on the basis of such findings. Full stop, next para. Thus, the entitlement of the plaintiffs to 5/6 share, not only in the shares which are the subject matter of the suit, but also in the amount of money already realized by Swarup Vikas, the predecessor in interest of the defendant's appellants, by virtue of succession certificate, was declared by the appellate court, and it was held that so long such amount is not paid to the plaintiffs, the said amount will remain charged over the assets of Swarup. Full stop, next para. The limited framework of remand, as reflected in the remand order itself is that whether original shares held by Sushil were really transferred in the name of Swarup Vikas Seth. Full stop. The other aspect was that the actual amount of money realized by Swarup by virtue of succession certificate is not brought to the notice of the court. Full stop. Next para. It was observed by the appellate court while remanding the matter that it found from the record that sufficient evidence had not been adduced at the time of hearing as to exact number of share and certificates held, share and securities held either in the name of Sushil or Swarup, and the learned trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Swarup Vikas or were still appearing in the name of Sushil. Full stop, next para. The other aspect of the remand order was that it observed that the parties were free to summon the concerned companies where the shares are lying for the purpose of showing the strength of the disputed shares as it stood on that date. And if it appeared to the court on the basis of such evidence that the original shares of Sushil are still continuing in his name and that those were not transferred in the name of Swarup Vikas pursuant to the succession certificate granted in his favor, the court would declare 5/6 share of the plaintiffs and 1/6 of the defendants in those shares. Full stop. The appellate court further held that if it appeared that any new share was purchased in the name of Swarup Vikas Seth and the same was not in continuation of the original one standing in the name of Sushil, nor is such share a bonus share or right issue arising out of the share standing in the name of Sushil, nor was such share even purchased at a premium on the basis of the benefit conferred on the share standing in the name of Sushil, the plaintiffs will not have right in those shares. Full stop. However, the plaintiffs should be entitled to 5/6 share of the amount of money already realized by Swarup by virtue of succession certificate. Full stop. Next para. Thus, the conspectus of the remand order was to ascertain two aspects of the matter. First, whether the original shares standing in the name of Sushil have been transferred in the name of Swarup, and if so, to what extent, semicolon. Secondly, what was the income, what was the amount of money actually realized by Swarup by virtue of the succession certificate granted in his favor. Full stop. Next para. Before the trial court, after the remand, the plaintiff's respondents laid substantive evidence to establish by bank accounts, dividend certificates and several other documents, to show that Swarup Vikas had derived substantial income from the estate of Sushil by dint of the extended succession certificate. Full stop. Next para. Although no specific transfer certificate was produced, nor were the respective companies, whose shares were the subject matter of the suit, called
for the summoned for the purpose of proving as to how much of the shares were transferred in the name of Swarup Bikash, comma, we find from the evidence adduced after the remand before the court below that Swarup Bikash has been shown to pay estate duty by reflecting the subject shares as his estate. Full stop. That substantially goes on to show that Swarup proceeded on the premise that the shares were actually transferred in his name. Full stop. Next para. We fail to understand, comma, however, comma, as to why the defendants' appellants are aggrieved by the said judgment and decree of the trial court. Full stop. We do not find that the remand order was not adhered to. Full stop. First, comma, the defendants' appellants cannot be heard to say that the trial court did not comply with the remand order. Full stop. Whereas the appellate court, while remanding the matter, clearly left it free for the parties to summon concerned companies where the shares are lying for the purpose of showing the strength of the shares and in respect of the transfer of names, comma, the defendant stroke appellants did not lift a finger in that regard by summoning any witness or adducing any evidence after remand. Full stop. It is the plaintiffs who endeavored to produce such evidence and succeeded to show that several incomes were earned by Swarup Bikash from the estate of Sushil by dint of the extended succession certificate. Full stop. Next para. However, comma, unfortunately, comma, neither did the plaintiffs amend their plaint in consonance with the spirit of the remand order to stake a claim to the money realized by Swarup Bikash set on the strength of the succession certificate, comma, nor did they make a prayer in logical continuation of the finding of the appellate court that the amount of money illegally earned by Swarup from the shares of Sushil ought to be charged by staking claim in such monies insofar as their 5/6 share is concerned. Full stop. Next para. Even today, comma, although the appeal has been preferred in the year 2008, comma, no cross appeal has been made, nor has any cross objection been filed, comma, nor has there been any substantive challenge by way of arguments to the non-grant of relief to the extent of the income earned by Swarup from the estate of Sushil. Full stop. In fact, comma, one cannot blame the plaintiff's respondents much for that, since the damage was done in the trial court by not seeking further relief for recovery of such money which was appropriated by Swarup Bikash from the estate of Sushil. Full stop. The plaint stood as it stood at the inception, even after remand. Full stop. The trial court, comma, even after coming to the finding that there has been sufficient proof to show that the original shares and securities standing in the name of Sushil have been transferred in the name of Swarup Bikash Seth, comma, apart from reiterating the declaration of 5/6 share of the plaintiffs, comma, has not been able to grant any further relief, comma, merely because those reliefs were not prayed for. Full stop. The trial court rightly found that the shares and securities were purchased by Swarup Bikash out of the income of the estate of late Sushil Kumar Seth, and as such, the plaintiffs are the heirs and legal representatives of the said Sushil Kumar Seth and are entitled to get undivided 5/6 shares of those assets left by Swarup Bikash Seth. Full stop. Next para. Thus, comma, we do not find any scope of interfering with the judgment and decree impugned in this court, since the same is in consonance with the spirit of the remand order and not contrary thereto. Full stop. In in fine, FINE, comma, a decree of declaration and permanent injunction as paid for by the defendants has been granted by the trial court after remand upon entering into an assessment of whatever evidence was produced by the plaintiffs, comma, in the absence of any evidence whatsoever being adduced by the defendants after remand. Full stop. Next para, as such, comma, there is no scope of interference with the impugned judgment and decree. Full stop. Accordingly, FMAT 742, FA 248 of 2008 is dismissed on contest without, however, any order as to cost. A degree, formal degree be drawn up according.
Lord, only one thing, my lord, it has been given in the order of remand with interest till payment. I could not be able to bring to your lordship notice.
Mr.
Page
Banerjee,
168.
no, that was granted by the trial court also.
No, appeal court, trial court did not.
So you have not challenged that.
Appeal court, Lord, that
Charge was also put to that property.
Lord, appeal court directed to grant it. Lordship, kindly look to only 3 lines. Page 168.
168,
my lord.
Yes.
The plaintiff will be entitled to get 5/6 share of amount of money already realized.
Yes, we quoted that in our order also.
Then kindly, learned trial judge will further grant interest in favor of the plaintiff over 5/6 share of Sushil that will be found to be due from the date of realization.
Where is that? Where is that?
Sarubika till date of actual
The further interest? Yes, yes.
Lord, this has been granted. Lord, but appellate court, Lord, did not follow that. Therefore, this can be modified to that extent. I need not go further, my lord.
You are arguing this for the first time
I
after.
not be able to, my lord. I am in fault. Lord, I beg to be excused for that, my lord. That is why I have gone into that aspect, my lord. Trial court was directed to grant.
Not only that, Mr. Banerjee, not only interest, you are on the interest. That entire amount was to be given to you, paid to you.
Yes.
See the previous line? The plaintiffs will be entitled to get 5/6 share of the amount of money already realized by Swarupika Seth by virtue of succession certificate. And so you are entitled to get that money.
Yes.
And so long such amount is not paid to the plaintiffs, the said amount will remain charged.
Yes.
And interest.
Now, Lord, trial court was directed to calculate interest. Now,
You should have argued it at the inception. This is the only aspect you should have
very
challenged.
inception, who could have. Lord, I beg to be excused for that.
No, question of. Yes,
Lord,
Mr.
I am at
Banerjee, he's
fault.
right.
Lord,
question
Lord,
Order for
appeal court did not
36.
make any whisper to this. Page 174 BGG. Appeal court did not make any whisper to this.
Trial court. Trial court did not.
Yes, trial court.
Let us sit at trial court whether it can be interpreted.
174 BGG. 74 A double A below to from the bottom BGG. 174 BGG. That is running, that is page 33.
Yes, why shouldn't you do that under order for 33, Mr.
The
Banerjee?
difficulty is, my lord, as such, my lord, the question of
We can do this.
quantification will come.
Question of?
Question of quantification. How much, my lord, is the amount to be realized? What is the amount to be realized?
We can direct the trial court to do that. For that purpose.
Then, my lord, the question is reopening, my lord. The question of
No,
reopening.
reopening to that extent. The rest, what has been held, has been held. We retain that.
My lord, if a cross appeal, my lord, is not preferred, my lord, against that judgment and decree, my lord. Hence, my lord, I argued on the very inception.
No,
my lord,
Mr. Banerjee.
Let us to be, my lord, considered.
Take the civil procedure code once. Have you got a copy?
Yes, yes, yes.
Just come to order for 33, please. Read with 22. Read with rule 22. The constants are enumerated in these two provisions. Order for 22 and 33.
May I, my lord, read 33 first?
First come to 22. There the limitations are there regarding cross objection. Please read that out. There are distinctions. If a decree is challenged, not challenged, let us read 22.
22.
Yes.
Order for 21. Upon hearing, respondent may object to decree as if he had preferred a separate appeal. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor, and may also take cross objection to the decree which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader a notice on the day fixed for hearing, or within such further time as the appellate court may see fit to allow. Form of objection and the provisions applicable there.
Form forget. So, in any issue ought to have been in his favor, he may take a cross objection.
The
Let us
proviso.
come to yes.
The proviso, my lord, comes.
Explanation. Explanation is there. Respondent aggrieved by a finding of the court in the judgment under the filed cross objection in respect of such a. Let us come to order 41 rule 33.
My lord, order 41 rule 22, the proviso comes. Provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for hearing of the appeal.
Proviso where?
My lord, order 41 rule 22, the provide.
There is an explanation.
My lord, the above that provided he has filed.
Order 22 rule 1.
Order 41 rule 22.
Order 41 rule 22.
Rule 22.
Sub rule 1. Order 41 rule 22 sub rule 1.
Sub rule 1.
Yes. Where do you find the proviso?
My lord, sure, my lord, may I mark it, my lord, may I, my lord, make it.
Not a proviso within that section.
Yes, provided.
Acha. Proviso means a separate clause is.
Provided.
That's not called a proviso. Yes. Anyway, provided he has filed such.
Provided he has filed such objection in the appellate.
Several judgments, Mr. Banerjee. Filing of cross objection is not necessary because we read this into order. Now come to order 33. Let us proceed on the premise. He has not even argued. 41 rule 33.
Power of court of appeal. The appellate courts shall have the power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all other respondents or parties, although such respondents or party may not have filed any appeal or objection.
This is very important. Although the respondents might not have filed an appeal or an objection, appellate court can pass any further or other decree. Now it has to be, we were proceeding on a premise that he has not prayed for a further relief. But the remand order itself says that he will get this.
He has been granted a relief.
So, borrowing your judgment, this should have been done.
That's why, my lord, my argument, my lord, at the very inception was that, my lord, quantification of the amount that is to be realized and segregation. And segregation. It has to be remanded back.
We have affirmed whatever decree has been passed by the trial court because we feel that that is in consonance with the remand. But we will add that this part of the remand order, it was pointed out after the judgment was delivered that this part of the remand order is not, has not been considered by us. So we will direct the trial court to remand the matter for the limited aspect of quantifying this amount and directing it to be paid to them as per the remand, the appeal court's order. Because our logic that this was not paid for by them, that is demolished by the demand courts itself, the observation itself, which we missed out.
Now, my lord, this argument may come, my lord, whether at all, my lord, they prayed for this.
They need not pray for further. That is the difficulty.
In the plaint, whether at all, my lord, this was prayed.
They did not, because if it's in the remand order, they need not make a further prayer. It's a consequence of
a division bench, your lordship.
We are a division bench.
Yes.
We are following it.
This order is of a division.
We are following it. It is not followed by the trial court. Trial court is not a division bench.
And my lord, whether any evidence was at all adduced to that effect, whether, my lord,
yes,
nothing in the reflection of the trial court, my lord, so far as the observation comes, my lord. Only, my lord, the exhibits have been, my lord, shown before your lordship. Nothing, my lord, so far as, my lord, both these aspects, my lord, nothing in the observation of the trial court.
যেটা লিখেছো না সেটা তুমি টাইপ করো
Lord, only one.
Unless it is quantified, the remand order said that you are entitled to the amount which they have earned, which Swarup has earned. What is that amount? No quantification in the trial court
No,
order.
that, for that part, your lordship, including interest. That part, all right.
Where does the interest come? The
But with
principal does
regard
not.
to shares, Lord, that cannot.
No, share. Why should you do?
Yes, that part, Lord, yes.
Share, he's also not asking. He's admitting that
Yes,
share has been
that
declared.
part, Lord, with regard to the quantification of amount and the interest.
So therefore, you win in his appeal because he has appealed against the remand order. He says that it should be, not a proper remand order. It should be re-adjudicated. But you get an order now. You get a judgment now, asking for quantification of that without preparing an appeal.
No, because the court is entitled to pass a proper degree in accordance with order 41 rule
ঠিক আছে
33.
হার্ড লার্নেড কাউন্সিল ফর দ্য পার্টিস জাজমেন্ট রিজার্ভ দেওয়া পাঠিয়ে দিন আর এটা যেটা দিলাম ওটা আলাদা একটা শিটে ওটা অর্ডার করে পাঠিও ওটা সই করে ফেলবো বলবো তো ওটা আলাদা করে একটা শিটে পাঠিয়ে ওটা উপর বেস
Now, Lord, only one thing, my Lord, that it is a degree. When High Court passed a degree of remand, it is a degree.
Remand is not a degree.
Yes, it is not a degree, it is an order.
It's an order.
It is an order. Undoubtedly, my Lord, it is an order. Now, Lord, this is the order that was a direction given by the High Court. Therefore, he is to follow that direction. Lord, on indulgence, I want to crave leave, otherwise, my Lord, degree will be defective. Lord, he filed an application for substitution. Hey? But substitution has been allowed, but department did not correct the memorandum of appeal as per substitution application. Because degree.
Why didn't you point out before, after arguments, all of these come to your mind, Mr. Banerjee? We have heard you at length for 3 days.
No.
These never came to your mind.
Not arguing, my Lord.
Call on the next matter, please. Yes.
My Lord, for item number 25, Mr. Parthapratim Rai is supposed to appear.
For the respondent or the appellant?
For the respondent, my Lord. For the respondent, my Lord. I'm praying for a week's accommodation. He's out of station, my Lord.
Gone to Mahakumbh.
Yes. I will not stand in.
An adjournment is sought by the respondent. Let the matter stand adjourned till February 5, 2025.
Grateful, Your Lordship.
But I beg to excuse, my Lord.
No.
I appear for the respondent.
Yes, Mr. Yes, Mr. That matter. আগেরটা দিয়ে দিন তাহলে জায়গা পাবো এটা আগেরটা এটা yes
Well, before going into the reading through the parties, just for the collection, it is a suit being delegated by the company court, and the judgment is exhibit 2 here, and in the company court, the defense was taken that accepting 2 of the bills, other bills are manufactured with the connivance with one director, Taruna Mitro.
Yes.
One can remember that. Taruna Mitro.
He left the country subsequently and could not be.
He was very much here. He was in the workshop. He was summoned by the defendant.
Oh, yes. Cross-examination in the nature of cross-examination.
So many things are there.
Yes.
Now, my lord, in view of these allegations, my lord, regarding the genuineness of the bills, etc., and also the allegation against Mr. Tarugnath Mitro, the company court was absolutely unable to proceed under the purview of the company petition, and that's why my Lord Justice Sanjeev Banerjee was pleased to hold that elaborate, my Lord, adjudications initially on this point. So, my Lord, the entire defense is that the Tarannath Mitra, along with the supplier, not only this supplier, was in the habit of making money or siphoning money by creating sham transactions with the suppliers, including myself, with other suppliers, including myself. And Lord, that is the defense. Okay. Now, my Lord, this is the background of this suit.
This was money claim for goods supplied by.
Money claim for goods sold and supplied. Price of the goods sold and supplied, usual terms to use.
Yes. Yes.
And let us look into the starting by the plaintiff. The plain starts. At page 1, we got copies are there. The page 2, concise statement. Suit for realization of money against the goods supplied by the plaintiff firm. Valued at rupees 19,75,594 with tentative interest of rupees 4,60,511, totaling rupees 24,36,105. Then it starts with paragraph 1. The plaintiffs are one of the reputed partnership firms engaged inter alia in the business of iron and merchants commission agent and general order supplier. And the original claim of the plaintiff was against a company, namely Exomate Allied Products Private Limited, hereafter called the Transfer Company, in short, a company incorporated under the provisions of the Companies Act 1956, and having its registered office at 4 Ripon Street, Kolkata 7,16, but the said company was amalgamated with dependent company as per order dated June 26, 2009, passed by Lordship the Honorable Justice Maharaj Sinha in the Honorable High Court at Calcutta. The scheme of amalgamation provides for transfer of liabilities of the transfer of companies, as also transfer and enforcement of legal proceedings. And since all the assets and the liabilities of the said transfer of company has been amalgamate and merged with the assets and liabilities of the dependent company, the dependent company is liable to clear the due in place of the transfer company, namely Exomate and Allied Products Private Limited. In course of business transactions, the transfer company has places various purchase orders on diverse dates between March 2006 to July 2007 upon the plaintiff for supply inter alia MS angles, MS channel, and MS flats, RS joints of diverse lengths and sizes and specifications as per purchase order. The plaintiff, in accordance with the said purchase orders, duly sold, supplied, and delivered the goods, and the same were received by the transfer company by signing the challenge with the transfer company seal without any objection, and the grievances as to quality and quantity at any point of time. All the supplies affected by the petitioner were received by the transfer company without raising any objection, and the transfer company consumed the same for his business purpose. The plaintiff states that pursuant to the supplies made by the plaintiff to the transfer company, various bills were raised upon company to the sum of rupees 21,02,203. And the transfer company has received the said bills without raising any objection or demand whatsoever. The plaintiff states the principal sum then due and payable being 21,02,203 as per particulars given below. Then the next page, the particulars of the bills have been given. Now, next paragraph 5. Plaintiff by the letter dated June 3, 2008, which was due received by the transfer company, demanded the transfer company to clear the aforesaid due and outstanding on account of goods sold and delivered. Upon receipt of the said letter dated June 3, 2008, the transfer company for the first time files letter dated August 1, 2008, deny and disputed the bona fide claim of the plaintiff and has sought to raise various frivolous disputes to frustrate the bona fide attempt on the part of the plaintiff to realize the judgment. Along with said letter dated August 1, 2008, the company forwarded a check of ₹1,26,609 on account of the bills raised by the plaintiff, bill number such and such. In the box, the last two bills there. According to the said company, other than the said bills, no other bills were due and payable by the transfer company to the plaintiff. Immediately after receiving the said letter dated August 1, 2008, the plaintiff's vice letter dated September 1, 2008 replied to the same and accepted the payment of ₹1,26,609 made by the transfer companies without prejudice to the rights and contentions and as by way of part payment of the total dues which was outstanding towards the plaintiff. The transfer company made payments against the opposite transaction on the following manner. Payment by one check, that is 1,20,000. In the aforesaid total transaction, the aforesaid payment was adjusted against the total dues, leaving a sum of ₹19,75,594. As balance due, payment by the said company was all along current and continuous since except in the last payment along with the reply to the demand notice, all other payments are made on account without indicating payment against any that should be any particular bill or bills. As such, no part of the plaintiff's claim is barred by limitation. Your plaintiff states that by the letter dated August 1, 2008, the transfer company has forwarded a check of ₹1,26,609 dated September 2, 2008 drawn on HDFC Bank Limited. After giving adjustment for this for such part payment, the total principal amount which is now due and outstanding by the transfer company to the plaintiff is ₹19,75,594. The plaintiff from time to time had demanded payment of the aforesaid sum, but the transfer company had failed and neglected to liquidate the entire due to the plaintiff. The plaintiff, finding no other options, filed a petition in company petition number 57 of 2009, praying inter alia winding up of the transfer of company. The said winding up petition of the transfer company filed in its affidavit in opposition, and the plaintiff also filed affidavit in reply and supplementary affidavit. Copies whereof the plaintiff gave due to refer to and rely upon at the time of hearing of the suit, if necessary. The allegations contained in the said affidavit in opposition filed by the transfer company in the said company petition number 57 of 2009, refusing to pay the dues of the plaintiff are all frivolous, vexatious, misconceived, and untrue. The said company petition number 57 of 2009 by order dated April 13, 2010, His Lordship the Honorable Justice Sanjeev Banerjee was pleased to direct the transfer company to secure the claim of the plaintiff to the tune of ₹12,28,000 by depositing the same with the Registrar Riverside High Court, Calcutta, within the period of 5 weeks from the date of order. The registrar will invest the amount by way of fixed deposit in a nationalized bank having its office in the vicinity of the court. It was further directed that the entire claim of the plaintiff is delegated to a suit and the said amount secured will stand to the credit of the suit. The plaintiff will remain restrained from a period of 6 weeks from the date of the order from instituting any suit in respect of subject matter of the claim made by the company petition being number 56 of 2009. A copy of the sale order dated April 30, 2010 is filed here as a part of the claim. Since the plaintiff duly sold, supplied, and delivered the goods and same were received by the transfer company without any objection and or grievances as to quality and or quantity at any point of time, all the supplies affected by the petitioner are received by the transfer company without raising any objection, consume the same for the business purpose. It will be evident from the purchase statement of the transfer company and the record submitted before the commercial tax department by the transfer company that are actually received by the transfer company, and the said company has taken the tax benefit thereof. Thus, the conduct of the transfer company shows that it is interested in delaying the payment of the admitted dues of the plaintiff, and there is no defense on the part of the transfer company, and thus the said company is liable to pay the said bona fide dues with interest to the plaintiff. The plaintiff is entitled to and claim interest on the said sum of rupees 90,75,594 at the rate of 18% per annum from February 8, 2009 till date of filing of the institute. By reason of the premises aforesaid, on May 18, 2010, a sum of rupees 23,41,693 only has become due and payable owing to the transfer company to the plaintiff as per the particular herein below shown in the schedule annex here. Then below particular given total sum due on account of the price of the food sold 21,03,203 less part payment 1,26,609, balance is 19,75,594. Then one interest added, the total is 24,3600 105. In spite of repeated page 11, in spite of repeated requests demands being made by the transfer of company, has wrongfully and illegally failed, neglected, and refused to pay the aforesaid sum of 24,36,105 only, or any portion there. In the premises, the plaintiff is entitled to claim a degree against the transfer company for a sum of rupees 24,36,105. The plaintiffs are also entitled to a claim interest and interest upon judgment at the rate of rupees 80% per annum. No part of the claim of the plaintiff in instant suit is barred by law or limitations. Further, the transfer company has maintained continuous current and running account with the plaintiffs. The transfer company was amalgamated with the dependent company herein as per order dated June 26, 2009, passed by Lordship, the Honorable Justice Maharaj Sinha in the Honorable High Court at Calcutta. The scheme of amalgamation provides for transfer of the debts, liabilities, and obligations of the transfer company, as also transfer and enforcement of legal proceedings, and treats all the assets, debts, obligations, and the liabilities of the said transfer company has been amalgamated and merged with the assets and liabilities of the dependent company. The dependent company is liable to clear the dues in place of the said transfer company, namely Exomate and Allied Products Private Limited. That the cause of action of the suit arose also on September 2, 2008 after demand notice when part payment was made at 45 Jautala Road, 3rd Floor, Police Station, Karaya, Calcutta, 7,19,000, while the dependent company has its registered office within the jurisdiction of the London Court on February 2, 2009 after expiry of the time stipulated in the notice dated January 16, 2009 of the London Advocate of the plaintiff for return of the said monies for the purpose of court fees and jurisdiction, etc. But that is not required. And then when players are there, degree for rupees A, degree for rupees 4 lakh odd, the degree for further interest. Then minor schedule has been given regarding the entire dues and the payment received. Then minor duty statement. With regard to the duty statement, I will make submission on two counts. Number one, I will submit that there is no duty statement in the IO. And second one will be, if there will be duty statement, then what will happen? These are the two things I want to argue below. Well, before going into the details of the duty statement, I'll just point out, you also can remember I was pointing out on this last that the duty statement, you will also have seen the original duty statement from the lower court record.
Yes.
You also can remember only signature of Subroto Datta has been made in the right hand top on all the pages. And my lord, there is nothing indicated that what is his position in the company, in what capacity, what kind of officer he is, or whether he is a director or anything like that. Nothing was given. Then, my lord, for signing this written statement, I was drawing your lordship kind attention to Order 6, Rule 14. Order 6, Rule 14. And my lord, I will also draw your lordship kind attention to Section 34 of the Companies Act 1956. Section 34 of the Companies Act 1956. Or it is well known to us that what will be the status of a registered company
56
in the eye of law.
ঠিক আছে আমি এখানে রেখেছি ও আচ্ছা ওনাকে একটা কপি দিন 56 অ্যাক্ট এটা 56 হ্যাঁ লাগিয়ে দিন
ফটো আছে সবুজ কালার আছে
এটা please place it
My lord, we'll have to consider, my lord, you also can consider, my lord, Order 6, Rule 14.
no first place section 34
Well, Section 30.
registration
Effect of registration.
yes
Effect of registration. 1. On the registration of the memorandum of a company, the registrars have certified under his hand that the company is incorporated, and in case of a limited company, that the company is limited. Then, my lord, 2. From the date of incorporation mentioned in the certificate of incorporation, such of the subscribers of the memorandum or other persons as from time to time be members of the company shall be a body corporate. My lord, this is very important. Shall be a body corporate by the name contained in the memorandum, capable of forthwith of exercising all the functions of an incorporated company and having perpetual succession and a common seat.
yes
But with such liability on the part of the members of the to contribute to the assets of the company in the event of being wound up as is mentioned in this act. So we are getting from this section after the registration of a company, the status of the company will be a body corporate with perpetual succession with a common seal.
yes
My lord, this common seal is very much important. For representing the company, my lord, this common seal must be there. Number 1. In this context, my lord, I was referring to Order 6, Rule 14 of the CPC. My lord, I will be praying, my lord, that your lordship will consider, along with Order 6, Rule 14, the Order 29. Order 29.
all right
Order 29 is the chapter, my lord, which has been given, which has been in the ordinary portion of the Code of Civil Procedure, dealing with suits by or against corporations.
yes yes
Just a minute. My lord,
secretary director or principal officer does not disclose his capacity also
and my lord, and there is no indication, my lord, can you see at page as it is the requirement of the present civil procedure code with regard to the can you come to page 41? It has not been stated. I will be pressing the reinstatement. And had there been any document created by the company itself by a resolution of the board of directors authorizing him to sign the reinstatement, that paper should have been given along with the reinstatement.
But did you take these points in the court below?
Yes. Yes, I have cross-examined the person on this point very vividly because I was, my lord, your lordship, I don't know whether you know it or not. In the lower courts, my lord, we should be very much cautious.
Absolutely. The case is made in the trial court. Up to the Supreme Court, you cannot improve the case after you do something wrong in the trial court.
Yes. Not,
And the other way around also.
not only doing wrong, my lord.
The other way also. If
Yes,
you,
yes.
you make or break a case in the
Yes, yes.
trial court.
That's why I.
Everything else is only a tapering off cylinder.
Yes. That is why, my lord, I put specific questions to the defendant, whether any signature is there,
Trial court is the
whether
most
signature
important.
is there, whether
Doubt.
seal is there, authority is there. I put several questions so that nothing can be done in between. Now, my lord, at page 41, you will so kindly see. At page 41, well, several documents, 11 documents have been, list is given. I think, my lord, subject to correction, I don't find anything with regard to the certificate or any resolution by the board of directors.
All right.
Even next page, my lord, list of documents annexed to the plan, there is no such document annexed to the plan. So, my lord, first one is relied upon by the, it has been written by the plaintiff, that should be defended. Anyway, my lord, that is a mistake. And also in the next page. Now, my lord, there is one thing.
We will continue tomorrow. Hardened part for further hearing tomorrow.
Lordship, just
Yes.
before your Lordship rises,
Yes.
next item, your Lordship, item number 27.
Right.
Mr. Kormokar is appearing for the respondent, your Lordship, and he is not present, and he went for Kumbh Mela. And
Will not be there for this week.
yes, your Lordship. The appellant is also present, your Lordship.
So we'll adjourn it for the week. Call on the next matter.
Item number 27.
Yes, you have any objection? You are for the appellant.
No, I'm for the respondent, he's for that.
A prayer, an adjournment is sought by the respondent for the week on the ground of personal difficulty of learned counsel for the respondent. Full stop. Accordingly, let the matter stand adjourned till February 5, 2025. Usually, give your names, both of you.
Can it be on fixed on 7th?
No, let it be on 6. No fixation.